All right, good morning, everyone. It is 9 a.m., and pursuant to my scheduling order, in this case, we are going to take some time outside of the presence of the board for argument on pre-hearing motions. At this time, I will note for the record, we are here on case number 12.18-2522230A. That is the Tennessee Department of Commerce and Insurance versus Vincent Nutt. These motion arguments and motion rulings are going to be on the record and transcribed by our court reporter. And for the record, today's date is June 12th, 2025, and it is 9:01 a.m. We are in person in Nashville in the Davy Crockett Tower. At this time, if I could have appearances, starting with the petitioner.
Kimberly Cooper, Associate General Counsel for the Department of Commerce and Insurance on behalf of the petitioner, the Tennessee Real Estate Commission.
All right, may I ask you have with you?
To my left is Ariel Carter. She's also Associate General Counsel for the department and with the Tennessee Real Estate Commission. To her left is Executive Director of the Tennessee Real Estate Commission, Denise Baker.
All right, thank you, Ms. Cooper. Is there anyone here for the respondent, Mr. Nutt?
That would be me, sir.
Excellent. If you wouldn't mind coming up here and taking a seat.
Yes, sir.
Excellent.
Okay. To talk and then turn that one off.
All right, excellent. If we could practice good microphone discipline and make sure those are turned on when we speak for everyone in the room, and I'll repeat that instruction, I'm sure, several times for both my own benefit as well as our witnesses today, just to make our court reporter's job a little bit easier. That being said, we are here for pre-hearing motion arguments and rulings outside of the presence of the board. I am showing six different motions that were filed by Mr. Nutt dealing with discovery issues in this matter. And I note that a response has been filed by the petitioner in this case and that the relevant discovery documents have been filed as well. At this time, Mr. Nutt, those are your motions. So if you would, please, I'd like to hear argument on those. And I may have some questions for you.
Sure. Did you receive my response to state's response?
I did.
Filing?
I did.
Okay, so that's my primary argument there with regard to these motions. I've boiled it down to two items that I need, and then I'll just waive everything else that I've asked for. And that is simply this, is the in-camera review of the legal report that was presented to the commission, because the deliberation was founded upon that report and that report only. There was no additional information received by the commission or sought by the commission between the June hearing, when a fact-finding mission was ordered, and the August hearing. There was no additional data collection that took place between those two. That meeting was just to discuss her legal report and narrative, which she quoted in the transcript. And I think you've seen all of that documentation in my motions. All of those arguments are there in writing and on the record. And so as for that, and the other one is that just that stipulation about whether or not a request of stipulation from the petitioner, whether or not they were able to access the respondent's response from the AG's office prior to the expiration date on the notice mailed to the respondent. And just either a stipulation or explicit denial of that fact. As you can see there, my state's response, or my response to state's response.
So let me ask regarding the portion of the relief that you seek regarding the in-camera review of the legal memorandum. What purpose do you intend to use that for in today's hearing? What do you think is in there? How would you?
I don't know what's in there.
Okay.
I mean, that's the whole thing. I don't know what's in there, and it's hard for me to build a defense against something that I don't know is there. And that was the only thing, that was the foundation and really the only thing discussed during that meeting about my case, was her legal report. And that led to a motion and vote on a civil penalty and I was not invited to the party.
All right, thank you, Mr. Nutt. I may have a few more questions for you, and I will note for the parties that I'm a creature of the modern era and prefer to take notes electronically. If I'm looking down and typing frantically, please, everyone in the for the parties and in the gallery today, understand that I'm not making eye contact with you because I'm not listening. It's because I'm writing down something that I think is important, and I don't want to forget. In this case, Ms. Cooper, I'll hear your response to the motion.
Quite frankly, the legal report that Mr. Nutt is referring to has been publicly available on our website for several months. There is no, he seems to believe that there's some internal or hidden report that was given separately to the commission. That is simply not true. As explained in the complaint standard operating procedure that he's also been provided, that is not how these meetings work, quite frankly. The legal report is presented by the attorney to the commission. They are given that report a couple of days before the meeting to review. They then, if they have additional questions for individual cases, they do what's called is pull those cases. One of those cases happened to be in June 2024. I asked them actually to discuss Mr. Nutt's case at his request. It was a represent. But again, all of those legal, and I would ask the court to admonish Mr. Nutt not to respond with shaking of head, and I know he's frustrated, but I don't think that's appropriate here. Everything that he's asked for regarding any reports provided to the commission is publicly available on our website. Not only that, I have emailed them to him, so there's no confusion about which report we're talking about. It's there. He stated that the June and August 2024 meetings that they were a party he was not invited to. Those meetings are also publicly noticed, and he can attend any meeting he likes, just like any other member of the public of the state of Tennessee. The party, quite frankly, regarding his particular complaint is today. As you're well aware, Your Honor, if they don't want to settle at the with a consent order, then we move on to a hearing. That's their due process right, and we're happy to provide that to him, and that's what we're going to do here today.
All right, talk to me in a little bit more detail about what this legal report is.
So as part of the process for complaints, the complaints are opened by the program, so the Tennessee Real Estate Commission staff, which is headed by Executive Director Baker, and she'll get into that more during her testimony. But it is an administrative opening of a complaint. The complaint, once it's opened, copy of the complaint is sent to the respondent, and the respondent is asked to provide a response. They are told to provide a detailed response up to and including the transaction folder for any transactions that are at the heart of this matter. That was sent to the respondent in this case. The allegation is that he did not respond as he was required to do, but all respondents are given that opportunity to respond, and indeed under statutory law for the commission, this commission at least, they are required to respond within 10 days. If a response is not received from the respondent, then that respondent is sent another letter saying you've missed your 10-day deadline, but you can still provide a response if you'd like to do. Again, that was done here. Once all the documents have been, that we can get from either the complainant or the respondent are provided by those parties, they are then entered into what's called our core system, which is our administrative software management system. And then a case is forwarded to legal, where we then open a legal case. The legal department, comprised of myself and Ms. Carter and Ms. Anna Matlock, then review the cases and compile an anonymous legal report. Every case is assigned a complaint number. The attorneys look over the documents that have been provided. We do an analysis based on our rules and our statutes, and then we provide a narrative, a summary narrative of the complaint and the respondent's response, again, if we have one. We then make a recommendation to the commission as to whether to dismiss the case, assess a civil penalty, suspend, revoke. If we have, if we'd like the commission's input on it, specifically regarding a complaint, then the recommendation will be discuss. That report is then compiled. All the names are stripped out of the complaint or the legal report, and it is presented to the commission, complaint numbers only, about a week before the meeting they get this legal report. The legal report is then discussed, is on the agenda, is discussed during the meeting. It's a consent agenda, so if they agree with our recommendations, they make a motion to approve council's recommendations in 1 through 30, and we want to talk about 31 through 35. And then that's what we do. They ask additional questions for, additional information. And then they may make their own recommendations regarding those cases, or they may say, oh, okay, now that I know a little bit more and my question has been answered, I'll approve your recommendation. Once the minutes are once the legal report is then approved on a motion, the next month, when the minutes are approved, those legal reports become part of the minutes that are then published to the Tennessee Real Estate Commission website in their entirety.
On the minutes of the commission, I note that there's a portion of it that is called the legal section. Is that what you're referring to here?
Yes, sir.
Okay. Is there any sort of separate document besides that legal section that would have come to the attention of the commission?
No, sir.
All right, Mr. Nutt, I'll hear your rebuttal to that response.
Yes, sir, and I've already given that to you also in writing on the record, but the minutes or published legal report that she's referring to online, I've reviewed that, and to me, it's not consistent with the conversation that took place that evening or that day, August 7th, 2024, where she mentioned in the transcript that she quoted a portion of my response in the narrative. I can't find a portion of my response in any of those legal documents that she says is located online.
All right, thank you, Mr. Nutt. Let's move on to the stipulation regarding the Attorney General's office, and I'd like to hear your argument on that portion of it.
Is the stipulation part of it?
Yes, please.
Yes. Well, in my view, the complaint originated with the AG's office. This is how the commission got a referral from the AG's office. And so, and in the transcript, Commissioner says that the AG's office had it. So, I mean, he states that in the meeting that they understood that the AG's office had it. And that's a known cooperating source. And so the question is before we assign a civil penalty to one of our licensees, should maybe we just check and make sure that he didn't file his response with the AG's office, since that's where the complaint originated? And I would just wanted to ask if they had access to that, and if they could verify that they had access to that before assigning a civil penalty to a 32-year-old professional who has an unblemished record.
All right, thank you, Mr. Nutt. Ms. Cooper, I'll hear your response.
Your Honor, I can't stipulate to that at all because that's not the timeline and that's not how it happened. So in this instance, the complainant initially filed a complaint with the Office of the Attorney General's Department of Consumer Affairs. Because that complaint more properly went under the commission's jurisdiction, the complaint was forwarded to us, and we opened our own complaint as is our responsibility as the regulatory agency for the respondent's license. We received the complaint. We forwarded that to Mr. Nutt, as we are required to do. We asked for his response. He declined to respond to it. He seems to think that it's our responsibility to go and search down additional documents, and that is not the responsibility of the commission. By statute, Mr. Nutt was required to submit a response to the commission, the Tennessee Real Estate Commission, within 10 days. He seems to think that comments made off the cuff during a meeting are evidence that we, the commission, had access to documents the minute that they were filed with the AG's office. As I explained to him in an email back in November of 2023, the Office of the Attorney General is a separate agency. I don't have access to their files, and they don't have access to mine. And to be quite frank, It wasn't until Mr. Nutt received the consent order, the proposed consent order of settlement in November of 2023, that he mentioned for the first time that he had responded to the Office of the Attorney General. So for me to stipulate to something that is not accurate, that is not factual, I can't do that.
All right, Mr. Nutt, I'll hear your rebuttal, please.
With respect, I didn't ask if she had gotten it. I asked if she had the ability to retrieve it. Did she have access to it? Would outreach to the AG's office had produced that result? I've been to the AG's website, and the AG's website has a FAQ page. And on that FAQ page, there's a question that says, should I be submitting this complaint to another agency? And they say, no, because we cooperate with all other agencies and we preserve a record.
And Your
And
Honor,
we all know that the AG preserves records.
I would object to the characterization or the statement that he just said it exists on the AG's website. I don't believe that's actually what it says, but it's not relevant. The AG's office is not a party here. The Tennessee Real Estate Commission and Mr. Nutt are the parties here. And that's the brass tacks of it. The commission is the one that regulates his license. The commission is the one he owed a responsibility to. The commission is the one that he did not respond to. And based on the standard operating procedure of our complaint process that I briefly described a few moments ago, a complaint in legal is not opened until over sometimes a month after a complaint is opened in the program. So no, sir, I would not have had the ability to get to a response that he filed with a completely different state agency the day that he filed it.
Rebuttal, Mr. Nutt.
With respect also, she said that the statute says that I should send the response to the Real Estate Commission. I think what she's referring to is the rules of the Real Estate Commission, which, are enforceable by law, but don't carry the force of law. I respect those rules, and those rules are set up in order to help licensees keep the law. But the universal law is when you get a complaint, the respondent must respond within 10 days. That's like from the top of the building down, every regulatory agency in here, and of course, that's what the AG's office said to me as well. Just to clear the record for my confusion, okay? I didn't know that he sent the complaint to the AG's office. I thought complaints go to TREC. I'm a realtor. So when I got approached by the AG's office, my first assumption was TREC already has the complaint. They forwarded it to the AG's office. Now the AG's office is contacting me. And so, yes, I'm getting right on that, but my thinking is that my responses going to the AG's office are going to track right back to them. And by the time I got her first letter, I had already sent the response to the AG's office. So when I opened it, I said, oh, well, they're just letting me know that I've got a complaint, but I've already responded to it, so everything's okay. Then when I got the second letter, I actually emailed the AG's office and asked them, and I have the records in my box, and asked them, I said, listen, I got this letter. And she said, listen, the issue is closed with our office. That's from the Department of Commerce and Insurance. So some confusion on my part, lots of stuff coming at the same time, but it's all about the same thing. It's all about the same complaint. And in my view, I just thought the Real Estate Commission was a little bit behind the curve, and that response was going to catch up to them because I was actually reporting everything to the AG and under the assumption that my complaint had already been through TREC and they had sent it over to the AG for a more serious legal review. So that's kind of what was my thinking at that early on state. It wasn't until later on that I found out that the complainant actually went to the AG's website first. That's something I found out more recently. So that's what my confusion was in the past. And in my view, at worst, this is excusable neglect.
All right, thank you both for your arguments on the motion. We are going to take a 5 to 10 minute recess, and we will come back on the record. All right, thank you. All right, let's all get back on the record, please. It is 9:29 a.m. And Mr. Nutt, for the record, you're welcome to sit at that spot whenever you'd like. You don't have to wait on me calling you up.
Okay.
Yeah, that's fine. I don't want you to have to play musical chairs today. So let me. I do have one additional question that I fear may splinter into multiple, but it is for Ms. Cooper. Ms. Cooper, do you have any documents in your possession from the Attorney General's office?
I do.
You do?
Yes, sir.
Okay. Have those been provided for Mr. Nutt?
Yes, sir.
Okay. And the only discovery document that I have in my possession as part of these motions are the interrogatories. Were there any other supplementary discovery documents propounded on the department, such as RFPs or admissions?
No, sir.
Okay. All right, then I'll announce my ruling on the motions. All right, in front of me, we have 6 motions, a response, and then a response to a response. The gravamen of these motions are twofold. The first is based upon Mr. Nutt's presentation today, which I found fairly clear and understandable, that he wants to ensure that if there is a legal report that was presented to the commission upon which the commission based its initial decision, he wants that document. And then number 2, based upon the charge of failing to file with the commission an answer within 10 days, he'd like a stipulation in this matter that the original response submitted by Mr. Nutt to the AG's office could have been obtained or retrieved by counsel for the Real Estate Commission before the deadline stated in the notice of complaint mailed to respondent. I'll start with the legal report and the motions to compel dealing with that legal report, as well as the motion for in-camera review of the legal memorandum. 2 things are very significant to me in this. The first is that Ms. Cooper states that the only legal report is the one that is found starting on page 4 of the minutes in this matter. I have not seen anything that convinces me that anything else exists that would be some sort of separate or secret legal report in this matter. That's the first thing on that. The second is that looking at the 2 charges in this case, the failure to provide services to all parties with honesty and good faith, and the failing to file with the commission an answer within 10 days. This hearing is being held de novo. That means we are starting from scratch, and that the department is going to have to prove its allegations from scratch, and that the prior actions by the commission, quite frankly, aren't going to carry any sort of weight in a de novo hearing. Whether or not they initiated an action that to which there should have been an answer filed, that's one thing. But in terms of the items that would be discussed in that legal report, each of them is going to have to be reproved from scratch. And I do not see how, given that my jurisdiction and the board's jurisdiction in this case is limited to those two specific charges, I do not see how a legal report that was done by counsel is going to be admissible or relevant in any way in this proceeding, mainly because it's not direct best evidence proof firsthand. I don't think it's going to have, even if it did exist, which again, nothing has convinced me that there is a separate legal report other than that found on page 4 of the minutes. I don't find that it would be, that it would lead to the discovery of admissible or relevant evidence in this case. So insofar as the motions to compel dealing with the legal report and the motion for in-camera review of a legal memorandum, those motions are respectfully denied in this matter. The next question is the conditional request for stipulation regarding access to response. That is a little bit trickier of a situation because I cannot make a party stipulate to anything that they do not want to. That's not within my purview of the discovery process. That being said, the earlier motions to compel sought a little bit more clarity regarding the process regarding the Attorney General's Division of Consumer Affairs and how that worked, and the acknowledgement that that proceeding was answered. And I look at that as primarily going to the charge of failing to file with the commission and answer within 10 days. I have the same basic issue there, which is that Ms. Cooper has stated that everything that the department has received from the Attorney General's office has been provided. The requirements for discovery don't make as part of the discovery process, don't make the department go out and find documents, or don't make any party rather find documents that are not within their possession. That being said, outside of the presence of the board will ultimately make this decision, and I will not give my input one way or another. In terms of the merits of the case, there may very well be some, the argument may very well be compelling that an answer was filed with the Attorney General's office in that process, and not with the Real Estate Commission as part of this process because of some confusion. I think that is certainly something that Mr. Nutt is capable of bringing up. I don't think that he is going to be prejudiced in any way, because I think he can make that. I think he can make that without the documents that are in the possession of the Attorney General's office that are not in the possession of the department. So with that, with regard to the conditional request for stipulation regarding access to response, as well as the discovery requests concerning the documents in the possession of the Attorney General's office, I will respectfully deny those motions as well. It is a closer question on those as to whether or not an opportunity should be afforded to allow seeking of those documents from the Attorney General's office. But since the gravamen is Mr. Nutt's desire to offer the argument that he did in fact respond to these claims in the Attorney General's office proceeding, and that should bear upon the charge here of failing to file with the commission and answer within 10 days. I think that he is perfectly capable, as he's shown so far, of being able to raise that argument. I don't think that the items in the possession of, if the AG's office even has them, are going to necessitate a continuance to allow discovery to continue in this matter. So with that, the discovery motions in this matter, all 6 are respectfully denied. And I am ready, unless there are any further preliminary matters, to bring the board in here and begin the hearing.
Not on this part of the petition, Your Honor.
Mr. Nutt, any preliminary matters?
I have one more motion. It was just a motion to be able to use a slide presentation to present my defense.
Certainly.
Okay, I have that motion here.
I assume that we have someone, Mr. Lammers, who can assist with technology.
Okay.
No promises, Mr. Nutt, that technology will work out. Sometimes, despite our best efforts.
I brought paper.
Sometimes, despite our best efforts, it does not. But to the extent we can get it to work, certainly we'll grant your motion to use the available technology in this room.
If I could get a copy of that motion, please.
Judge, it may take me a couple minutes to get him down here. Do you want the board in now, or?
Let's go ahead and get the board in.
Yes, sir.
And my intention, off the record, my intention is that, Mr. Nutt, before we get to the use of technology, we're going to take a little bit of a recess. The department will have to present its case in chief first, then we'll take a recess. We can get it all set up and go from there. All right, let's get started. Today is June 12th, 2025. We are present in Nashville, Tennessee for a hearing before the Tennessee Real Estate Commission. The commission will consider the case of the Tennessee Department of Commerce and Insurance versus Vincent Nutt, which is docket number 12.18-252230A. First, I'll appreciate the board's patience. We had a few pre-hearing motions for which argument was necessary. We've resolved those, and we're ready to proceed on the hearing in chief. My name is Alex Rieger, and I'm the administrative judge assigned by the Secretary of State Administrative Procedures Division to preside over this hearing. I'm sitting today with you, the Tennessee Real Estate Commission. I will make all rulings regarding the order of proceedings, the admissibility of evidence, and any procedural questions of law pursuant to the authority granted to me by the Tennessee Administrative Procedures Act. I will not participate in the findings of fact, the conclusions of law, or the ultimate decision of this commission. The decisions in this case, the final decisions, will be made by the commission members. At this time, I would now ask the commission members to introduce themselves for the record, beginning with our chair.
Thank you, Judge. Jeff Diaz, Chairman.
DJ Ferris.
Joan Smith.
John Moffitt.
Steve Gwynn.
Kathy Tucker.
Joe Begley.
Stacy Torbett.
Thank you all. Mr. Chair, is a quorum of your commission present?
It is, sir.
Excellent, thank you. We'll do appearances, starting with the petitioner.
Kimberly Cooper, Associate General Counsel for the Department of Commerce and Insurance on behalf of the state of Tennessee.
Ariel Carter, Associate Counsel, Department of Tennessee State.
And Mr. Nutt.
Vincent Nutt, respondent.
All right, Mr. Nutt, I note that you are here without counsel today. You are, of course, entitled to your right to counsel, but it's not provided for you in this type of case. Do you wish to waive that right and present your own case today?
Yes, sir.
Excellent.
I guess I have a fool for a client.
Thank you, sir. All right, members of the commission, I have a few opening instructions for you. I'll charge you later on regarding the specifics in this case, but these are just generalized hearing practices that need to be followed. During the time this hearing is being conducted, no discussion concerning this case may take place between commission members and myself, witnesses, Mr. Nutt, attorneys, other commission members, commission staff, or any other persons outside of this hearing. Everything has to be done within this hearing. During this hearing, the commission will sit like a jury and must only consider the evidence admitted during the hearing in reaching your ultimate decision in this case. The Tennessee Open Meetings Act requires that all commission discussions and deliberations be in public before all parties that are present for this hearing. Failure to comply with these laws, also known as Tennessee Sunshine Laws, could result in the Commission's action being reversed or remanded if this case were to be appealed. Commission members, during this hearing or during any breaks that we should take, you may not use any device to conduct any sort of research about this case or anything related to it, or to communicate with anyone about this case, or to receive any information from anyone about this case. So using smartphones, tablets, iPads, computers, internet service, text messaging, websites, you cannot use those to acquire information about this case. You cannot use that to communicate information about this case or receive information about this case or research this case. Everything has to take place in this hearing on the record, or else we could have an Open Meetings Act problem. I will also note, Commission members, that you should not draw any conclusions until all of the proof has been submitted. You should listen openly to all proof regardless of which side submits it. At this time, Ms. Cooper, I will ask, as petitioner, do you have copies of the notice of charges and in this case?
I do, Your Honor.
Excellent. Have those been provided to the commission in this case?
They have not. I'll be happy to distribute them now.
Please publish them to the commission. Commission members, I am handing out this document early for the purposes of determining whether or not there are conflicts or any disclosures that need to be made. That document, the notice of charges, is not evidence. You are not to rely upon it for any other purpose at this time other than to determine whether or not there's a conflict or there's anything that you need to disclose. I'll ask that you skim it, and then I'll ask each of y'all some questions, and then we'll go from there. But that is not evidence. You cannot rely on it when you make your determination in this case until or unless it is admitted as evidence in this case, and then I'll let you know. So please take a moment to skim that. All right, members of the commission, the law requires you to disclose on the record any outside knowledge of this case or any communications, whether written, verbal, or otherwise, from any of the parties concerning this case. Do any of you believe, by raising hands, that you have any sort of conflict in this matter? Seeing none, does anyone have any, again, by show of hands, does anyone have anything that they feel they need to disclose regarding this case before we begin? Seeing nothing, I will note that both of those questions, if at any point you think of something, any of you that you feel might raise a conflict or that you feel like you need to disclose, it is never too late. Please bring that to my attention as soon as you can. With that, let me talk a little bit about the procedure that we are going to use today. First, we're going to begin with opening statements. As the petitioner, Ms. Cooper will go first for the department, and then Mr. Nutt will have the opportunity to make an opening statement as well. Those will be just very brief outlines of what the parties expect the evidence to be, but opening statements are not evidence. They're helpful for organizational purposes, but they are not evidence. Afterwards, we'll hear evidence, and the evidence usually consists of numbered exhibits and testimony of witnesses that may or may not include affidavits. The proof will begin with the petitioner, the department, because the department will have the burden of proof in this matter. Afterwards, the respondent, Mr. Nutt, will have the opportunity to present his case. I'll note that although evidence is presented by asking witnesses questions, the questions themselves are not evidence, only the answers are. During the course of this hearing, there will be an opportunity for each of you to question each witness who testifies under oath. Please use your questions as opportunities to gain any information or clarification of the facts that you think would assist you in reaching a decision in this case. However, when you ask questions, you should reserve any expression of opinion that you may have until your deliberations in this case. So when you ask questions of witnesses, please don't do anything that would indicate how you feel about this case or any opinion that you might have about it. That is for deliberations. We wouldn't want to have an expression of opinion perhaps affect another commission member prior to deliberations. During the hearing, objections may be made to evidence or trial procedures. I may sustain objections to questions asked without permitting a witness to answer, or I may instruct you to disregard an answer that has been given. In deciding this case, you can't draw any inference from an unanswered question, and if I instruct you to disregard testimony, you may not consider it in this case during your deliberations. Likewise, arguments may result in me excluding information, and that works the same way. If I exclude information in this matter, then you may not consider it or use it during your deliberation. I will note that any decision on an objection or admissibility of evidence or evidentiary exclusion, the like that I make, will be based solely on the law and nothing else, and you cannot infer from any of my rulings that I hold any view or opinion for or against any party or their case in this matter. If I rule on an objection, it is not intended to show my thoughts on the merits of this case, because that is a question that is solely for you and not for me. After all the evidence has been presented, we will have closing arguments. Closing arguments are, again, not proof in this case. They're an opportunity for advocacy and a summation of how the parties think that you should decide this case based upon everything that has transpired at this hearing. In this case, as the party with the burden of proof, Mr. Nutt will make the first closing argument, and Ms. Cooper will close this matter. I'll again reiterate statements and arguments that are made during objections, during opening statements, and during closing arguments are not evidence. They're statements by the parties as opening statements or objections are only intended to help the parties understand the evidence and to apply the law to the evidence. You should ignore any statement made in this hearing by the parties on an opening statement, closing argument, or objection that is not supported by the evidence. Pursuant to the uniform rules for hearing contested cases, the department has the burden of proof in this matter. The burden of proof in this case that the state must meet is by a preponderance of the evidence, which means the amount of evidence that causes you to conclude that an allegation is probably true. We call that the 50% plus standard. So in order to meet preponderance of the evidence, the state has to prove its case basically 50.0000001%. If it's 50-50, then the case is in what we call equipoise, and the party with the burden loses. So if it's 50-50 and you're not sure, then the department will lose in this matter. The state must prove that it is more likely by not, but there's no threshold once it proves there's more likely or not. It's just if they hit any part above 50% that you think their case is more true than not, and that the allegations and the evidence show that their case is probably true, they will meet that burden of proof. But again, if you find that the proof is equally balanced, the department will lose because the case will be in equipoise and the party with the burden will lose. You must limit your inquiry and deliberations regarding violations of statutes and rules to those violations that are alleged in the state's notice of charges in this case. If you believe that there's been a violation of a statute or rule that has not been alleged in the notice of charges, you may not inquire into or address those alleged violations. The state is the party with the burden of proof in this matter. It is the department's sole burden to establish all of the facts necessary to prove every violation alleged in the notice of charges. Mr. Nutt does not have to prove that he is innocent of the charges in this case. As sole judges of the facts, you commission members must determine which of the witnesses' testimony you accept, what weight you'll attach to it, and what inferences you will draw from it. The law does not require you to accept all of the evidence, nor to give every piece of the evidence equal weight. That is within your purview to decide. In deciding that what testimony you will believe and what weight to give to testimony in this matter, you may rely on your own common sense and experience. There's a reason why these cases go in front of commissions for determining findings of fact and conclusions of law rather than an administrative judge sitting alone. It is because you have professional expertise in this area that I and my colleagues do not have. And that professional expertise and experience is something that can be relied upon to determine how you will accredit testimony and evidence in this case. After closing arguments are made, I will further instruct you on the rules of law that will apply to this case, and I'll give you some guidance as to the structure of your order. At this time, I will ask, does either party request the rule of sequestration?
I do not.
I do not.
Okay. Then all of the witnesses in this case will be permitted to remain in the room and will be able to listen to the testimony in this matter as it is given. I will ask, we do have a fairly large gallery in here today and welcome all, but if I could please have you check your cell phones and make sure they are on silent. And if it does ring, it will not be a big deal. Just try to silence it as quickly as possible. Believe it or not, there have been times when I have had my phone go off and forgot to silence it. So it won't be a big deal. Just let's try to do our best on that. And then as well, we'll ask everyone in the gallery as well as the parties and witnesses as well as the members of the board. Please refrain as best you can from having any sort of reaction to testimony, whether or not it's a facial expression or whether or not it's a comment or laughter or anything like that. Let's just try to keep this as straightforward as possible, mainly because it will make our court reporter's life a little easier if we cut down on extraneous noise. We have these devices in front of us for a reason, and they're to make our court reporter's life a little easier. Are there any stipulations or preliminary motions in this case before we go to opening statements, starting with the petitioner?
No, sir.
And Mr. Nutt?
No, sir.
All right, excellent. Then
Your Honor. Judge?
Yes.
Sorry, I just wanted to note for the record that there are 8 commissioners present. So if there's a motion and the vote is tied, the motion will fail.
Certainly.
And then I also wanted to ask commissioners to, for the benefit of the court reporter and the record, to seek recognition and to hold your comments until you are recognized, please.
Certainly. Thank you, Mr. Chair. And at this time, Ms. Cooper, I'll hear petitioner's opening statement, please.
Good morning, Commissioners. Remind you all to use your mics when you talk, since that's a problem for all of us sometimes. I'm here today regarding the actions of Mr. Nutt here to my right, but I'm also here today, as you all are, because of the purpose and the mission of the Tennessee Real Estate Commission to regulate the real estate brokers and all real estate licensees in the state. And you all have been doing that for almost 75 years, I realized this morning. Your 75th birthday is next year, so happy birthday. The commission does that through these hearings, but you also do it through enforcement of the rules and the statutes of the Real Estate Commission, or that are act pursuant to those statutes and rules, I'm sorry, to enforce those statutes and rules against these licensees. It all falls apart if the licensees don't do what they're supposed to do. The most basic rule for the commission, for the licensees, is to respond. When you, the commission, reach out to them and say, you've got a complaint, you have 10 days to do so. It is such an important responsibility that the legislature saw fit to codify it in a statute years ago. You have 10 days to respond. In this case, it's going to be pretty simple, despite allegations and arguments by the respondent to the contrary, but that did not happen here. The respondent was notified that there was a complaint against him from the commission. He was told to respond. He did not do so. You are also going to hear from Mr. Stephen Moss. He was a potential buyer of a property listed by Mr. Nutt. You're going to hear from Mr. Moss that he was not treated honestly or fairly or in good faith by this respondent. I believe that at the end of the day, or at the end of the morning, hopefully, that you will have that 51% proof that you need to find that not only did Mr. Nutt not respond, as is his duty and his requirement to the commission, but he also did not treat these respondents fairly. And I will ask at that point for you all to impose civil penalties and/or more than that, but we'll get to that in a little bit. For that, I thank you for your attention, and I would turn it over to Mr. Nutt.
Thank you, Ms. Cooper. Mr. Nutt?
Judge and members of the commission, good morning. My name is Vincent Nutt, and I appear before you today as a licensee of this state for 32 years with a spotless record. My father, Virgil E. Nutt, just died on April 1st of this year, and it's still very fresh to me. He was an agent and broker for over 55 years with no complaints, and he brought me up in the business since I was a little boy. I want to begin by addressing the allegation that I failed to respond directly to the commission. That is correct. I submitted my full response to the Tennessee Attorney General's office and the Division of Consumer Affairs, who originally contacted me regarding this complaint. I believed at the time that this satisfied my obligation, and I had made the assumption that TREC had received the complaint first and that they had sent it to the AG's office, and that's why I was hearing from the AG's office. As a realtor, I expect all complaints to go to TREC. And so when I'm hearing from the AG's office, it makes me nervous that you guys have already looked at it and you've sent it over there. And so that's why I took it so urgently. And then I realized, of course, that this was a false assumption, and in hindsight, I should have known and do know that I should respond to the commission and should have known at the time that I sent it to the Attorney General's office whether I'd gotten a notice from you or not. I should have sent it to you. I should have found a way to send it to you. What if you didn't know about the complaint? I should have taken that responsibility. 32 years of experience, I should know better. This is my first complaint, so I don't have a lot of experience with complaints. In fact, my communication with the AG's office was exactly this. This is my first one. Please tell me what to do. And, of course, I have the email communication with the AG's office. Anyway, I do want to tell you that I watched the meeting on April 7th, and I remember a friendly motion for $500 amendment.
Your Honor, I wouldn't normally interject at this point, but it's already been discussed prior to the hearing. This is a de novo hearing, and anything that occurred at those meetings is not relevant
That's correct.
and inadmissible.
All right. I was just trying to humbly thank you for the amendment of the motion, but anyway.
All right, I see that the statement's been withdrawn, so it'll moot out your objection.
All right. So, at any rate, I agree that I should have responded to the commission, and Ms. Cooper's right. And that's why when she sent me the original consent order, I had asked you guys for grace and mercy. But what I must contest, and what brings me here today, is the charge that I acted dishonestly or in bad faith. I take that very seriously because I'm a very honest man to a fault. And if I were a dishonest man, I would sign a consent order and mail you a check. I'm here today because I'm an honest man and I want to fight for my integrity. It means something to me. The evidence will show that I treated all parties with transparency, honesty, and lawful conduct. The complainants were shown the full property at their agent's request. They were informed of other interested parties. Their offer, which asked for a $2,000 concession, was submitted in writing and was rejected in writing by the sellers. There were no misstatements, no misdirection, and no unfair treatment. I made a personal interest disclosure to the sellers, and I submitted an offer not to take advantage of anyone, but to help my seller achieve his goals without contingencies after another buyer had introduced a risk of an acreage discrepancy up to 25% just that day. and only with a survey to determine whether or not the buyer could pay the full price or not. And that was the other offer that had a contingency in it. My offer was clean, transparent, and loyal to the interest of the seller who hired me. Our law requires listing agents to submit any and all offers on the subject property as soon as practicable, no matter the content or source. The listing agent could not lawfully withhold his own interest of the subject property, and he made that interest known to his sellers immediately. The complainant did not lose the property because of dishonesty. They lost it because of how their offer was structured and because their own agent was unavailable to assist him during a critical moment. I respectfully ask that this commission dismiss the charge that I acted dishonestly. I have made my mistakes in life, but I ask you not to impose on me the label that my conduct does not deserve and that the record does not support. Thank you.
Thank you, Mr. Nutt. Please. Ms. Cooper, if you'll call your first witness, please.
I would call Ms. Baker.
Your Honor, just a moment, please. Commissioner Ferris.
Judge, pardon me. Thank you for being here. My name is DJ Ferris. I want to make you aware that I will need to leave for a child's doctor appointment at noon, and so I do not want to jeopardize the integrity of the hearing by doing so. I have no need to recuse myself by any measure, but if it will be better for the cause of the rest of the commission members for me to leave at this time before hearing or any deliberation, I would regret to do so, but again, I don't want to.
Thank you for bringing that to my attention, Mr. Ferris. Mr. Chair, will you still have a quorum?
We would be reduced to 7, but that would still be a quorum for us, yes, Your Honor.
All right. Does anyone have anything else that would preclude, that would require an early stop or the possibility of unavailability should this proceed into the afternoon a little bit? All right. That will be fine then, as long as we've got a quorum. That's my interest in this, and it is quite a bit easier if we don't have someone leaving in the middle of the presentation of proof. So certainly that would be acceptable. Yes, absolutely.
Thank you.
Thank you.
Sorry.
And please go ahead, Ms. Cooper, with Ms. Baker.
Thank you. We would call Ms. Baker.
Would you like us to reset?
That's fine. And Ms. Baker, if I could please have you raise your right hand for me. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. Please proceed, Ms. Cooper.
Would you please state your name and position for the record?
My name is Denise Beard Baker. I'm the Executive Director of the Tennessee Real Estate Commission.
And how long have you been in that position?
I have been in this position since August of 2023.
And what are the typical responsibilities of your position?
I manage the day-to-day licensure of Tennessee licensees, Tennessee real estate licensees in Tennessee.
And when you say the day-to-day, what sort of things does that entail?
Making sure we complete initial applications, renewal applications, transfer applications, hearings, complaints, making sure that the commission has meetings on a regular basis as well.
Okay. And you mentioned complaints. Can you tell the commission what the sort of process is for the processing of complaints?
Once a complaint is submitted to our complaints office, we then send out a letter to the respondent. We request the respondent reply within 10 days. Once we receive that reply, it is then sent over to our legal division for review, and then in time it is presented before the commission.
Who is considered the custodian of records for the Tennessee Real Estate Commission?
I am.
Okay. And do you know Mr. Vincent Nutt?
No,
Ever seen him before?
not before today.
Okay. As part of getting ready for the hearing today, did you look into Mr. Nutt's licensure?
Yes,
And is Mr. Nutt licensed?
yes.
Okay. And I'm going to. If I may approach the witness, Judge. Director Baker, have you seen that document before?
Yes.
And what is it?
It is a Tennessee real estate broker's license.
A Tennessee real estate broker's license for who specifically?
Vincent E. Nutt.
All right. And can you tell the commission the expiration date of that license?
This license will expire January 4th, 2027.
At this time, Your Honor, if I could have that entered as the first exhibit?
Any objection, Mr. Nutt?
No, sir.
And if I'm,
Ms. Cooper,
Yes, sir.
thank you.
Yes, sir. And if I may publish this to the jury?
Certainly, thank you. No. I'll let you keep it. Thank you.
And if I may, Your Honor, I'm going to share it to the big screen here if I can figure out the technology required to do so. There we go. Director Baker, on the screen there, is that the same document you have in front of you?
Yes, it is.
And is Mr. Nutt's current license in good standing?
Yes,
All right. As also part of your preparation for the hearing today, did you pull what's called a licensee overview?
yes,
Did you have a chance to review that?
yes.
All right. And if I may approach the witness, Your Honor?
Please go ahead.
Sorry, trying not to. Director Baker, what is the document I just placed in front of you?
It is a licensee overview from the system that TREC uses to manage licensees' data.
And whose data is that in
This
front of
is
you?
Vincent E. Nutt,
And can you tell the commission when Mr. Nutt was first licensed?
December 16th, 1993.
And what is this, is he a principal broker or an affiliate broker at this point?
He is a principal broker.
Can you tell the commission when he obtained his principal broker license?
He received a principal broker's license on October 14th, 2016.
And how many firms is Mr. Nutt currently affiliated with?
He was affiliated with 2 firms, now it's just 1 firm.
Okay. When did what firm is that he's now affiliated with?
One moment, please. He is affiliated with A Plus Enterprises Incorporated.
And what was the firm he was previously affiliated with?
He was previously affiliated with Nutt Realty Company.
Do you know when that affiliation ended, or can you tell from that document?
The firm license expired April 9th, 2025.
And at this time, Your Honor, if I could enter that as the second exhibit.
Any objection?
Mr. Nutt, is there any objection?
No, sir.
All right, thank you. That will be exhibit number 2, and you may publish it to the board.
Thank you. And Director Baker, the document that's on the screen, is that the document also that you have in your hand, exhibit number 2?
Yes,
Now, you said that he was a principal broker now.
yes.
What is the difference between an affiliate broker and a principal broker?
An affiliate broker is not able to manage other agents, and a principal broker is able to manage other agents, and
Alright.
does manage other agents.
In the licensee overview that you have there, or in your preparation for the hearing today, were you able to determine if Mr. Nutt is currently supervising any other agents?
I believe he is a solo practitioner.
Are you familiar with any complaints that have been opened against the respondent, Mr. Nutt?
Yes.
Can you tell the jury about that?
The complaint that we received was forwarded by the AG's office and presented to the commission
Okay.
for consideration.
I'm sorry, I cut you off.
Okay,
You said that it was forwarded to you from the AG's office?
correct.
Okay. Before we get into talking about that, if I may approach the witness, Your Honor.
Please go ahead.
Director Baker, do you recognize the document I just handed you?
Yes.
And what is that?
It is a complaint sent to us,
From,
the Attorney General's office, the Division of Consumer Affairs.
and is that the entirety of the documents that you received from the AG's office to the program?
Yes.
Okay. And at this time, Your Honor, if I could have that marked as the next exhibit and entered into evidence.
Any objection?
No, sir.
All right, thank you. That will be exhibit number 3. You may publish to the board.
Before we get into the nuts and bolts of referrals from the AG's office, could you explain to the commission how complaints usually, typically, come into the program?
Typically, a complaint is someone that has an issue with the Tennessee real estate licensee will complete our complaint form that is on our website. We process the complaint by sending a letter to the respondent requesting a response for the complaint that was given to our office.
So typically, it comes into the commission directly, is that correct?
Yes.
Okay. In this case, is that what happened?
No.
Okay. Can you tell the commission how that happened here?
The complaint was sent to the Attorney General's office, their Division of Consumer Affairs, and since it was outside of the AG's office jurisdiction, it was sent to our office.
And when you say it was outside of their jurisdiction, what do you mean?
They do not look at complaints as it pertains to Tennessee real estate licensees.
Okay. So is it unusual to receive a referral from the AG's office?
No,
When you receive, when the program receives a referral from the AG's office, is it handled any differently from any other complaint?
no,
Okay. So the notice goes out, the
Yeah.
respondent?
yes.
Okay. And, sorry, let's see, there we go. Oh, I didn't mean to do that. Hold on. I apologize. I'll stop sharing until I can get that straightened out. In this case, was a copy of the complaint sent to the respondent?
Yes,
And was the notice that went to the respondent any different from any notice that would have gone to any other respondent?
no,
In preparing for the hearing today, did you look or pull up the complaint for this particular case and this particular respondent?
yes,
Did you confirm that that was how it was handled?
yes.
All right. And if I may approach the witness, Your Honor.
You may.
The document I just handed you, Director Baker, do you recognize that document?
Yes.
And what is it?
It is a email sent to Mr. Nutt in reference to the complaint that was sent to us.
And the next page?
It is the letter that was sent to the address Mr. Nutt provided the commission about the complaint and requesting a response.
Okay. And can you tell me the date of the email and the date of the letter on the next page?
The date on the email is Thursday, May 18th, 2023. And it appears that we sent the letter May 18th, 2023.
So that same day.
Correct.
If a response is not provided by the respondent, does the program do anything else? Do they follow up with that respondent at all?
Yes, we follow up with the respondent.
Was that done here?
Yes.
Okay, can you tell me what the next page is of that document?
It is another letter sent to the respondent, Mr. Nutt. It was sent to the address that we had on file for him, and it was sent via certified mail.
And what is the date of that document?
June 20th, 2023.
And you said it was sent certified mail?
Yes.
All right. Tell me what's on that next page. Does that have to do with the certified mail?
Yes.
Okay. And does it show that the letter was delivered?
Yes.
And at this time, if I could have that entered as the next exhibit, please.
Any objection?
No objection.
All right, that set of documents will be admitted as collective exhibit number 4.
If I may publish it to the jury, Your Honor. All right. Director Baker, I'm going to ask you to look at the document that we just had entered as the next exhibit. Is that the document that's on the screen as well?
Yes.
And dated May 18th, 2023, correct?
Yes.
And I want to direct you to the first sentence that's in bold there, which is the third sentence of the email. What does that say?
A written response must be filed with this office within 10 days of receipt of this notice. If your response, in your response, please provide a detailed explanation of the allegations presented.
And then there's another part that's in bold there. Could you read that for the commission as well?
The next part in bold.
In bold, yes, ma'am.
Reads, this matter will be forwarded to the legal section of the Department of Commerce and Insurance for review and determination regarding further action with or without your response.
All right. I'll direct you to the next page then, the letter that was sent to Mr. Nutt. Again, May 18th, is that correct?
Yes.
All right. And please read the first part that's in bold there, or starting with the bolded.
You are hereby notified that you must send written statement responding to the allegations of this complaint to this office within 10 days from the date upon which this notice is received.
Could you read the rest of that paragraph, please?
This statement should contain, at a minimum, the following information: a point-by-point response to the allegations contained in the complaint, and all applicable documentation, including but not limited to the entire transaction file and supporting correspondence.
And please continue to read the next paragraph.
Please be advised that the commission may make a probable cause determination based solely on the information and documentation provided with your response. Therefore, it is very important that you respond fully and completely to each allegation made in the complaint, and that you provide all information that you believe to be relevant and important to any determination made regarding this complaint. If there are additional facts or additional information that you would like to be considered, please submit them with your response. Please direct your response and all supporting documentation to the email address or the address listed below.
All right. And if you could go to the bottom of the page, who is this letter from in the program?
The complaint coordinator, Gretchen Culver,
And who does it say she works for there at the bottom?
the Tennessee Real Estate Commission.
All right. And if I could have you go to the next page of that document. Could you tell me the dates, please, at the top of the letter?
6/20/2023.
And Director Baker, do you recognize this letter?
Yes.
And what is it?
It's a follow-up letter sent to Mr. Nutt in reference to the complaint.
And why would Mr. Nutt receive a follow-up letter?
He received a follow-up letter because we didn't get a response from him.
Okay. And to be clear, at this point, you said you didn't receive a response from him
Correct.
within the 10 days or at all?
At all.
Okay. If you could read the part in bold, please.
If you wish to respond to the allegations in this complaint, you should file a response with this office immediately following your receipt of this notice. In your response, please provide a detailed explanation of the allegations presented. This letter is not an extension of time to comply with the requirement in the laws or rules of any program that you respond within a certain time frame, but instead, it is an additional opportunity for you to have your response and information considered in the review of this complaint.
Director Baker, the end of that first paragraph, and I believe you had testified to this already, but just to be clear, once the respondent is given an opportunity to respond, whether they respond or not, what then happens with the complaint?
The complaint is sent to our legal division, and then it's presented for the commission's consideration.
Okay, and the lag time between when the complaint is opened and when they are, and when I say they, I mean all licensees who don't respond, and when they are sent this letter that says, we don't have a response from you, we need to have a response, is typically what?
30 to 45 days or so.
Okay. Do you know, once it's passed on to legal, when a legal complaint is opened?
Can you repeat that question?
Once it's out of the program's hands and goes to legal, when does legal open their own complaint?
Immediately,
Okay.
yeah. I really can't speak to the legal division, but the complaint is then reviewed by legal, and it's presented before the commission for review.
Okay. And again, is that what happened here, just like it does with every respondent that doesn't respond?
Yes.
Okay. As you sit here today, can you say whether or not Mr. Nutt provided a response to the program?
No, we haven't received a response from Mr. Nutt.
I believe that is all the questions that I have for you. Mr. Nutt may have some questions for you.
Mr. Nutt, please.
Thank you, Ms. Baker. How are you?
I'm good. How are you today?
I'm doing well. Ms. Baker, when someone's issued a civil penalty by the state, doesn't that mean they've been charged with a violation of law?
I'm going to object to that. I think that calls for,
Legal opinion?
excuse me,
Sorry.
thank you. I think it calls for speculation and opinion beyond what this witness can testify to.
I'm going to overrule the objection. She can answer it if she can.
Will you repeat the question, please?
When someone is issued a civil penalty by the state, doesn't that mean they've been charged with a violation of law?
I can't speak to the state in general, because I'm the executive director of the Real Estate Commission, so I can only speak
Understood.
on things that pertain to the Real Estate Commission.
Okay. Would you agree that civil penalties carry reputational harm, financial burden, and regulatory consequences that resemble misdemeanor-level findings in other legal settings?
Your Honor, and I'm going to object to that on multiple grounds. First of all, it's a compound question. Second of all, it calls for opinion and speculation by this witness.
Well, I was just trying to get some clarification. Maybe it's the wrong.
Let's break it up, and let's see if you can break up your question and ask it part by part, and we'll see where that takes us.
All right. May the commission vote to impose penalties based solely on suspicion without requiring direct evidence?
Can you repeat that question one more time?
May the commission vote to impose penalties based solely on suspicion without requiring direct evidence?
The commission reviews a summary of the complaint and makes a determination of what they will do in reference to that complaint. And what they can do several things. They can issue a civil penalty, they can issue a letter of warning.
Now, you mentioned a while ago that the complaint goes or the complaint, if you have a response, the complaint goes to legal, right? It goes over to a legal.
We have the Department of Commerce and Insurance has a legal division.
I see. And so do you have any idea what the process of screening those complaints are as far as how they determine whether or not those complaints have
If the
merit?
complaint, I'm sorry, if the complaint is in TREC's jurisdiction, it goes to our legal division.
I understand that. Can you tell me anything about the process of how they determine whether or not a complaint has merit to be presented to the commission for further discussion?
If the complaint is in reference to a licensee and it's in TREC's jurisdiction, it then moves to our legal division.
All right, I understand. Does the commission ensure that the licensee is given equal access to the full evidentiary record being considered by the commission?
Your Honor, I'm going to object to that. I believe that's beyond the purview of her personal knowledge, and I'm not sure what the question is asking, quite frankly.
I'll overrule the objection. If something is beyond someone's personal knowledge, they can certainly respond that they don't know.
Will you repeat the question, please?
Does the commission ensure that the licensee is given equal access to the full evidentiary record being considered by the commission?
They are giving a summary of the complaint.
Do they ensure that the licensee is given equal access to the full evidentiary record being considered by the commission in the case against the licensee?
The commission receives a summary of the complaint.
And what does the licensee given access to? Is he given access to the full evidentiary record?
The respondent is given everything that was sent in on a complaint.
Understood. Do you think it is consistent with the principles of fairness to issue disciplinary charges without neutral legal standards, evidence requirements, or equal access to the case record?
And I'm going to object to that, Your Honor. It calls for opinion.
I will sustain that objection and instruct the witness not to answer, because I'm afraid that that answer would ultimately step on the toes of what the commission is
Understood.
being called to determine.
I understand. All right. Is there any SOP requirement that ensures exculpatory information from the licensee is included before a report is submitted to the commission?
I'm sorry, will you repeat the question?
Is there any SOP requirement that ensures exculpatory information from the licensee is included before a report is submitted to the commission?
The Department of Commerce and Insurance does have an SOP in reference to complaints.
Thank you. Do the SOPs provide guidance for consistency across cases and how legal recommendations or lack thereof are handled?
The SOP is a procedure that we use for all complaints within the Tennessee Department of Commerce
So
and
it
Insurance.
does provide guidance for consistency across cases and how legal recommendations or lack thereof are handled?
It,
Yes or no?
Hold on. I'm going to object to that on the compound question. I think if you could break it down, it might be a little more understandable.
Okay. So there is a process whereby a report is provided to the commission and there's typically a legal recommendation.
there are legal recommendations included with the legal report, and then there are some cases within the legal report that we want the commission to discuss.
Within the SOP document that was provided to me, does it provide guidance for consistency across cases on how these legal recommendations are determined and made?
I think every case and every complaint is different.
I was just wondering if it was in the SOP document.
I would have to review the document to answer
I
that
understand.
question
I
with
understand.
100% certainty.
Okay. Who decides whether a legal report will be prepared, and what determines the scope of work included in it?
If the complaint is sent to TREC, and if it's in TREC's jurisdiction, it's sent to our legal division.
And so it's decided there, right? What
No, the
determines
commission
scope of work?
no, the commission decides what the outcome of the complaint will be.
The question was more about scope of work. And you said before that that it's not uncommon for you to receive complaints from the AG's office. Is that correct?
TREC does receive complaints from the Attorney
You said it
General's
was
office.
not uncommon.
TREC does receive complaints from the Attorney General's office.
Okay. Would you be able to ballpark an estimated percentage of how many complaints you receive actually come from the AG's office?
I cannot.
Okay. I take issue with the not uncommon part of that. All right. And then also, ma'am, you said that you never received a response from me. Is that correct? I thought I heard that a while ago. Have you ever received a response from me?
Our complaints division, or excuse me, our complaints department.
Never did? Because I want to say that I got communication, and even in the documents of record, that you did receive it by May of 2024.
Okay.
Because it was brought to a June hearing, and then in June, at the June hearing, a fact-finding mission and legal report were ordered for the August meeting.
Your Honor, I'm going to object at this point to the testifying on behalf of the respondent and ask him to ask a question.
Yes, ma'am. So my question was, you said earlier that you'd never received a response, and I have, is it possible that you received the response in May of 2024 prior to the June meeting?
If I recall correctly, the case was represented, yes.
Right, and that was because I had FedExed that response along with the email documentation from the AG's office and.
Yes, a year later,
Which was
yes.
received in May of 2024, is that correct?
Yes, about a year later.
All right, I agree. All right. Ms. Baker, is an administrative law judge present when the commission votes to impose charges during meetings such as the one on August 7th?
An ALJ,
And Your Honor, I'm going to object to that. We previously discussed that prior to this hearing about how this is a de novo hearing, and what happened in these prior meetings is not only relevant, it's not admissible.
I'm sorry, I didn't know.
My ruling on our pre-hearing motions was to deny the motions to compel and the ancillary supplements to those motions. I don't know where this is going. It may end up leading someplace where I may have to sustain an objection, but I think that question is innocuous enough that Ms. Baker can certainly answer it, and then if it goes further than that, we'll see. So please answer the question.
an ALJ was not present during the meeting.
Thank you. So can the commission vote on, to charge a licensee with dishonesty, which is a serious offense, without a legal recommendation and without evidence from the licensee or from any other source that confirms evidentiary proof of that?
The commission has jurisdiction over licensees here in the state of Tennessee.
Yes. And so that, and they are able by statute or law to charge a licensee with dishonesty without a legal recommendation and without evidentiary record.
The commission can,
They can.
Your Honor, he can't both ask the question and answer it for the witness.
I just said what she said.
well,
She
it
said
was, they can,
I'm sorry.
commas, I'm sorry. And then I stopped when you started.
Okay, so let's please finish your
Okay.
answer. It's I can, and then please conclude.
The commission, they can do several things when a complaint is before them. They can issue a letter of warning, they can dismiss, they can ask for a suspension or a revocation of a license. They can do several things
Okay.
in their purview.
And they
That's
can
in their
do that? And they-
To make our court reporter's job as easy as we can, we've got to try to do better on the crosstalk. Let's try to make sure that everyone gets an opportunity to finish an answer before we move on to the next question, and not interrupting the question either. Ms. Baker, is there anything else that you'd like to add in your answer to that question?
I believe I answered his question.
Okay.
Yeah.
Okay. Please go ahead, Mr. Nutt.
Yeah. Would you agree that regulatory agencies have a duty to ensure neutrality and accountability in their own procedures, especially when disciplinary penalties are at stake?
The mission of the Tennessee Department of Commerce and Insurance is to protect Tennesseans and to empower licensees, and so that's what we try to do at TREC.
All right. So, if legal counsel does not recommend a charge and did not include any exculpatory evidence, during the commission's deliberation to clarify the law and prevent a possible miscarriage of justice, I'm just trying to determine if there's no recommendations of a charge, as there were on this particular evening when I was charged with dishonesty, there was no recommendation made by, if I'm understanding correctly, by legal counsel for that meeting.
I believe, if I recall, well, it depends on which meeting you're referring to.
August 7th, 2024.
Okay. I believe it was open for discussion, and we wanted input from the commission as to.
No recommendation from legal counsel. Sorry.
Let's let Ms. Baker finish her answer.
We wanted guidance from the commission as to the best way to proceed going forward with this particular complaint.
Right, so the meeting started out without a legal recommendation, correct, from legal counsel? That's
The
correct.
recommendation was discussion.
Right, okay. Ms. Baker, what would you say to licensees who sign consent orders, not because they agree with the charge, but because they fear the cost, the stress, the political nature of the commission's process, and the intimidation of meetings such as this?
And I'm going to object to that.
I'm gonna sustain that objection. That goes beyond the scope of the notice of hearing that we're here today on. I don't see how that's going to be relevant to either
I have no
charge or to the relief.
I have no further questions of this witness. Thank you, Ms. Baker, for putting that
Thank
with
you.
me. It's my first time.
Ms. Cooper, before you redirect, I'll ask if the commission members have any questions in this matter. My preference in any case where I'm sitting with the board is, since redirect would usually belong to the party who calls the witness, that even board member questions would need to come before opportunity for redirect.
That's fine. Thank you, Judge.
Mr. Chair, we'll begin with you.
Okay, I'll go ahead and take my privilege here and ask. In the nature of the complaint, I'm looking at State Exhibits number 4, the communication from Ms. Gretchen Culver. In one part of her email, in her signature block, it says centralized complaints, administrative assistant number 3, Department of Commerce and Insurance. And then in the letter, over the letterhead for the department, she gives her title as complaint coordinator for TREC. So I'm wondering if there's a distinction between the two. Is she the TREC at centralized complaints? Is she the TREC person that sits there, or is she?
She sends out, she's the coordinator for all regulatory boards, specifically TREC, in this capacity of this complaint.
Okay, thank you. Commissioners, do you have any other questions?
Chairman, I have a question.
Commissioner Smith?
Yes, this is Commissioner Smith. I have a question. I want to confirm that the address that the letters were sent were the address on file. Is that correct?
Yes, those are the addresses that we have on file for him.
Including the email addresses?
Correct.
Okay, thank you.
Commissioners, any other questions? I got one more. For the terms of the dates, the relevant dates for this complaint, are those dates calculated? We normally calculate based on calendar days versus business days. Are these calculated based on calendar days?
Yes,
Okay, so weekends would count into that 10? Any
Yes.
exception for federal holidays that may occur during that
Yes.
time period?
Yes.
Okay, so when the department sent out the letter on the 20th, as the follow-up letter
okay,
to Mr. Nutt on the 20th, the second notice, that was the 10-day clock had lapsed, and
yes,
that was the time to send it. Thank you.
yes.
Commissioners,
you.
any other questions? Hearing none, Your Honor.
All right, thank you, Mr. Chairman. Ms. Cooper, your redirect.
Director Baker, the meetings that the commission has, when they deliberate over the legal report, are they making binding decisions that are in effect right then, or are they recommendations?
If the respondent agrees to the commission's decision, then they're binding. If not, then they can appeal and have a hearing.
Okay, and that's available, that right to have a hearing is available to every respondent, correct?
Correct.
Okay. And I want to confirm for the commission that when the initial notice of a complaint is sent to the respondent, what along this, with the notice, is sent to the respondent?
They receive all the documentation that we receive in reference to the complaint.
Okay. Once a complaint is turned over to legal for legal's review, are you or the administrative staff of the commission involved anymore at that point?
No,
Okay. So you would have no idea of knowing what happens then, once it's turned over to legal?
no.
Okay. And in regards to Chairman Diaz's question about is it calendar days or is it business days, are the respondents informed that they can submit a response online?
They can email a response.
Okay. So a response can be submitted at any time?
Correct.
Okay. Thank you.
All right, thank you, Ms. Baker. At this time, we'll note for the parties and the board that we've been on the record for about an hour and a half. I can go all day, but I understand that some folks are not camels like myself. So if anyone needs to take a break at any point in time, parties, witnesses, or board members, please just speak up and let me know, and I'll be happy to call a break. But if everyone is all right proceeding, then, all right, Ms. Cooper, if you will call your next witness, please.
The state would call Stephen Moss.
All right, Mr. Moss, will you please raise your right hand for me? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Absolutely. Thank you. Please proceed, Ms. Cooper.
Good morning, Mr. Moss. Could you state your name for the record, please?
Stephen Jeffrey Moss.
And how do you spell your first name? Sorry.
S-T-E-P-H-E-N,
Okay. And your last name, sir?
M-O-S-S.
All right. And do you know Mr. Vincent Nutt?
From our previous encounter,
Okay. And I want to take you back a little bit. You said your previous encounter. When was that?
a couple years ago.
Okay. I want to direct you back to March of 2023. Does that sound about right?
It should be right here. Oh, somewhere about that.
Okay. And what brought you into contact with Mr. Nutt?
My wife had looked up the piece of property in question on her phone, and we reached out to our realtor to see if we could go look at it, if she would contact Mr. Nutt.
Okay. And you jumped ahead on me a little bit there. What kind of property were you looking for and why?
Land to build a homestead, a house, and live on.
Okay. And are you and your wife residents of Tennessee?
Yes.
Okay. The piece of property that you're referring to, was that nearby or far away, or where approximately was it?
We, at the time, were living in Savannah, Tennessee, so it wasn't far.
Okay. And did you employ an agent to help you in this search?
We did.
And who did you sign an agency agreement with?
Elisa Braga.
Okay. Did you know Ms. Braga before this?
Before his property, yes. She helped us look for some others, and she took us around to some we had found and some she had listed.
Okay. And how long had you been looking for a property?
8 months or better.
All right, so this wasn't a new, just rash decision to buy some property?
No.
All right. Were you at the time a first-time purchaser of real property?
No, we've owned other homes.
Okay. And if I may have the buyer agreement. If I may approach the witness.
You may.
Mr. Moss, that document that I just handed you, if you want to look through it for just a second, do you recognize that?
I do.
And what is that?
This was the paperwork with Elisa.
Okay, when you say the paperwork, it's the designated agency agreement, is it not?
It is.
Okay. And if you could go to the very last page there and tell me what day that you entered that agreement with Ms. Braga.
1/24/23.
And who signed that agreement?
She did, and my wife and myself.
Okay, and what's your wife's name?
Sandra W. Moss.
And is she here in the room today with you?
She is.
Okay. And if I may, at this time, enter that as the next exhibit, please.
Any objection?
No objection.
All right, that will be exhibit number 5. You may publish it to the board.
Thank you. Now, Mr. Moss, between this property and properties before this and properties after this, can you give this commission an estimate of how many properties you were interested in and looked at?
100 or better, all over the state of Tennessee.
And how many offers on properties did you make?
One, besides Mr. Nutt's.
Okay, so 2 total,
2 total.
all right? Can you tell the commission about this particular property and what got your attention?
The size of it, the 75 acres it was listed as, and it was just raw land.
Sorry. Technical difficulties. All right. Mr. Moss, the document there on the screen, is that the document you have in front of you, the buyer agreement?
Yes,
Okay. So getting back to this particular property, you said you had looked at up to 100 other properties,
right,
and out of all that, you made 2 offers.
yes.
Okay. So how did you come to see this property?
Our real estate agent reached out to Mr. Nutt, and he met us near the property and took us to it.
And why did Ms. Braga not accompany you to view the property?
Because she's 2.5, 3 hours away.
Okay. Were you involved personally in the setting up of the viewing, or was that between Ms. Braga and Mr. Nutt?
We called Elisa, and then she contacted Mr. Nutt.
Okay. So can you tell the commission about that day that you met Mr. Nutt out at this particular property?
What would you like to, in particular?
Well, upon first meeting Mr. Nutt, how did that go, and what did you do once you all were there, and that sort of thing?
Okay, we met Mr. Nutt out at the Hard Road. I take it it's a private road that these folks had a agreement with the neighbors to go through since the county road was abandoned. They'd had it for years, and they were working on the deeded access. We met Mr. Nutt, followed him back there. We went into the property, and he started by showing us the little shed they had out there, I guess, that they stayed in when they were there. It was in disrepair. Showed us the pond, walked us to the back side of the pond, and said this was the only property line that he knew of was somewhere on top of that ridge, that he had not walked the property or seen it.
Okay. So was it your impression that that was the first time that Mr. Nutt had also been to the property?
No, ma'am. He had said he had been there previously, working on the road a little bit because it was in disrepair, washouts and things. And there was a tree down by the little shed, big pine tree that he had, cut some branches off of to make it where you could get around it.
Okay. When he said that he had not yet walked the property, what did you take that to mean?
That he didn't know where property lines were or anything about it.
Did that concern you at all?
Not particularly. My wife has an app on her phone that she can pull up, and it will show you the property lines, which after we'd been to the backside of the pond, we asked him if he'd like to walk the property, and we'd show him the lines. And it gets you within 10 to 20 feet of the property lines. So he agreed, and we spent 3 or 4 hours walking the property.
Okay. And refresh my memory at least. How big was this property?
Supposedly 75 acres.
Okay. So you said you spent 3 or 4 hours out there with Mr. Nutt.
Yes.
All right. And what kind of interactions or conversation were you having with Mr. Nutt during these 3 or 4 hours?
Everything from just personal and getting to know each other to about the property, which, the beauty of it, the trees, what we were looking for.
And what was your impression of the property? Was that going to work for you?
Oh, it was amazing.
Okay.
Definitely.
All right. Did you have any conversation with Mr. Nutt about whether or not you were going to put in an offer?
My wife had asked him if they would take less, just common sense, try and go low and reach up. He said, absolutely not. Told us a story about the people, and then later we put a full price offer in,
Okay. Do you remember what that full price was?
$150,000.
All right. And was that, were there any contingencies on that offer, sir?
We asked if they would pay for half of the survey because they weren't sure and said they'd never had a survey done, but it was not like it was a deal breaker to do the survey on our own.
Okay. Was that a request or was that a demand that they pay for half the survey?
A request on our part. I'm not sure how they took it or whatever.
Okay. And so you stated that you made a full price offer?
Yes.
Okay. No contingency on financing?
No, we had cash in hand.
Okay. Was there any contingency as to whether or not the survey showed less acreage?
At that time, we really didn't know. My wife did measure on her app, and it came up less than the 75, but still wasn't, so far off that it wouldn't have been a good piece of property.
And if I may approach, Your Honor.
You may.
I just handed you a document, Mr. Moss. Do you recognize that document?
Yes,
And what is that?
it's the land purchase sales agreement.
All right. And was this between you and the sellers?
It is.
And if you could go to the second to last page, under special stipulations, is that the survey you were talking about? The survey request?
Yes.
Okay. And if you could read to the commission what it says there in the type. It starts with the word buyer.
Buyer to perform survey after closing. Buyer requests for seller to pay up to $2,000 maximum for half the survey cost, either directly to survey company or apply it as a purchase price discount.
And if you could go to the very back of the page and tell me what the date that offer was submitted.
3/22/23.
And how long after you walked the property with Mr. Nutt was that offer submitted?
We called our realtor that evening or that afternoon and told her to put in a full price offer.
Okay. And Your Honor, at this time, if I could have that under just the next exhibit.
Any objection?
No objection.
It is admitted as Exhibit Number 6. You may publish it to the commission.
All right. Mr. Moss, I'm going to direct you to the screen up there. Is that the document that I just handed you, the purchase and sale offer?
It is.
agreement? All right. And you said that out of all the properties that you had viewed, this was the one that after walking it with Mr. Nutt for hours, you decided to make an offer right then?
Yes,
A full price offer, no less?
yes.
Did Mr. Nutt make any statements to you regarding whether or not he was going to be able to sell the property or something along those lines?
As we walked, he probably said a dozen times, I'm gonna sell this property, I'm gonna sell it. And it's, you're the listing agent, of course you're gonna sell it. Didn't understand, but, so,
And what did you take that to mean?
we kind of thought that it meant he was gonna be the lister and selling it, so he'd get both sides of the commission. I mean, we don't didn't understand what it meant, but that's all we could assume.
Okay. And did you speak with Ms. Braga by phone that afternoon or by email?
Phone,
And what did you ask Ms. Braga to do?
put in the full price offer on that piece of property.
And to your knowledge, was that done?
It was.
Okay. Did you receive a copy of the emailed offer?
I believe we did.
If I may approach you.
You may.
Mr. Moss, if you could disregard the top part of that there, I didn't want to cut it out and disturb the credibility of the document, but it's starting on where it says forwarded message. Who is this email from?
Our realtor, Elisa Braga,
And who is it to?
Mr. Nutt,
And can you tell the commission the date and time of this email?
March 22nd, 2023, 2 p.m.
Okay? And what is the gist of this email?
Thank you for your time yesterday and for all for the information along the way when writing the offer. Offer is attached. We look forward to working with you.
All right. And this time, if I could enter that as the next exhibit, please.
Any objection?
No objection.
It will be admitted as Exhibit Number 7.
Now, Mr. Moss, going back to the second to last page of your purchase agreement, was there a time limit on the offer?
2 o'clock PM, the 23rd of March, 23.
So 24 hours after it was submitted?
Yes.
Okay. Between the time that the offer was submitted and when you heard back from Mr. Nutt or Ms. Braga regarding Mr. Nutt, what was going on in that 24-hour plus time period?
We were left in limbo, didn't hear anything. It was not the day after, but further than 24 hours, he finally reached out, said he would let her know something by the end of the day. And then the next correspondence was at 9 o'clock at night, a text or email that it sold.
Okay. Was Ms. Braga keeping you in the loop about these communications, sir?
Yes, because my wife was calling her regularly to find out what was happening.
Okay. If I may approach, Your Honor.
You may.
I'm gonna hand you a document. You could tell me what that document is, sir. And again, if you could start with the forwarded message part going down.
This is, the buyers have requested verification that this offer was submitted. Thank you.
Okay, and then could you tell me the date of that email?
March 24th, 2023,
And the time?
10:41 a.m.
Okay. Now, Mr. Moss, why was your agent asking for verification that that offer was submitted?
Because we hadn't heard anything within the 24-hour period.
Okay. Were you concerned about anything?
Yes and no, because according to Mr. Nutt, there was no potential buyers, no other people interested. So we thought, it was a pretty well for sure deal.
And, Your Honor, at this time, if I could have that email labeled agent communication entered as the next exhibit.
Any objection?
No objection.
That'll be admitted as Exhibit 8. You may publish to the board.
I'm not
That's
sure
right,
if
to
you
the
already have a
commission.
copy or not. If I may publish it to the jury, or the commission.
Please.
Now, Mr. Moss, was your agent and you and your wife, I don't want to put words in your mouth, but were you irritated or concerned, or what were your feelings, including your agent, the discussions you were having?
Just concerned, wondering why we hadn't heard within the 24-hour period and why we hadn't heard till later the day after.
Okay. And then you eventually heard what, sir, regarding that property?
That it sold. That's all he had said.
Okay. Did you finally, at some point, receive written confirmation that it had been rejected?
Yes.
Okay. If I may approach, Your Honor.
You may.
I hand you a document that looks similar to one I already handed you, but if you could turn to the last page there and tell me what's on the back there.
It's rejecting our offer.
Okay, and what's the date on there?
3/23/23.
And who is it signed by, sir?
My wife and myself and the owners of the property.
Is there a time on there as to when it was rejected?
Not that I see.
If I may have that entered as the next exhibit and published to the jury or commission?
Any objection?
I'm sorry.
If I can have it.
No objection.
It is entered as Exhibit number 9, and you may publish to the commission.
Thank you, sir. Now, Mr. Moss, after the offer was rejected, did you ever any further dealings with Mr. Nutt?
No.
Okay. Why did you, on May 15th of 2023, you and your wife, file a complaint with the Office of the Attorney General regarding Mr. Nutt?
Because my wife, like previous other properties we looked at, kept tabs on them and found out that he had bought the property.
Do you remember when you learned that?
It wasn't a few days, I'm not sure. It wasn't long after.
And why did that bother you, or why did that matter?
Because we were told there were no other interest. The logging company who had been turned down, one other, a doctor that wanted it to ride his bikes if Mr. Nutt would put in bike trails and maintain them or have someone do it, and there was no other interest.
If you had known there was any other interest, would that have made any difference?
No, we'd have still put in the full price offer.
Okay. Were you given an opportunity, or did you ask to make a counteroffer?
We were not given the opportunity. It was sold.
Okay. If you had been given an opportunity to make a counteroffer, would you have?
Absolutely.
You mentioned
I'm
timber.
sorry, objection, that's speculation.
Response, Ms. Cooper?
I'm asking the person directly, if such and such had happened, would they have acted in a certain way? I think he can testify as to whether or not he would have acted that way.
I'll overrule the objection. The answer will stand.
Thank you, Judge. You mentioned a moment ago timber rights or logging. Why was that important?
Wasn't to us. We didn't plan on cutting trees. Just enough to build a house and have a garden and live.
Okay. Had Mr. Nutt said anything to you when you were with him on that day walking the property about timber rights or logging?
No, he was just talking about the size of the trees and how many big ones there were and how beautiful everything was.
Okay. At some point after the property was sold, did you learn anything about the timber rights or logging that also caused you concern?
Originally, his reposting of the property for sale stated that he maintained timber rights to the bigger trees and a percentage of the smaller trees.
Okay, and when you say he listed it, who are you referring to?
Mr. Nutt.
Okay. When did you learn that he had relisted the property?
It wasn't too far down the road.
Okay. Were you able to find out what he had paid for the property?
I don't remember if we saw what he paid, but he listed it for $175,000.
Okay. Do you know how long after, and if you don't know, that's fine, you can say you don't know. Do you know how long after he closed on the property that it was relisted for?
Repeat it, please.
You learned that he had purchased the property, correct?
Right.
Did you learn how long, time-wise, after he closed on the property that Mr. Nutt relisted it?
Not quite sure.
Okay.
My wife kept looking on her phone and has screenshots of the listings. The original listing with the timber rights and stuff disappeared, and there's a new listing for $175,000.
If I may approach, Your Honor.
You may.
Mr. Moss, I'm going to hand you what's previously been entered as exhibit number 3, and direct you to, sorry, 1, 2, 3, page 4 of that document. And you see at the top where it says Office of the Attorney General, State of Tennessee?
Yes,
Okay. Can you tell me the date on that?
5/15/23.
Okay. And, Mr. Moss, in that complaint, you mentioned that you do mention Mr. Nutt had already relisted the property for 175,
Okay.
correct?
Right.
Well, don't don't
Right.
agree with me unless you know that's the truth. So, if you could look and see if that's what is mentioned in that complaint. I believe you'll see it's at the top of, save a little time, page 3 of the actual complaint.
You may.
Thank you. On the next page, this way.
This one.
Yes, sir.
That's it?
That's it. No,
Oh, I'm sorry.
no, you're fine. You see where it's, so
Yes.
170, okay. So would you agree with me, Mr. Moss, that you, in that complaint that you filed on May 15th of 2023, you mentioned, part of the allegations were that he did relist it for 175?
Right, yes, ma'am.
Okay. All right. So sometime between March of 2022, 2023, and May 15th, he purchased the property, turned around and resold it, or tried to resell it. Is
Yes,
that accurate? Okay.
Yes.
And then you filed that complaint?
yes.
Okay. And again, if you could, tell the commission why you filed the complaint.
Well, the property sold the day we looked at it or the day after, and it concerned us that he bought it because he knew our bid, so he upped his bid and that was it.
All right. Can I have just 1 second? I don't have any other questions. Thank you.
All right, Mr. Nutt, any questions for Mr. Moss?
Yes.
Please go ahead.
Good morning, Mr. Moss.
Good morning.
How you doing?
Good.
All right. Mr. Moss, you stated you were represented by Miss Elisa Braga of Skinder Newton Realty of Cookeville, Tennessee. Is that correct?
Yes,
And you stated that her office is more than 3.5 hours from the land that we looked at together.
somewhere approximate.
Now, did you ask Miss Braga to show you the subject property?
No, because we were there, we had tried to find it and turned back because the road's disrepair and didn't want to wait 3 hours and be late in the afternoon before we could look at it.
I see. So I guess then that's how the decision was made. Would you agree then that that's how the decision was made, that I would show you the property instead of Miss Elisa Braga or someone from her office?
Yes, because you listed it, you should have been the one that knew about it.
But the decision was made because her office was 3.5
Yes.
hours away? Okay. Did you get confirmation from your agent, Miss Elisa Braga, that an appointment had been made for you to meet with the listing agent of the subject property?
Yes,
Now, other than that physically deteriorated building, I think you've already testified to this, but I'm just making sure. Other than that physically deteriorated Morgan building with no power or water, would you agree that the subject property is an unimproved tract of land?
yes,
Were you made aware that the subject property was landlocked during the showing?
yes.
Okay, were you permitted to see all of the property that you wanted to see?
Yes,
Now, did the listing agent inform you, and I'm going to ask you this explicitly because I think there's a point of contention here. Did the listing agent inform you that there were other interested parties and that offers had already come in and that others were expected to come in?
the listing agent?
No?
Who?
Yeah,
Our-
me. Did me, the listing agent, inform you that there were other interested parties and that offers had already come in and others were expected to come in?
You had mentioned the logging company that put an offer in that was low and they rejected, and the doctor that showed a little bit of interest if you would cut him in bike trails and maintain the road for him.
That was the fellow from
That
Birmingham.
was the only two. You said there was no others, and us.
Right. Unfortunately, I think you might have misunderstood me on the timber buyer. Wasn't really a logging company. And
Objection, Your Honor. It's telling him what he understood or
Okay.
didn't understand.
If we could keep it to questions, that's certainly, you can certainly add that in your testimony.
did the AG's
but-
office send you my response?
Your response.
My response to your complaint?
Next.
Did you get a response to my complaint? Did you receive, I sent a response into the AG's office, and did you read my response? Have you read my response to your complaint? Okay,
Yes.
that's kind of what I was getting at. And so, in that response, did I disagree with you about whether or not the property had been relisted, and did I correct the record and say that only the timber rights had been listed?
You did state that, but that's not what it said in the original listing that's disappeared off
Well,
Zillow or
the
whatever it was.
MLS has historical data on that, but.
They do.
The petitioner hasn't submitted that as an exhibit. But the response did disagree with you on that point, that I've only listed the timber rights in my response to you about that, and I did not list the property for sale.
That's what you state now, but that
In
wasn't
the
what I
response.
understood from the first listing that disappeared.
Well, all right. Thank you for clarifying that. Now, did the listing agent inform you, oh, excuse me, that's already done. Did the listing agent inform you the sellers had rejected other offers where things were asked for in return and preferred clean offers?
No, the only one rejected was from the land company because they didn't want to pay what they wanted. That's
Okay.
what you had stated.
All right. Did you communicate with your agent, Miss Elisa Braga, the landlocked issue? And did you talk to her about the presence of other interested parties, even the timber company or whatever, how you would explain it to her? And the preference, and did you explain to her the preference that I gave you, that the sellers wanted clean offers?
Don't recall the conversation of a clean offer. We did make a full price offer and asked if they were willing to do part of the survey.
So you don't recall. Now, is this your offer that Miss Exhibit 9 here, this Exhibit 9, Petitioner's Exhibit 9, the offer that was signed on the back by the sellers? Is this your offer here, Exhibit 9? It's the one signed by the Tysons on the back side there. I'd like to go over that document with you.
If this is the document, the purchase sales
Land-
agreement?
Lot, land, purchase, and sale agreement, yes, sir.
Yes.
Okay. And so on the front page, do you see that, does it say that the purchase price to be paid is $150,000?
Yes.
Okay. And as the petitioner stated, no financing, so that's a cash offer, right?
Cash offer.
Does your offer state that you will put up $1,500 earnest money?
I don't recall.
Don't recall. All right. Does your offer indicate that the closing will be within 21 days? That would be on. Be over here on, it would be section 4, line 177 through 180. Says here, April 12th, and that's, I did the math on that, it seemed like it was about 3 weeks. But is that correct? April, the offer was made on 3/22, and the closing date, April 12th. Do you agree with that?
That's what it says.
Okay. And so that was 3 weeks closing, which I thought was pretty fast. All right, and then we turn back over here. Now, did you put an expiration date on your offer of 24 hours?
I believe our real estate agent did.
I see. That was going to be one of my next questions. Did you discuss the strategic implications and how a 24-hour expiration may be interpreted by the other side with your agent, Miss Elisa Braga? Would you like me to repeat it?
Please.
Okay. Did you discuss the strategy, the strategic implications of how a 24-hour expiration date on your offer, which is a self-limiting expiration, may be interpreted by the other side with your agent, Ms. Braga? Did you and Ms. Braga talk about the strategy of that term, 24-hour expiration?
There was no strategy on our part. I don't know if that's routine for her or what.
I see. Does your offer state in the special stipulations section of your contract the following? Now, that's going to be the next to the last page, and it's lines 443. I believe the petitioner's already covered this with you, but I want to go over it again. And it says here, this second paragraph, and I'll read it for you. It says, buyer to perform survey after closing. Buyer request for seller to pay up to $2,000 maximum for a half of a survey cost, either directly to survey company or applied as a purchase price discount. Did you agree to that term, sir?
We did put that in.
Okay. And did you discuss the strategy implications, the strategy effect of that with your agent, Ms. Braga?
I don't know that there was any strategy. It was a question if they would do that since there
Okay.
was no survey. It
So this was
didn't,
something that you asked her to put in there for you?
I believe my wife did.
Okay. Now, it says here that $2,000, that it can be applied as either a payment directly to the survey company or applied as a purchase price discount. Is that correct?
That's what it says.
And so if it were applied as a purchase price discount, $150,000 minus a $2,000 price discount, would that then make the offer, would you agree, make that offer $148,000 net
If
to the
they-
sellers?
Well, it wasn't the 2,000, it was half of a survey, which was a guess, but it could be, or they could have rejected that part and just accepted the offer.
Yes, they could have done that.
They could
They
have,
could have, but that was their choice.
yes.
Yes, okay. But this was your choice, to put the $2,000
Request, yes.
what we call in the business a concession. And you did say that you would take that applied as a price discount, did you not?
Yes.
Okay. All right. And there's that time-limited offer right underneath that. Okay. Now, on the very back page, there's a signature page right back there.
Yes.
All right. Now, the signatures of the sellers, your signatures are electronic, is that correct?
Yes.
And the seller's signatures is handwritten, is that correct?
I guess, yes.
Yes. And so, and I agree with the petitioner that the time was left off, but the date of that is 3/23 of 23, is that correct?
Yes.
And your offer was made on, up there where you signed, it was made on 3/22 of 23, is that correct?
Yes.
Okay. So maybe not 24-hour turnaround, but we did get it turned around in a day, in a calendar day. Is that correct?
We didn't hear back in 24 hours, though.
Understood. Understood. I'm going to give an explanation for that later, and if you stick around when I give my defense presentation, okay? All right, so thank you very much. That answers those questions. Now, did you receive from your agent, Ms. Braga of Skinder Newton Realty of Cookeville, a response from the sellers rejecting your offer, signed and dated by their own hand, which we just looked at, which is Petitioner's Exhibit 9?
Eventually, we did.
Okay? Would you agree then, Mr. Moss, that you had an honest presentation of the subject property? You presented an offer that was good for 24 hours by your own choosing. You showed a price of $150,000 on the front page, while requesting $2,000 price reduction or a cash payment to a surveyor on the back page. Your offer, which was in writing, was submitted, reviewed, responded in a timely manner from the sellers with handwritten signatures. Is that correct?
I guess it is, yes.
Did you pay your agent, Miss Elisa Braga, and her firm, Skinner Newton Realty, compensation for professional services you engaged them for regarding the work performed on the subject property?
For the work before.
Did you, yes, regarding her work for you, writing this offer up and talking with you about it, did you provide her any compensation for her work on this matter?
On that matter,
Yes, sir.
not particularly, no.
Okay, thank you. No further questions of this witness.
All right, Mr. Chair, does the board have any questions for Mr. Moss?
Ms. Torvett?
Mr. Moss, when did you receive the rejection?
We were told of it a day and a half later. She got it at 9 o'clock at night from Mr. Nutt, and all it said was, "It's sold."
So
Well, there was
this that we have here, that doesn't have a time on it, but it has the date on it.
It has a date on it. I
3/23.
don't know when she got that, but
When did you get that?
that I couldn't tell you.
Do you know who owns the property now?
I assume it's Mr. Nutt still.
Did Mr. Nutt ever indicate to you that he was interested in the property?
No, not as far as buying. He did make the comments about the trees and how beautiful it was. So did we.
Okay, that's all.
Any other questions? Commissioner Gwynn?
Yes, I heard the word landlocked. I think in your question regarding the land, how were you going to get to the land if it was landlocked?
Well, legally, you can't. These folks had an agreement with all the neighbors, and they'd been using the road that went through to it that everybody else used. And I don't know how it is here with Florida, you can't landlock. And if you grant them access for so long, it's access. Now, he had stated there was an attorney working on getting it to be a deeded right-of-way, gave us that information, that we could take it over and pay him to get that done.
So the contract, though, didn't say anything about that, correct?
No.
So if the contract had been accepted as written, how are you going to deal with not being able to get to it?
There is a road to it, and they can't stop you legally from getting to it.
Is it a public road or is it a private road?
If it's private, they've granted these folks access for however many years they've owned it. So if you're granting it, it's kind of grandfathered that you can't shut it off, you can't landlock it.
Right. So did you look at a document that said anything about that?
No, he told us who the attorney was and who was working on it. And I don't know if we went by and talked to the attorney or not,
Okay.
because we'd have gladly taken it over and gotten it taken care of.
Did you and your agent talk about that?
Not to my knowledge.
Okay, thank you.
Commissioner Smith?
I have a question. How did you receive the rejected document? Was that an email or hand-delivered?
We got the initial over the phone
Okay. You got an initial phone call from
from
your
our
agent
agent stating that it was sold, and it was after 9 o'clock at night when she got it.
But you eventually did get this document saying that it was rejected?
I'm sure we did.
Okay, but you're not
I'm
sure?
not positive.
Okay, that's fine. But you don't know if you received it in an email or not?
Not sure.
Okay, thank you.
Commissioners, any other questions for Mr. Boss? Hearing none, Your Honor.
Thank you, Commission members. Ms. Cooper, redirect.
Mr. Moss,
Yes.
when you left Mr. Nutt that day at the end of walking around the property for 4 hours or so, what was your understanding about whether or not there were any other offers outstanding?
There were no other offers. There was the doctor that was interested. The land company had been rejected. and-
So there had been at least one offer rejected, as
Yes.
far, is what you were told.
Yes,
Did Mr. Nutt tell you that this doctor, you've mentioned a couple times, had already made an offer or was just thinking about
he
making
was
an offer?
thinking about it.
Okay, so Mr. Nutt told you there's no other outstanding offers?
That's correct.
Okay. Did Mr. Nutt ever tell you, while you were there with him, that he had decided to purchase the land himself?
No.
That's all I have, thank you.
All right, thank you, Mr. Moss. Any break requests? Let's take a 5-minute recess and try to keep it to 10.
Thank you, Your Honor.
All right, we are back on the record. It is 11:55 a.m. Central Time. We have just concluded the testimony of Mr. Moss. Ms. Cooper, your next witness, please.
The petitioner rests, Your Honor.
Petitioner rests. All right. Mr. Nutt, call your first witness, please.
Okay, I don't have any witnesses, so I'm just going to present, I have a slideshow to present, and I have a slideshow to present, and I'm going to try to work my exhibits in, because, they're not necessarily in the slideshow, okay? And so to do that, I think I gotta go over here and do that.
All right, before you begin, Mr. Nutt, if I can get you to raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Excellent, thank you. And for the purposes of just board instruction and expectation, I assume that Mr. Nutt will need to give testimony from that position. I know that the board in no way would allow the seating arrangements of prior witnesses to infer anything from that, but I'm now stating so for the record, just to protect the case on appeal.
All right. There we go. Okay. Can everybody see that okay?
Excuse me, Judge. Mr. Nutt, if you,
Yeah.
this module can move in its entirety, if you could move that closer to you, so we can
Is that better?
make sure to get you on the microphone.
Sorry.
Yes, sir.
Okay, first time. I have these slides here, but I also have, if you prefer paper, I have sort of a Word document kind of version of this, if anyone prefers to have paper in front of them, but otherwise, we'll just go through this.
So for the record, my preference is to go slide by slide rather than the entirety of the paper document. Even though technology is being used here, there may be objections to certain slides that may result in instructions that could involve me telling the commission how to accept those, or if they need to exclude them. If you give them a paper copy, I'm concerned that there may be some reading ahead that would not allow for the contemporaneous making of objections and protection of the record.
Okay.
Your Honor, at this time, I'm going to have to object to the slideshow. I've never seen it before. It wasn't on an exhibit list submitted by Mr. Nutt. I'm going to object to it being broadcast to the commission at this time, and I would ask you to strike it.
Response, Mr. Nutt?
Well, this is the organization of my defense. If I would say that let the petitioner give me a chance at it, and she could object slide by slide if she objects to some of the data that's presented.
And, Your Honor, he's already simultaneously broadcasting it to the commission, and again, I've never seen it before. So in order to object slide by slide, I would have to be able to look at it before it can be broadcast.
All right.
But I would also, again, object on the grounds that he did not submit this document, slideshow, whatever it is, as part of his exhibit list, and I have not previously been provided a copy.
I'd be more than happy to email it to her if she wants it now. I can read it without displaying it.
All right, give me a moment.
I did make a motion to use that and was
Well,
granted.
the motion was to use technology that doesn't.
I got you.
That
Content.
doesn't include that everything that gets posted on there is going to necessarily be admissible in this case. Let me look through. Would you mind handing me a paper copy?
Yes, sir.
And going ahead and handing Ms. Cooper a paper copy. All right, here's where I am on the slideshow, having looked through the paper version and compared it to the witness and exhibit list in this case that was filed by Mr. Nutt. Two things two things are coming to mind in this circumstance. The first is that it wasn't on a witness and exhibit list, and that could potentially create prejudice to the department. My concern here, and perhaps the most important concern here, is that there are portions of this presentation that as part of a procedure, I do not make objections sua sponte. But I can look through a document and I can anticipate when things might be problematic. There are portions in this that I can anticipate that there is a strong likelihood that there will be objectionable information in here, as written. Whether or not Ms. Cooper chooses to make objections in that line, I can't control that. But this is significantly easier to rule on objections and to prevent potential damage should something be presented visually that gets objected to. It is significantly easier to control and to protect the record if this matter is presented as a narrative without the slideshow. So at this time, I don't think there's any prejudice to you, Mr. Nutt. You've done well so far in presenting your case and asking questions. I think you're appropriately clear in this matter to where I don't think that you would need the slideshow to adequately say everything that this indicates that you want to say. But the risk is of allowing a slideshow and getting challenged for prejudice based upon the witness and exhibit list, as well as the difficulty in walking back objections and exclusions for material that's presented visually in slideshow format is too great for me. So I'm going to exercise my discretion over matters of discovery and evidentiary procedure, and I'm going to disallow the usage of this slideshow. And I'll note that does not, board members and commission members, that does not indicate how I feel one way or another about anything that was in the presentation that I saw, or that anything that will come in Mr. Nutt's narrative. That is just simply me making an evidentiary ruling to do my best to limit prejudice to both parties and to protect the record. So with that, Mr. Nutt, you may present your case. Thank you.
The honest licensee defends his integrity. A dishonest man will sign a consent order and mail in a check. An honest man will fight to maintain his integrity. The key takeaways from today's presentation are this. I plan to tell the truth and the whole truth. And what I did wrong, what I did right, all that. Application and reconciliation of laws and rules, we're going to talk about those things. This is probably the subject that might be a little bit, touchy, but we're going to talk about TAPA guidelines and fairness and neutrality that TAPA guidelines speak about, particularly with regard to the August 7th, 2024 vote and the 2024 meeting.
And Your Honor, I'm going to object at this point to the relevance of that.
We are not there yet, Ms. Cooper. Certainly, we can deal with that issue once we get into it a little bit more. But I consider this more of an opening statement to a narrative. And so I'm going to overrule your objection without prejudice if you choose to bring it up when we get into the meat of that subject. Please continue, Mr. Nutt.
Thank you, sir. And then, of course, we're going to review that meeting from August 7th a little bit. And then there will be closing statements and a call to action. The first thing I want to talk to you about is the subject property. Now, at the time of the listing, the subject property was a 75-acre deeded timber tract. The sellers were in their 80s, and they were making those kinds of decisions that you make when you're in your 80s. And they had bought the property on the deed, and they had never had the property surveyed. And they were wanting to sell the property on the deed. The property is severely landlocked. It's 1.2 miles from the public access road down an old access road bed, which is in disrepair. The seller relied on the respondent for marketing the property in the seller's best interest. And at this time, I would like to show an exhibit, and please bear with me on the exhibits because I made a file for each of you thinking that I could just hand it to you, and then I watched Ms. Cooper do it one at a time, so
So here's the procedure that we'll use for that.
Yes, sir.
First thing, you'll need to show it to Ms. Cooper.
Yes, ma'am. Yes, sir.
You're fine. show it to Ms. Cooper. Then I'll ask Ms. Cooper if she has any objections, and then we'll take it from there. Excellent. So, and while Ms. Cooper's looking at it, it might be a good idea, since those will have to be published to the board, to go ahead and start separating them out to where there's a copy for everyone.
May I start passing these out before I?
Just one second. Ms. Cooper, any objection?
I would just ask, is he wanting to enter the documents he just gave me as a whole or in part?
Well, it should be, you know, 3 pages. Is it 4 pages?
No, sir, it's 5 pages.
Is it 5 pages?
Mm-hmm. And we have a map and then 4 documents of legal documents.
Yes, that is correct, 5 pages. And that's going to be, you know, in whole.
Okay. I don't have any objection.
No objection. They will be admitted as collective exhibit number 10. And you may publish that to the board and a copy for the court reporter as well, please.
I only made 10 copies.
I believe you will ultimately need 1,
I might
2,
have
3,
11.
4, 5, 6, 7, 8. Only 9 copies, and including possibly 1 for yourself. My copy is the exact same as the court reporter's copy.
Every break we take, I'll try to get these.
You're fine. You're fine.
May I have permission to approach?
You may. And for the record, collective exhibit 10 looks to be an admitted complaint from McNairy County that's 2 pages long, a warranty deed that is 2 pages long, and a map. All right, please proceed, Mr. Nutt.
Yes, sir. And so I think Mr. Moss was a little bit confused about some of the things he heard me say, but this lawyer was not working on the easement. I had gotten a quote from him about the easement, and I was telling Mr. Moss what that quote was, what that estimate was, and what that attorney's name was. Now, he wasn't working on it, but I had gotten a quote from him and was passing that information on to Mr. Moss. as a prospective buyer. But this is what was filed day of closing. And by the way, the sellers saw that. It was a joint closing. And so they were completely aware of it as well. But this is the procedure that we're taking to try to cure the external obsolescence, which is severe. The property, if you'll look at that map, and then you'll see that those old county road systems actually goes all the way through to 2 separate public roads. And one of those roads is Sulphur Springs Road, but it's 1.2 miles away, but it goes along a ridge. So it's an all-weather access. It would qualify for lending purposes. Lenders want an easement with all-weather access. It's 0.6 of a mile from Danhead Road, but there's a creek bottom that runs through that side. The loggers say they need to come out that side. So it's a very complex lawsuit. It's very, very difficult to get a judge to agree to giving you an easement to 2 separate public roads. But that's the daunting task that we're trying to get done, because the loggers are telling me, I won't log your 69 acres. I won't log that farm 1.2 miles down an old county road. I'm just not going to do it. We'll just pass on that. So the 0.6 of an acre, or the 0.6 of a mile going out to Danhead Road, that's what we need for the loggers. And we're trying to negotiate with sellers on the property owners on that side to, maybe just give us timber rights only. And we're even floating, 2-year floating every 10 years, something like that. But wanted to show you about the subject property, the external obsolescence that it did have. And of course, that was also disclosed. And these are the things that we're doing to try to remedy that for this property. Now, the next thing I want to show you is I showed you the easement, but I also have some videos of that easement road that I took for you guys. If you wanted to see it, they're not that long. I did submit that as part of the exhibits list when I submitted my exhibits list. So if I'm not mistaken, it's approved. And I did try to shorten it a little bit from YouTube so it wouldn't be too long. It's up to you if you'd like to see, that 1.2 miles and that 0.6 of a mile from both of those sides. Just see the external obsolescence for yourself, what it is. But then I'd probably have to share my screen and whatnot. But I think you can see from the map. Is that good enough for you? And that way we can spare the time on the watching videos and that. It's entirely up to you. I do have video evidence of this road if you guys would like to see it. And it has been submitted as an exhibit.
So Mr. Nutt, it is your choice as to the evidence that you want the board to see. So if you'd like them to see it, you can move for its admission, and then I'll hear whether or not Ms. Cooper has any objection to it, and we will go from there. But the board can't answer that question. It's really each party's individual determination whether or not they want to attempt to offer something into evidence.
Well, I would like to show the videos of the easement road, please.
All right, Ms. Cooper, any objection?
I would object on the basis of relevance. I'm not sure what this has to do with the failure to respond or the good faith and honesty allegations that are contained in the notice of hearing and charges.
All right, I'll hear a rebuttal from Mr. Nutt.
Well, I think that one thing it does is it kind of recreates what Mr. Moss went through that day, but it's okay. I can do with or without it. I can still present my case. I just wanted to show the external obsolescence, and I thought maybe a visual might help, but not totally necessary.
All right, I will. I think that the board's time would be better suited with a narrative. I think that the in this case, Exhibit 10's map, as well as your testimony, is certainly descriptive enough to show the issues with land locking that you're discussing in terms of functional obsolescence.
External obsolescence.
Sorry, external obsolescence. Sorry.
Okay, so we'll move on then to the timeline of offers. We're going to cover some offers now. And again, I think Mr. Moss misunderstood some of the comments I made to him because I was in negotiations with this timber buyer. There was a counter offer in play. Yes, he came in low, but it wasn't rejected. It was countered. and I have that document here. The Stoltzfus offer will be the next offer, my next exhibit. Is the Justin Stoltzfus offer. In fact, it's okay with, that's the Tyson offer. This is the whole offer, right? This is no, that's not. That's it. My apologies, Ms. Cooper. My fault. My bad. Sorry about this. Where's that signature for that? I had something's mixed up here, Ms. Cooper. I got it. Please let me know if you have any objections.
I don't have any objection.
All right. The document will be entered as exhibit number 11, and you may publish it to the board, Mr. Nutt. Ms. Cooper, Mr. Nutt, should this page be in? No, sir? All right. If everyone can check and make.
That's the next exhibit, I'm sorry.
You're fine. I will leave it up here for in front of our court reporter for the moment. For the record, exhibit number 11 should be.
So,
Just a second.
I count 12 pages, Your Honor.
I do as well, and I'm going to change. I'm going to change my nomenclature for Exhibit 11 to Collective Exhibit number 11. You've got 13.
Does everybody have the right pages?
3, 4, 5, 6, 7, 8, 9, 10.
what are we missing?
I have 13. One of mine stuck together. The first page should be
Counteroffer 2.
counteroffer 2. The last page should be signature page with reflecting an offer date of March 17, 2023 at 6:55.
I have those pages, Your Honor.
Here are the pages.
Yes, sir, I do.
So the first page should look like this minus the sticker. The last page should look like this. All right, please proceed, Mr.
Okay, so everybody's okay? So if you'll see from this offer came in on March 17th. And the sellers sent this young man a counteroffer for $150 for the deed, $150 clean, we call it. And then on March 2023, an email from the respondent sent that counter over to him saying that it was a take it or leave it offer from the sellers. The Stoltzfus did counter back. As you can see, that counteroffer 2 is him countering back contingent on a satisfactory survey because he also did not think the acreage was there. And he was concerned about that because the math has to work for him. He's a pragmatic timberman, and the math has to work. And so that acreage is important to him. And my next exhibit is my communications with him, which took place contemporaneously with the Moss's showing.
All right, for that offered exhibit, if you'll hand a copy to Ms. Cooper.
Your Honor, I would object on the grounds that not all of the messages are contemporaneous with the Moss offer going back and forth. So I'm not sure if he wants to break them up or how we would separate them out.
Be more specific if you could, Ms. Cooper. Which ones are contemporaneous and which ones do you contend are not contemporaneous and which ones do you contend are?
I'm sorry. You'll let me have that. It may be that page 2 is a little less than, this would be after the fact, just showing, I included those just to show that our relationship continued after.
And I would object on relevance at that point, but we have dates in the text. These haven't been published to the commission yet, have they?
They have not.
Okay. I have dates in here showing August 10th, May 7th, or I thought that said May 17th. There was one. Yes, there's a May 16th text in here that I just don't think are relevant and would ask those not to be included.
Would it be okay with her if I read or if she would like to read the ones that she's willing to let be on the record? all I want to do is just show the commissioners the communication with them that was contemporaneous, if she's okay with that. And we can omit the ones that are not, and we don't have to publish if we can't separate them on paper. I can just read them if she will approve of that.
What say you, Ms. Cooper?
Let me see. I would say like, show you this page, the words just got the 4 on there.
Let me,
And just take that one out.
at the risk of being a little too hands-on, let's do this. Let me stand near y'all. Madam Clerk, if you can't hear me, please just have to speak up. And walk through the ones you have an objection about, and which ones you're all right with Mr. Nutt reading and don't have an objection about.
I have an objection to these, that one, and that one, because from what I can tell, they have nothing to do with the dates that we're talking about.
And what about the first page?
I'm going to have to accept Mr. Nutt's sworn oath that these are contemporaneous. They could be, so I won't object to
Okay,
those.
so no objection to the first page?
No, sir.
But the second page is objected to?
Yes, sir.
Mr. Nutt, do you want to read in the first page, or would you prefer to, I'm gonna sustain the objection on the second page. I can't tell if they're contemporaneous or not really. First page, there's no objection. I can give you your choice. You can either read those in, or if you just want to put in the first page but not the second into evidence, we can do it that way too.
Okay, I'd like to just publish that first page then.
All right, without objection, the second page, sorry, the first page of messages between you and Mr. Stoltzfus will be entered as collective exhibit number 12. Just need the first page. That is the first page. That is the first page. You may keep that. If members of the board, if you have, if you have this page, then you have exhibit number 11.
You don't want the one with 4.
You don't want one, but we don't take anything.
Hey, well, I think some people got some extra pages on the end. I'm sorry.
Your Honor, just so I understand the sequence of these messages, do they go across, or are they?
Some of you have it already.
So that will need to be a question that Mr. Nutt would have to answer, and can certainly be a question that you ask during your opportunity. Thank you.
How many do I lack? 2. There we go. Now let's hope I've got one left. I don't know if you can read it or not. I wore my laser printer out last night. So let's see if I can find one that I can talk with you about. Okay, here we go. So what I wanted you guys to see was that, and under oath I attest that this is contemporary. So this was after the showing with the Mosses. I was actively working this buyer, and he was an unrepresented buyer, by the way. So here's what it says. I think I've got a cash offer coming in tonight from another buyer. No survey, no easement. I'll keep you posted. He didn't accept my offer, Stolzfus said. Not yet. I'm still showing the farm. I think I just sold it. Justin, no survey or easement, $150 for deed. Do you want to reconsider your counteroffer and accept the seller's counteroffer to you, $150 for the deed? I told you I was going to sell this farm. And then I think this other one, this one that's in small print, I think it's the same message. It's just the whole thing. And it says, do you want to reconsider your counteroffer and accept the seller's counteroffer to you, $150 for deed? I told you I was going to sell the farm, Justin, and I can...
Your Honor, if I may interrupt, at least one commission member has the page that we've already excluded. So I would ask that we, again, make sure that they're only looking at things they're supposed to be looking at.
Please disregard.
My fault.
Please, it should just be one page, 6 messages. And if you have the second page, please disregard.
And so just moving on to that, the main point from that thing is the top line is that I asked him to accept the seller's counter to him for $150 for the deed. And then he came back and said, I believe I made a good offer. Anyone buying it is going to want to go a good deed description. I'll buy the farm. I just want a survey. I'm a cash buyer. I said, well, they are too, and they want to close in a week because their offer says they would close faster. The real question is, are me and the seller, it's supposed to be with an S, but I was talking, too low at $150? It would be a very good price at 75 acres, but it's not there. If that deal falls through, I'll pay the $150. How can they run a title in a week? My lawyer would need at least 2. If you want to sell it to the couple, I'm okay with it. I'd love to buy it, but I'm not desperate. I have 3 other farms under contract at the moment. One is 1,200 acres. And so this gentleman and I were working together, and he was an unrepresented buyer. I was completely, the message to him was the same as the message to the Mosses. The sellers want 150 clean. Bring me 150 clean. The message was the same to both parties. And it was, and I'm encouraging this man to accept the seller's counteroffer for 150. That's not a sign of covetousness, okay? I'm not steering this man. I'm asking him, please buy the seller's farm. Take the counteroffer they've given you and sign it, and the farm's yours. So that would seem to run counter to a listing agent who's coveting the farm, and he's operating with greed, and he's trying to, manipulate the situation for himself. That's not what happened at all. I was a listing agent right up to the last second, and I was trying to get both of these parties to bring me a clean 150, and they just didn't. All right, so moving on now. The next timeline offer is going to be the Moss offer. Now, you guys have seen that one. Those exhibits are the petitioner's exhibits that you've seen before, Petitioner's Exhibit 9 that we talked about with Mr. Moss. And that was written by Miss Elisa Braga. And I remember Mrs. Tyson made a long face when I read the special stipulations requesting the $2,000 concession. But I want you to know something. I presented this offer just as positively as I could. I actually wanted them to counter. And I told him, I said, look, this is a couple loves the farm, and they're giving you this 150. It's all cash. They got 3 weeks closing date. I didn't even talk about the 24-hour thing, but they knew about it already because they were pounding the table for the 24 hours. Now I was having to call the sellers and say, look, I need to meet with you because they really want to know. But the sellers were out of town visiting with grandkids. They had doctor's appointments the next day. So I met with them when I could. And then I even asked them, I said, well, can you nail down a time for me so I can let these people know? And they said, no, we'll call you when we get out of our doctor's appointment and let you know when you can come over. As soon as I had that information, I relayed that to Ms. Braga and said, I will get you an answer later tonight. And I gave these communications as I had relevant data to share. So that's covering the Moss offer. The other thing that they saw about the 24-hour period, though, was they felt like there was that anxiety, and then they also sort of felt like, well, with the 24-hour expiration, it just doesn't seem like a very depth of sincerity. It's a self-limiting time, expiration on your own offer. So the next one is the Nut Trust offer, and I would like to submit that as a exhibit, if I may. Here we go again. Yes. Are we okay, ma'am? Oh, sorry.
All right. The document which begins lot land purchase and sale agreement by the Virgil E. Nutt Revocable Trust will be entered as exhibit number 13. And And the last page of what you have should be a page titled Confirmation of Agency Status.
Now, this is the Virgil Nutt Trust my daddy, who died in April 1st this year. He was trustee at the time. He was beneficiary at the time. I've been trustee since 2016 when he had his stroke. So, anyway, the Nut Trust offer is clearly superior than the other offers. It's for $155,000. It's cash. Doesn't have a fast closing. It was a little more like a 45-day closing. Okay. There were no contingencies, except for, not a contingency of any kind. The buyer requested that he be able to survey the farm at his expense to mark the property lines. You'll see that in the special stipulations area. That was the only request that we be able to do that before closing, which is another reason why we had a longer closing date, because I wanted to give the surveyor time to give me a good meets and bounds description for the deed. And so that was the only thing I asked to be allowed to do for that. Now, somebody says that this was an unfair competition. This was not an unfair competition. Not at all. The fact of the matter is that I applied as much soft pressure to both those buyers to give me 150 clean, and had just come to the conclusion that I was sitting there looking at those offers, and I was like, okay, how are we going to present these? We got to summarize these, present these. Kind of hard to give advice on them, because on the one hand, you would probably rank the timber buyer's offer a little better. At least it's contingent on a survey, but he's willing to pay for it. And then if he doesn't want to close, he doesn't close. But you hate to see a market participant start spending money like that on your seller's property, and then because I would tell him right off, well, if you don't want it for 150, forget it, because I'm going to get the seller's 150. I've made that very clear to everyone I talk to, that the sellers, they told me they needed 150. They were making those kinds of decisions in their lives, and I was bound and determined to get it for them. Now, I fell in love with the sellers long before I fell in love with the farm. The sellers were real good people, and they had told me all kinds of memories that they had about the farm, but I was focused on being the listing agent. I was happy that night. I just knew for sure that offer was going to come in clean. That's what I was telling Justin. I said, Justin, this farm's fixing to sell. You're going to lose it. And if you want it, you better accept the seller's counter offer for 150 and take it. And he said, well, I can't, I'm not comfortable with doing that with the survey, and the acreage discrepancy. So, and potentially, I think that maybe the Mosses, that was a concern for them too, was that survey and the cost of the survey and getting a survey done. And so the fact of the matter is that neither of these parties were steered, manipulated. There was no type of, intentional delay to try to, orchestrate things for myself. The fact of the matter is that I bought my sellers problems. I'm 2 years into a lawsuit solving external obsolescence. I still don't have it resolved. And the lawyer gave me an estimate of 3 months. And I'm paying 8% on money, too. So we've had to do that. But the Nut Trust buys on a particular criteria. We don't buy things just because we like them. The math has to work for us too. And it's this, we're not much different than the timber buyer, but we can be a little bit more flexible on the math because we're more creative as marketers. So the trust criteria is simply this, is that if a property will pay for itself in 10 years, the nuts are usually a yes. And we have a reputation for buying property in the area. Oftentimes, it never comes to this. We usually go to the listing appointment and say, sell it or list it. We're wholesale buyers. We'll give you this. We think we can get you this, But if you want to sell it to us for that, this is what we're willing to do. All that's done. We usually do that right up front. If we have an interest in the property, we'll just let the seller know right now. In this case, I didn't have the time for that. Dad was sick. And my mom also has Alzheimer's. It's that stage of life where you're taking care of parents. But the fact of the matter is that I didn't have the time to go out there and just walk that farm. If you've seen the video of the road, you'd know. That road was in bad shape. Every time I went out there, I was filling the back of the vehicle up with riprap so I could fill in the ruts in the road. And so I bought my seller's problems, but I also bought a beautiful piece of land. I mean, it's a beautiful piece of land. The Mosses are right. I mean, it's a beautiful piece of land. And I didn't know how beautiful it was until I took that time to walk it with them. Just like I told them, I said, I haven't had time to walk the lines yet. I've been working this road, trying to get it where I could show it. You can't sell it if you can't show it, Daddy said. And so I've been working on the road, happy to be the listing agent, and thought I had that farm sold that day. Wasn't thinking about buying the farm at all. Sold it, going home, happy about it, just knew that offer was coming in. Couldn't get the timber buyer to accept the seller's counter. That would have sealed it. But he wasn't comfortable with it. And then this offer came in, and the sellers didn't like it. I mean, they ranked it, below the timber buyer's offer. And they just simply didn't like that offer. They didn't like the anxiety that came with it that day. The pound on the table, please give us an answer. And, the $2,000 thing, that was just really, that was the thing that really got Mrs. Seller. She did that every time somebody asked for something. It was just something but I put my hand over that on the paper and I said, don't you worry about that. I can get them to buy. I can get them to remove that. I said, all we got to do is tell them about this acreage discrepancy and see how they feel about it. And that's exactly the way I showed it to the sellers before they even seen my offer yet. I presented the offers in this order. The timber buyer came first. His offer was first. Their offer came in next. Their offer was presented next. Mine was sitting there in my folder, and I'm reading the room with these guys. And I already knew what their reaction was going to be to the Moss's offer, but I tried to assuage it the best I could and convince them to make a counter to them. The only thing that I told them was this, is that if you're going to counter, you can't really accept the timber buyer's offer and counter the Moss's, right? If you take this timber buyer's offer and he's going to spend his money on a survey, you sort of need to take your property off the market until he's done with that, right? Because you're engaging with him in a contract, so in other words, it goes in pending status until that contingency is removed. So that was the way that offer got explained. And then this offer here, I just said, oh, don't worry about that $2,000. I can get them to drop that. I said, all we have to do is tell them about the acreage discrepancy and see how they feel about that. But the sellers weren't interested in it. They ranked the timber buyer's offer better, and you couldn't counter them both back. If you were going to do with the timber buyer thing, you were going to have to put it in pending status. So then I said, well, I do have another offer to show you guys. And this time I put my hand over the name. I didn't, and I just showed them the terms. I said, okay, these are the terms. It's 155, just what you see there. And they liked the offer, and of course they liked the offer. It was what they wanted. I just gave the sellers what they wanted. No, I couldn't get anybody else to do it. So they said they liked it, and I said, well, if you want to accept this offer comes with a great deal of disclosure and explanation, because the identity of the buyer is Virgil E. Nutt Revocable Trust. And, they kind of did that, oh, okay, type of thing. And then I explained to them what my role was as trustee, how that the decision to buy the farm had to make sense, how that I was going to have to cut some timber, and I knew they didn't like the idea of cutting timber. But I told them all that. I said, look, I'm going to have to cut some timber on that farm. And we're going to have to do some other things, creative things to, like hunting leases and things like that, to try to get this farm to pay for itself in 10 years. Otherwise, our trust won't be interested in it. And so I explained my responsibilities as trustee to the trust, and then I explained my responsibilities as an agent. I said, now look, you can't, up until now, I've been fighting for you, all the way. I said, but now that, I'm the buyer, I can't honestly say that I'm representing your interest and mine. So I explained to them in the confirmation of agency status, I said, what the law requires us to do is to be facilitators in this case, not having loyalty to either party. And so all of that was explained to the sellers that night. And so that is the handling of the offers. All right. Now, the facilitator status was clearly disclosed. The buyer interest, you can see these documents for yourself. And
Okay, so personal interest solicitor's agent, and then disclosures built in the contract itself with regard to the trustee as the buyer, okay? So communications with the buyers, we've talked about those already. You've seen those text messages to Justin. Now, there was a consistent message to both of the prospective buyers, and I wasn't interested in buying the farm at that time. I was only interested in selling it to one of them. When I saw that neither one of them had offers that one of the sellers that the sellers wanted, I sort of got frustrated. And I said, it's a real beautiful farm. And, it's like, I don't know why these people aren't willing to take the risk. And then I had to ask myself the question. I said, well, are you willing to take the risk? If you think it's that good of a property, then maybe you should consider giving the sellers what they want. Now, there was no misuse of information, and the respondent did not use information in the other offers to gain a competitive advantage. That's not the case at all. I actually considered, I said, well, they'll probably take 150 clean. And I said, well, yeah, but that may be true, but I was also wondering, if we were too low on it, considering, the level of interest we were getting. And then I also wanted to make sure that my offer sent the message that I put the seller's interest ahead of my own. Okay? So that was the motivation for adding the extra $5,000. It wasn't just to, just kind of blow everybody out. It was a matter of, hey, I don't want to just be the listing agent that comes in there and says, okay, I'm going to give the 150. I'm going to get it as cheap as I possibly can. Because they would have took it. They probably would have took the 150 clean. I said, you know what? Under these circumstances, I need to make sure that I'm putting the seller's interest first, so I put an extra $5,000 on there. All right, so inside man, the seller hired the respondent to be the insider. This inside man, insider trading stuff, it might be okay for securities licenses, but it's not. The real estate business is designed to have an inside man. That's what you're hired to do as a listing agent, to be that guy. And of course, you have the obligation to loyalty and obedience and all those things. Never at any time did I go against my seller's interest. The law was followed. There was no misconduct, no steering, no concealment. All buyers were treated honestly and fairly. They got honest information. Their offers were presented fairly to the sellers. The sellers made business decisions. And agency law was fully complied with. You can see that in the documentation yourself. So now I want to talk about for a moment laws versus rules. This is where, things get, maybe a little hairy for me, but.
And, Your Honor, I'm going to object at this point. Based on the outline that was provided to me of the slideshow, it looks like Mr. Nutt is about to get into the purview of the commission. If he has additional information he wants to provide as to the facts of the matter, that is one thing, but instructing them on the law or the rules is going over the bounds of what he should be permitted to do.
At this time, I'm going to leave that objection open. It's a hair premature still without having heard what Mr. Nutt intends to say. So Mr. Nutt, I'm going to leave Ms. Cooper's objection open. I will be mindful of it, and I may interrupt
Okay.
with some instruction.
I understand. Yes, I get it. I know it's sensitive. Well, the one thing I wanted the commissioners to know is that I did look these things up, and I understand that our charter, the charter for TREC is good. I mean, it's a good charter. Consumer protections, number one. Promoting public trust, number two. Establishing and administrating licensing requirements, number three. And enforcing laws and rules, number four. And I know that I need to submit to those rules and understand that. Now, this is probably where she's going to object, but because I made this point before this hearing, but and I'm not trying to be disrespectful. The rules of the commission are wonderful. They're given to us to assist us and lead us and guide us. They're to be the light into our path and the boundaries into our path to make sure that we follow the law. And they are created under law
and under the charter. But the rules of the Real Estate Commission are, while they are enforceable by law, they do not carry the full force of law.
And
I will, at this time, I'm going to revisit Ms. Cooper's standing objection, and I will note for the commission that I will charge you with what the law is in this case and how rules and statutes will operate together, but ultimately, you will make the ultimate determination as to what the rules say, what the statutes say, how they work together, and whether or not there's been a violation as charged in the notice of charges. So with that, with the last statement of Mr. Nutt, I'll ask you to disregard. At this time, I will sustain Ms. Cooper's objection. Now, the reason why I left that objection open is because everything before that last statement was fine. And certainly, Mr. Nutt, you are entitled to talk about your understanding of what you believe the rules are, insofar as that goes to your state as to whether or not you were attempting to stay on the right side of the line. But in terms of telling the commission or making an argument to the commission about how the rules interact with statute and the weight and how we tier those, that's simply not your
All right.
purview. It's not Ms.
Is that
Cooper's purview.
I'm certainly not
It's going to be what I
qualified.
charge them. So,
Okay, all right,
thank you.
very well. So I'll move on then. The only argument that I was going to make was simply this, is that I already told you guys about the confusion and I've already confessed that I'm guilty. I already confessed I was guilty. I asked for grace and mercy. You guys talked about it. And so I'm not saying that I'm not guilty. I'm only saying this is that 32 years, no slip-ups, no complaints of any kind in 32 years, and I'd like to keep it that way. I care about my license being right, but I did mess up. I mean, I'm not saying I didn't. I was just making the point that it might qualify for what's called excusable neglect, and she may object to that.
Mr. Nutt.
I can't say that.
No, not saying that. You made a statement in that I want to make sure that since you are pro se, you understand.
Yes, sir.
I'm going to charge the board in this case that because this case is de novo, everything that occurred or that the board heard, the commission heard in the prior settings of this case when we had our motion hearing and talked about the things that happened before, none of that is going to be before them unless it is re-brought to their attention.
I got you.
So when you made your statement about things that were said and explained at the prior hearing, I want to be as clear as I can that because this is de novo.
We don't talk about that.
No, they don't know it yet.
Okay.
So if it is something that you want to bring to their attention and have them consider, you're going to have to re-say it or recount it. So I'm not saying Ms. Cooper may object to it, she may not.
Right.
But I want to make sure that you're not operating under the belief that things that happened in June or July or that were explained to them or arguments that were advanced to them at that time, they're not before them right now.
Okay. So we're clean slate
You were
type.
clean slate. You can certainly try
Okay.
to get it in front of them again, and depending on an objection, I'll rule on that accordingly. But I just want to make it clear for the record that anything that happened before is completely clean slate, and if you want them to think about something, you've got to tell them.
Well, there was this Ferris parable portion.
And, Your Honor, I would object to that.
Okay, I was trying to
I can't rule on that objection. I have no idea
what I'm talking about.
what the discussion is on that. I'll certainly hear the objection, but
Well,
I'm a little in the dark about what the Ferris parable
it's okay.
is in this case.
All right, understood. I will honor my.
All right, if the question, if that's withdrawn, then I won't rule on an objection.
Okay. So I guess what I'd like to do then instead is maybe just talk a little bit about conflicts of interest and whether or not, did I have a conflict of interest with Mr. Moss? No, I did not. Not in my view. In my view, competing interests are not conflicting interest, okay? Unless it's with your client. I mean, case in point, for example, if Miss Braga had shown the Mosses the farm and she fell in love with it and she wanted to make an offer on it, well, then she has a conflict with her client and she has a duty to disclose. Even though they have competing interests, because her client is her buyer's agent, she would have a conflict that would require disclosure. When you are in competing interests and the competing interests are not your client, it's my view that personal interest is not required. A personal interest disclosure is not required. It's my understanding of law, of the real estate law. I'm not a lawyer. Here, I say there is I'm just trying to let you know what my understanding is for my practice. Okay, this is the way I understand it in my practice.
And Your Honor, I'm going to object to any of this as to relevance. We're getting off far afield.
I'm going to overrule that objection. I think that his understanding can go to intent and could impact the ultimate sanction chosen by, if there is a sanction at all, chosen by the commission here. Certainly, it is not relevant for the purposes of whether or not there actually has been a violation of a rule, but his understanding and certainly the assertion that he is not a lawyer, I think, can go to issues that the board can consider regarding an appropriate sanction if there is ultimately determined to be a violation. So I respectfully overrule the objection. Please continue, Mr. Nutt.
We're just talking about conflict of interest, how to identify them, and what is the proper use of the personal interest disclosure. And what I've heard, and one of the reasons why I'm addressing it is because maybe one of the questions that was asked to Mr. Moss is whether or not I told him that I was interested in the farm. The fact of the matter is that when I was with him, I wasn't interested in the farm. I had personal feelings about the farm, but I didn't have personal interest. I differentiate between personal feelings and personal interest. You can be thinking all kinds of great thoughts about a property, but it's not personal interest until you sit down and start writing the offer up. If you're showing an open house and a couple comes through and they say, boy, I really would love to have this home, but you look at them and you say, well, sit down over here at the kitchen table and I can make your dream a reality. But they say, well, we're not ready to do that right now. What have they just done? They've expressed personal feelings, but they didn't express personal interest. Personal interest involves developing a strategy to acquire the property that results in an offer being presented to a party. So it's always been my understanding that personal interest disclosures, if I'm understanding the law right, they are used whenever a licensee enters into transaction documents with any other market participant. If you're entering into a transaction with any market participant at all, you have to use the personal interest disclosure and disclose that you're a licensee and what your role is in that particular transaction. That's the way my daddy taught me. And so, but to use a personal interest disclosure for a competing buyer or a prospective buyer, I think that would set a precedent that would just be, I think it would be difficult. I think it would make the business more difficult. And let me give you a case in point. Let's say that I sent over a personal interest disclosure form to Miss Braga that night. I said, I've got a personal interest in this property and I'm fixing to write an offer on it. And she says, well, what? Wait a minute. Cancel that first offer. We're going to put another offer in. And the offer comes back and it's $160. And I'm like, whoa, that's too high for me. So I decided to just back out. At the closing, Ms. Braga comes up to me and says, so how much was your offer? And I say, well, I mean, after I saw your buyer's offer, I mean, I was out, so I didn't make one. And she says, my buyer wanted to buy that property for $150,000 minus $2. and you sent over that personal interest disclosure form and manipulated him to change his offer. Now, I think at that point, I have given him grounds for a complaint. I manipulated his offer. I manipulated him off of what he really wanted to do with a personal interest disclosure to another buyer and a competing interest. And so, personally, I don't think that's a good use of the personal interest disclosure. I don't think we need to become, how do you say this, overly sensitive about conflicts unless they're legitimate. A legitimate conflict is a conflict that you have with your client, but you rarely end up in transaction documents with a competing interest. And of course, I can't even imagine a seller competing interest, but I suppose if you're listing a house and you own a house 2 houses down, that might be a competing interest that you might disclose to that party. But like I say, those are the rare cases where you have a buyer that has a buyer's agent, and if they fall in love with the property, that's a conflict. Because, I mean, you're representing a buyer, and you're supposed to be helping them buy something. You can't be interfering with that. But now, when you're operating for the seller, you don't owe any, the machinations of your head and your calculations and how you calculate your personal interest on your own listing, that's between you and the seller. That's not between you and prospective buyers. It's not for them to know. That would create an unfair competitive advantage for them. And it makes an unfair competitive advantage for licensees. I think the law makes it clear that licensees are allowed to participate and even encouraged to participate. Let's face it, salesmen sometimes buy their own sales pitch. And that's probably what happened here. I mean, I seem to like my sales pitch of that farm better than anybody else did. And so I just wanted to talk for a moment about that because I kind of felt like maybe there was that feeling that you're supposed to give a personal interest disclosure to a competing interest that is not your client. I don't see it that way, and maybe you guys can explain it to me if that's the case. So I think that it can cause problems with regard to, just confusing disclosure with, for example, competition suppression, confusing disclosure, in that way. I think it's just, I don't think it's the right thing to do. Maybe you guys would disagree. But I've always been taught that you use your personal interest disclosure. In fact, I read the law about this. I don't know if I'm allowed to say it, but it says that the personal interest does have to be made in writing, And so when personal interest is disclosed, I think the rules in the law are clear that it must be made in writing. And so usually they're made in writing when you're entering into a transaction. In fact, I believe it says to all parties to the transaction. Now, a lot of times we broad stroke when we go all parties, and then we kind of leave out to the transaction. But there's only 2 groups of people in a transaction. Transaction is a strong word. And there's sellers and they're buyers. Prospective buyers, they don't make it in that category until they get into a binding agreement, and then they become one of the 2 parties in the transaction with regard to personal interest disclosure. Now, all parties deserve honesty, fairness, no misleading, no steering, no misconduct, no misuse of, of data, no concealment. All market participants are owed that. We have to be, I'm honest to a fault. And that's like with my sellers. I said, look, now that we have this new information about the acreage disclosure, from now on, we have to let people know about it, So that's the kind of agent that I am. And I just think that it's dangerous to try to set a precedent where we're handing out personal interest disclosures like candy. Every time we, get a fine thought in our heads about a property, we have to disclose it to everybody we've ever talked to or everybody we ever showed it to. I fall in love with my sellers' farms all the time. I sell them. I'm in the real estate business, and I love farms. So I fall in love with farms all the time, but that doesn't mean I covet them and want them for myself. But I fall in love with them, and then that makes me a good salesman for them, and it makes me a good listing agent for my clients. But falling in love with a property is not covetousness, it's not greed. It doesn't, there's nothing evil about it. All right, we're not going to talk about that other stuff, Ms. Cooper. I'm going to pass on. I'm going to skip on the objections. Okay? And we're not
Your
gonna-
Honor, I'm not the person that he needs to be directing his comments to.
I'm not,
so I
I'm
would ask him
sorry,
to
I'm
stop.
not a lawyer, but I'm passing over some things that,
All right, let's move along.
all right. Now, I've already told you guys, I didn't do right when it came to sending back I should have sent back the failure to, I'm guilty on the failure to respond. Are we clear? I'm not even going to argue that. I'm guilty. And incidentally, if I didn't say it before, some of my email communications were a bad tone. They had a bad tone towards Ms. Cooper, and it shouldn't be that way. Okay? I should be better. I should be better than that. Okay? And so, like I say, when I'm honest to a fault, I confess my faults. I'm not afraid to do that. And I should have sent that. I should have sent you guys that response. So, but I'm still going to ask for forgiveness. I have to, because I want to keep my license clean. I want to keep my record clean. And I think I've been a good agent, and I just made a clerical mistake, and I was confused. Okay, so finally, again, I want to repeat that a dishonest man would sign a consent order and go back to work, mail in a check and go back to work. I can't do that. I can't sign a consent order that said I was dishonest. I wasn't dishonest. I told everybody the same message, and I told them the truth. And I told them how to buy the farm. This is what you need to do to buy the farm. Please buy it. So I'm not a dishonest person. I didn't lie to the Mosses. They didn't even accuse me of lying to them. They just didn't think it was fair that I could compete with them. All right. So my final appeal is that, look, 32 years of a spotless track record. I'd like to keep it that way. I apologize for the misunderstanding on the response. I know it was disrespectful, and I need to be more reverent and mindful of the commission and the rules and all that. There's just nothing else I can say about it. If we're going to promote public trust, I think listen, I'm okay. I understand you got to be fair with everybody, and you can't be gracious with one guy if, unless you're going to be gracious with all guys. So I understand that.
And Your Honor, at this point, I'm going to object to the fact that this isn't testimony. He is preaching and arguing, and this is a statements that are better left for his closing argument.
All right.
I'll sustain the objection, but I will note that you will have an opportunity to make those statements in closing argument, which, as Ms. Cooper noted, is the more appropriate place.
I had some other exhibits for Ms. Braga, but she didn't come, I guess. But anyway, the only point I was going to make about that is that, if Ms. Braga or somebody in her office had shown him that land, I'd still be out there working on the road. I wouldn't have known. I wouldn't have seen what he saw. And so that was the only thing I was going to bring up to Ms. Braga if she was here. But I'm just going to say that, boy, I mean, it sure would have been nice for the Mosses if I hadn't have seen that farm, because it sure was a pretty farm. And when I saw that nobody seemed to want to give my sellers what they wanted for it, I thought it was okay for me to do it. It's not like I didn't unfairly present those offers. I did fairly present them, and even held mine back until I saw what their reactions were to those offers. So it wasn't, I wasn't trying to interfere with market participants doing their thing, but at the same time, it's my understanding of the law, also my understanding, that the seller is duty-bound by law to present any and all offers on the subject property to the seller, no matter their content or source, and it needs to be done as soon as practicable. So in my view, the moment I decided that I had a personal interest, I had no choice but to present it. By law, I have to do that. So that's the end of my defense presentation.
All right, thank you, Mr. Nutt. Ms. Cooper, do you have any questions for Mr. Nutt?
I do.
All right, please go ahead.
Mr. Nutt, you did eventually, in March of 2024, a year after you received notice from the commission that this complaint had been opened, you did eventually submit a response to legal, to me. Is that correct?
Was it in May or was it March? Did you
It was
say Mar-
May.
Okay, May.
If I
Yeah.
misspoke, May of 2024.
Yes, that's what I remember.
Okay. And I want to direct you to, I believe it's what's previously been entered as exhibit number 11. I just want to make sure I have the timeline right here, sir. That would be the offer and counter offer from Mr. Stoltzfus.
Yes, ma'am.
Okay. And you would agree with me that this offer went in on, the initial offer went in on
17th.
March 17th, is that right?
Yes, ma'am.
Okay. You're saying that Mr. and Mrs. Tyson made one counteroffer,
Yes, ma'am.
and then there was another counteroffer, is that right?
Mr. Stoltzfus counteroffer coming back, which
Okay.
was presented that evening with the Mosses and my offer.
Okay, and you would agree with me that counteroffer number 1, sir, is not dated, is that right? I'm looking down here.
Yeah,
sir.
I'm just making sure I'm reading
Okay.
the right one. This was from the sellers to Justin. Yes, it looks like they failed to date it.
Okay. And so it's somewhere around March 17th, right?
It was, I could probably look up my records on when I emailed these things to him, if you wanted me to, but between the 17th and the 22nd, he had gotten a counter back, and then this counter was coming back at about the same time that the Moss's offer was coming in.
All right. So I want to get back to, you did eventually submit a response to this complaint in May of 2024, right?
Well, I submitted it to the AG within 4 days, but I sent it to you in May of 2024.
All right.
I think I tried to email it to you in November. I tried to forward you the AG's emails, but I'm not sure if they went through or not, because I did it twice and then I didn't get a response, so. I do, go ahead.
I'm going to hand you this document, sir. Do you recognize this?
Well, that looks like the Moss's complaint.
And, I'm going to go back here. Do you recognize this?
That looks like my response.
And it includes, your response, it looks like, is 1, 2, 3, 4 pages, along with documents from the AG's office.
Yes.
That you said you submitted to the AG's office back in 2023.
Yes, ma'am.
All right. Your Honor, at this time, if I could have that as the next exhibit.
No.
All right, that document will be entered into evidence as exhibit number 14. I do not. Thank you.
All right. Mr. Nutt, you spent some time in your narrative telling this commission that you were not covetous of this property, that you did everything above board and that you had no reason to act with dishonesty or in bad faith towards Mr. Moss. Is that correct?
Well, I didn't act in bad faith towards Mr. Moss in any way.
Well, it struck me in particular that you kept saying you weren't covetous of this property. You weren't.
I wasn't covetous of that property at the time that I was walking around with the Mosses. I loved the property. I said good things about the property. I expressed personal feelings about the property. But
Okay.
covetousness, that's a strong word.
Well, it's your word, sir, so I'm just.
Well, I'm just saying that I
making sure.
wasn't,
Let
though.
All right,
me-
let's
let me finish.
tone down the temperature a little bit.
It's,
All right, please ask your question, and let's see if we can't get past this little squabble over the word covetousness.
Mr. Nutt, you would agree with me that in your response down on the bottom of the page there, as we walked the property, I fell in love with the property,
I fall in love with properties all the time.
okay? And that every time I saw something wonderful, I would say, oh my goodness, I just sold the farm.
Absolutely. It was so, I was so enthusiastic.
So we would agree that so far that Mr. Moss's testimony that you kept saying, I've just sold the farm, I've just sold the farm, you would agree with that, right?
Yes, I was enthusiastic. I was.
Between the offer that Mr. Stoltzfus
Stoltzfus.
excuse me, made on March 17th, and when you showed the property to the Moss couple, the only thing that had changed in there regarding you and that property was that that was the first time that you had really had a chance to walk the property. Is that right?
In that depth, yes.
Okay. You spent 3 or 4 hours out there that day.
Yes, I
right?
did. Mm-hmm.
Going hither and yon.
I
right?
did. We tiptoed over trees, over running creeks.
Okay.
We were like just giddy as school kids out there.
And that when it came time to present the offers to your clients, direct you to on page 1, 2, 3 of your response, the first paragraph, top of the page,
I'm reading it.
I explained to my clients that the complainant spent time with me at the farm and their offer was a hard cash with a very fast closing.
Mm-hmm.
Move on to, when you presented your offer, sir, it was above asking price, which you knew because you had those 2 other offers in hand, correct?
Well, the asking price was $150. Everyone knew that.
But you knew that you were going to go in there and offer above asking price.
No, I did not. I didn't know I was going to offer anything until after I saw these offers come in.
So
Didn't
we-
have an interest in it. I had an interest in
All right,
selling
all
it.
right,
Hold on.
all right, let's make sure we're not talking over each other. Mr. Nutt, please finish the answer to your question, and then Ms. Cooper, please answer the next one, and I'll instruct both of you to please not talk over each other
Yeah.
for the benefit of our court reporter.
As already stated, I was perfectly happy to be the listing agent and work like crazy for these guys to buy the farm. I pressed them as hard as I could. I gave them exact instructions on what they needed to do, what the sellers wanted to see in an offer. And again, encouraged Mr. Stoltzfus to accept to reconsider his counteroffer and go back and accept the seller's counteroffer.
Which is all very interesting, but that wasn't my question. When you presented your offer to the sellers, you had the other 2 offers in hand, correct?
I did.
And you.
I'm the listing agent. I'm supposed to have them in my hands.
And you had already decided, because you were presenting your offer as well, what you were going to offer.
Well, of course, I decided what I was going to offer. Otherwise, I wouldn't be able to offer it.
And because you were presenting your offer in person, I want to go to the last sentence there. I also shared with my client all that was on my heart, including my future vision for the property, which I hope will stay in our family trust for generations.
Which is what I already explained to the commission, that I was going to select cut timber on the farm, and we were going to manage the farm in that way, and that we were going to be able to try to lease the hunting rights as long as we needed to, or find other creative ways to generate revenue so that we could meet our criteria for paying off the farm in 10 years, the farm paying for itself in 10 years. That's the criteria of the trust,
You
as
then-
stated.
You then go on in the next paragraph, again, talking about how you loved the farm more than the complainant, but you weren't covetous, is what you were saying.
Well, I love the farm more than the, oh, sorry.
Hold on, I don't think that Ms. Cooper got her question out there. I think that was just the first clause of it.
Go ahead.
That you say in your statement, and this is the statement that you submitted to the commission.
Yes.
In response to the complaint.
Mm-hmm.
That you just loved this farm more than the complainant.
According to my offer, yes.
Okay. And that,
Was he willing to give that?
sir, don't ask me questions. I'll ask you questions. You then go on to say, well, why didn't the complainant offer more initially?
Is that also in my response?
Yes, sir, it is.
Yes, okay, good.
Okay.
I think it's a good question.
All right, we're going to take a brief 2 or 3 minute recess, and then we will come back for continuation of cross-examination. If I could ask the board members to please take your recess outside, and everyone else, please take your recess inside. And Madam Court Reporter, I'm afraid that you will not get recess.
You all can exit out the door by Commissioner Tucker.
That's great, thank you. All right, let's get back on the record. Nobody talks but me for the next little bit. Whatever is going on stops. I try to conduct my hearings loosely at first because I feel like that is better at getting information before the board while maintaining a tone of the proceeding that is not adversarial. Clearly, we are starting to test that trend with this hearing. So for both of you, Ms. Cooper and Ms. Cooper and Mr. Nutt, for both of you, and this is not directed at one or the other, is directed equally at both of you. Let's keep it civil. Let's not argue with each other. Let's not crosstalk. Let's not get snippy. Let's lose tones, and let's avoid playing in the dirt. As we know in this case, when this sort of conduct happens in cases, and I was a litigator for a very long time on some of the most challenging cases that the state of Tennessee has to offer, you know, it was a lot easier when the parties got along. You know, we can take issues that would, you know, drive most people apart, litigate those in court, and leave on friendly terms because we know that, you know, this is a professional proceeding, and I expect that everyone try to be as professional as they can, because when this happens, neither one of you is looking good in front of the board. I can tell you they're not interested in hearing the sniping and the tone and the aggression. They want to hear the facts of this case, and that's what I'm going to give them. I hope I don't have to say this again. It only gets worse the next time that I have to send them out and waste time having this conversation. The next time is going to be worse. So please do the best you can. My patience with it is fairly exhausted at this point, so I won't be giving the leeway that I was before. Before, when things would happen or you two would communicate with each other instead of with me about things like objections, I let it go because it hadn't risen to a level where I felt like I needed to step in. I'm going to step in now because this just isn't working, and I'm not happy about it, and I don't think that the board is particularly interested in hearing. So with that, some advice: stick to the facts. Don't argue with each other. Try to avoid the use of adjectives and adverbs. As Mark Twain would say, they are usually unnecessary in your writing. They're fairly unnecessary in a hearing as well. Don't communicate with each other. Answer questions. Questions only go one way. Ms. Cooper asks the questions right now of Mr. Nutt. Mr. Nutt, you do not ask questions of Ms. Cooper. If she's asked you something that you do have a question about, you ask that question of me, and I'll jump in and I'll intercede at that point, and we'll see how it goes. But let's keep it just to the facts, just to questions and answering. Try to cut out some of the tone, and try not to get into a scrum with one another. With that, I'm going to take a recess myself to take a little break, and then we will come back on the record at 1:40 p.m. Central Time. Thank you all. We're recessed. All right, we are back on the record. Ms. Cooper, please continue your cross-examination of Mr. Nutt.
Let me have just a minute, I'm sorry. Of course. Mr. Nutt, after walking the property with the Moss couple, did you tell them about your interest in the property?
I didn't have an interest in the property at that time.
You didn't have an interest in the property on March 22nd.
Not at the time that I was with the Mosses.
When did you?
I was expecting the Mosses offer to come in 150 clean. I was kind of excited about it. I was very disappointed when it didn't.
When did you draft the offer to present to the sellers?
Well, it was after the other two offers came in. Doesn't make it wrong. It was actually part of the reason why. The other two offers came in, and it just wasn't what the sellers wanted, and that just meant we were starting over again. And now we have a acreage discrepancy on top of the already landlocked issue, and it just looked like maybe things were going to start going downhill from here, and that maybe the price was going to be dropping down here real soon. If a survey comes back short, if the Mosses aren't comfortable with an acreage discrepancy, this thing could go south. And I didn't want it to go south. I was committed to making sure I got the sellers their 150 or better. I was taking care of my sellers, ma'am.
Mr. Nutt, you would agree that making a counteroffer would have been one way to get higher from the buyers, potential buyers. Is that
Well,
right?
I've testified already about the counteroffer situation. The timber buyer's counteroffer, it had a contingency for a survey that he was willing to pay for, but if he wasn't happy with it, he didn't have to close. And then the Moss's offer, of course, it had the $2,000 price discount on the back page.
You would agree with me that no opportunity was given to the Mosses to make a counteroffer,
But
correct?
that wasn't my decision. That was the seller's decision.
That they were not given an opportunity to make a counter, correct?
That was the seller's decision, correct.
I don't have anything else.
All right. Mr. Chair, does the board have any questions for Mr. Nutt?
I would like to start and ask questions, yes, please. So based on the exhibits that we received and the dates contained therein, I'm looking at the counters for Mr. Stolfus, the timber buyer, and the Moss's offer. And I note the dates on both of those that they were rejected was March of 2023. Then I look at your offer, and I see that your offer was accepted on March 22nd.
Does it have 22nd written on it?
Yes. So I'm curious as to how,
I don't really know, but I can tell you for sure that those offers were presented at the same time. It looks like on my documents, I've got problems with dates.
well, that's a
Yeah.
huge problem, sir. I also note that, you know, the lack of noting the time the documents were signed. And I don't know about you, sir, and what your daddy taught you, but the broker that I worked with said no blank spaces on our documents.
No what?
No blank spaces on our documents. You fill it out completely. So the lack of noting the time these documents were signed and the dates seem to be out of whack about this, that's a huge concern for me. And I also want to know if these offers and the counter offers were all signed on the 23rd, that means the Moss offer and the Stolfus offer was still alive when your offer was considered.
But
I
that's
wanted
not
to
the-
know. I wanted to know if you had disclosed a multiple offer situation to the clients to have them, to give them a chance to offer a counter offer or a highest and best offer.
Yeah, listen, I'm not happy about what you just told me about the dates, but I can assure you that, and you're welcome to ask the sellers or if you want to, or, but I can tell you this for sure. All three of those offers were presented at the same time. If we got some dates mixed up, then we got dates mixed up. I mean, the offers were written up on the 22nd. They weren't presented until the 23rd. So I mean, I have to look at the dates on my offer. Were they pre-typed or were they handwritten or?
Well, your exhibits, sir, that I'm looking at that you
I
submit to
understand.
me, is they're handwritten dates and they look like wet signatures. They're not electronic signatures that would have
No,
a date stamp on them.
Everything was wet, yeah.
Okay, so they're handwritten sections, so that, to me, that's contemporaneous at the moment. So they signed those on the 23rd. Your offer says it was signed on the 22nd. So that's a huge concern for me, and it kind of tears the foundation out of your defense, in my mind. I don't know how other commissioners feel about it, but in my mind.
Well, I'll admit it's a bad piece of data, but I'm telling you
Well,
the truth.
it's more than a bad piece of data, sir.
Well,
This is
it's-
what you wrote. This is what you wrote. I'm not here to argue with you, sir. You
Yes,
had
sir,
you
I-
had your time to present your case. This is our time now.
Yes, sir.
I will note, I don't enjoy jumping in on board questioning, but it is a time for board questioning and not
Yes, sir.
board, and not board deliberation or board
Yes, sir.
commentary on the facts of this case.
Thank you, Judge.
Thank you. And since this witness is likely to result in a number of questions, I think we are going to be better served rather than having each commissioner bounce back and forth questions and keep having to introduce themselves on the record. Perhaps seriatim might be a better way to go. Start with the chair's questions, then move on to one individual commissioner to exhaust their questions, and then move down the line.
Yes, sir. Thank you.
May I?
You'll have an opportunity during rebuttal to present any additions you might like to your narrative, but this time we'll wait for the board to ask the next question.
That's all the questions I have. Commissioner Smith.
Thank you, Chairman. How long was the property on the market before you started receiving offers?
I can't remember the very first offer I got, but probably 15 days maybe.
Okay.
But
Is the property listed now for sale?
no, it is not.
Was it ever listed after
It
you?
was never relisted.
It's never
Only the timber rights. I listed the timber rights for sale because I wanted to start getting loggers talking to me. And so I listed the timber rights to try to start collecting data about trying to get loggers to cruise my farm. Because that's going to be the next step once I got an easement, for that. And that was another thing I wanted to talk to loggers about, was whether or not I could, what kind of easements they needed and so forth. So that's why I relisted the timber rights.
Okay, thank you.
And that's verifiable in MLS.
One more question.
Verifiable, tell me what is verifiable.
In other words, if you, well, I mean, I can go into, I don't know if you can, but I can go into MLS and look at my historical data and provide you that document. So you can see exactly what it was, and I'm glad to be transparent about it. I can give you a screenshot of all my, data entries over the past couple of years. If you want to see them, I'll be happy to send them to you. But I only listed the timber rights to start gaining information about timber. And I still own the farm.
Okay.
Plan to own it for generations.
And this question may be out of line, Judge. If it is, stop me. Is it typical for you not to be as proactive if it's a short-term response in a contract?
I'm sorry, could you repeat the question?
If I can say it the same way, I'll try. Is it customary for you to feel like with a short response time, you wouldn't be as proactive, or
No,
do you think that's?
No, not at all. I just think that in my own personal interpretation of that type of a term, when you put a self-limitation that's that soon, I think it makes it difficult for a lot of people. I think it's, in a way, you're trying to lock that seller up for a non-competitive, 24-hour period. And I don't know that that's in the best interest of sellers to be put in that type of a predicament. But be that as it may, if I get an offer with a 24-hour period on it, I'm going to try to get it in front of the seller as fast as I can. I'm not going to hold up on it.
Thank you.
And I didn't in this case either.
Thank you.
Commissioner Moffett, any questions?
Yes. I understand, if I remember correctly in your testimony, you said one of the reasons you didn't call them back was because they were out of town.
No, I called the sellers.
But they were out of town.
The sellers were out of town.
When were they out of town?
That day, the day that I got the offer, I called them and they said, well, we're out of town with grandkids right now, and we have doctor's appointments tomorrow.
Then how could they sign?
It sounded like 9 o'clock at night.
22nd.
Let's let Mr. Moffett finish his.
Yes, sir.
All right. Well, it just seems strange to me that they're out of town and they signed this document on the 22nd.
Well, you're talking about my offer.
Yeah, right here.
Yes, sir, I see it, and I looked at it, and the mistake that I made was that I prepared the offer on the 22nd, and I was, in the software, and I typed it all in.
Oh, okay.
But if you'll look down below the signatures, you'll see a handwritten 3/23/23. That's where I acknowledge receipt of it, and I did it right there at the
My
time.
document they signed it on the 22nd.
It was pre-printed as the 22nd because that's the day I typed it in there, the day that I prepared the offer, but I didn't meet with them till the next day. And if you'll see
Well, it's in black and white.
it's typed in, yes, sir. When I prepared the offer,
To me, that's, if it says the 22nd, it was the 22nd.
well, I understand what you're saying as far as reading the document, and you're correct about that. And it's a mistake on my part.
Well, that's
But-
a big mistake.
Well, yes, sir, because I prepared
I think
it.
that's a little unethical, to tell you the truth.
It wasn't meant to be unethical. It was just
Well,
typed
it
up
may
that
not have
way.
been, but it was black and white.
It is black and white, but also is my hand signature underneath that says acknowledgement is 3/23/23, and that's handwritten.
Well, that's
And
on
that was done at the
that's
same
on another
time.
page.
This, on this page here, sir.
Huh?
The acknowledgement,
What you talking about?
the acknowledgement. See the acknowledgement there? That's handwritten 3/23/23.
Well, mine doesn't have it. This is the one I'm talking about.
Okay, that's a different one, yeah. This is what he's talking
And I'm talking about the page before. The page before says, has your signature, their signatures on the 22nd.
Because I prepared the offers on the 22nd, and I used the typewriter to fill those in, and because at the time, I didn't know, when I was writing it up, I didn't know whether or not I'd be able to meet with them that day or the next day, but again, it is a clerical error on my part.
I'd say that's a real big clerical
I should have left those dates blank and filled them in by hand.
Yeah, that tells me that something went right.
Well, you guys are welcome to talk to the sellers if you'd like to.
No, I'm not gonna talk to them. I'm
Okay.
talking to you.
The 23rd is when this happened, all of it.
Yeah,
Any other questions, Mr. Moffett?
no, thank you.
Mr. Gwynn, any questions?
Speaking of the sellers, you've talked about them a lot in your testimony. I don't see anything from them, any affidavits or any
Well, I
any
didn't want to,
testimony.
I'm sorry.
So my question is, did you think about calling them as a witness, bringing some evidence about communication that you had between them?
I did,
Because all we have to go on is what you're telling us.
I understand. Well, I didn't, they're in their 80s. And one of the reasons why I bought the farm from them is so that nothing would come back on them. And they hired me to take care of this for them. And I wouldn't feel right, bothering them about it. And I didn't realize, of course, that, of course, I didn't go through my own paperwork and realize my own mistakes. But I didn't realize that I would need their testimony. So I didn't ask them to do anything, but I can. If the board would like to order me to, to get that, I don't mind doing it. And I'm also willing to sign under oath as well. This is a typing error, but the handwritten 32323 is in the acknowledgement.
So, getting back to the offers, let's assume we're talking about the timber guy and the Mosses. So you had two offers roughly at the same number. They had differences. One was acreage, the other was maybe a $2,000 survey cost that reduced it down to $148. But they were two different users. One was a timber guy, and one was a guy that wanted to build his house on the land. So if the timber guy was, if the sellers were saying to themselves, we don't want to take a bunch of trees down, that's not who you would go to if you were selling the land to a timber guy. Where you would go to a homeowner, the guy wants to build his home there, I would think. So was there any conversation you had with the sellers about that point, trying to, counter Mr. Moss because he was, let's say, a homeowner versus a timber guy who was going to cut all the timber?
The sellers told me that they didn't cut the timber. They said, we're not those kind of people. But the fact of the matter is that they didn't really balk at offers that were people that wanted to do that. Even me, when I told them, I said, look, I don't have any choice. I'm going to have to cut timber. They were still willing to sell it to me for that. So, I understand what you're saying, but and then that's why I say, that's why my response says I told them all that was on my heart, because any reservations they might have, I wanted them to have it, to tell me about it. So, like I say, I told them about my position as trustee. I told them that I had to be prudent. I had to find ways to make the farm pay for itself, and that was going to mean timber sales. And that if they weren't happy with that, they needed to let me know now.
Okay. One other thing I'm confused about, you handed out a document, this looks like it's a complaint with the Chancery Court. What was the purpose of handing this out?
Because I wanted you guys to see the external obsolescence that we were dealing with on the farm, and the difficulties that needed, in my view, someone with a good skill set to deal with.
So are you still dealing with it now?
I am. It's 2 years old now. Still active.
Okay. That's it. Thanks.
Commissioner Tucker, any questions?
Yes, I guess my question is, if you're working on behalf of the seller and you know that you have an offer outstanding that has not been countered, wouldn't you advise them to counter that offer and see what they did?
What I tried to do was I tried to get them to respond to each offer individually as it was presented, right? And so when they looked at the timber buyer's offer, it was 150, but he was the one bringing the acreage discrepancy, and I had to bring it to them too. I had to get on the website and draw it out and say, okay, look, this is what he's seeing, and it's real. And so you had that, like I told you before, it'd be very difficult to counter both of those. If you're going to counter the timber buyer and he's going to do a surveyor, survey, then you probably need to put it in pending status because that's a contingency until that contingency is removed. And so it wouldn't be prudent to counter both of them. And the sellers seem to show very little interest in the Moss's offer. They
And
just
why
weren't-
was that?
they didn't like any of the offers that came in that asked for something back. We had people ask for deeded easements and things like that. He mentioned the doctor that wanted, bike trails and stuff. So the sellers didn't want to spend any money or do anything. They just wanted to sell their deed for cash, and they wanted 100. They needed a minimum of 150. And it looked to me like this deal was about to start going south of that.
Commissioner Bagley, any questions?
So it is hard to counter two deals. Have you ever done a highest and best?
I have.
Okay. Do you find those difficult to do?
Well, if you no, but if you look at my communications with Mr. Stolzfus, he was at his limit. He was, from a perspective, he's wanting the. He started out at $1,800 an acre. If you look at his offer, and at 75 acres, that's 135. So that's where he started out, and I already with just one counter offer, I've got him up to the 150, contingent on a survey.
Yeah, but we're here because the Mosses didn't get their shot. And, I mean, that's who the complainant was. And, there's 3 people wanting to buy the property.
Mm-hmm.
So why not let them settle it? Why not let them
Well, there's
have
two
highest
people.
and best?
2 people if I'm out. If I'm out, then there's only 2.
But you're saying you're in.
I am
You were
in.
in.
I
So
have
that's
to-
3 people.
That's right.
Yeah.
And so I have to
let's
be.
just move on here real quick.
Yes, sir.
So you talk about duty to your client. okay?
Yes.
What do you think? Do you think getting them the highest possible price is a duty to the client?
Absolutely.
Okay. And who came up with the list price?
They did.
They did. They told you they needed 150.
Yes.
But you didn't think it was your duty to somehow get on the property and fall in love with it and realize it may be worth more.
Well, here's the thing. I saw enough of it to see, and I had to work hard to get back to it the first time. 1.2 miles of cutting down trees falling over and filling in ruts, and that road was in really bad shape. So that's what I was working on those first few weeks. I did get back there, like the Mosses said, and clear out enough of the trees that are laying on the ground and whatnot, so you could drive back to the pond area because that was the primary feature of the property. So I'd beaten a path back to that. But then every and this is March, it was rainy season, so every warm day I was going out there and trying to get the road in better shape because you get a little rain, you can't even go.
I guess my question is, the day that you walked the property, did the value of the property go up in your head?
Well, I did ask the other buyers, said, are we too low? Are me and my sellers too low at 150? That's the question, see? I did ask him that. I asked the seller that, so I was
But as a buyer, I would never tell you that.
As a buyer, you would never tell me that?
I'm trying to buy it as low as I can.
I'm sure. No, but anyway, all I'm saying is that for him, I said, you really should take the seller's counter offer at 150 because, hey, who knows, we could be too low on it, right? The question is, are me and the seller too low? That if you read those text messages at 150. But it's very difficult to put a value on a piece of property that's landlocked. It's very, very difficult to do that.
I understand. My question was, when you first saw the dilapidated house and the acreage that was easily accessible, and you decided you'd try it at 150 because that's what they said their minimum was.
Well, no, that's what they said they want. I said, well, what do you guys want to list this property at? Because it's a landlocked property.
Right. But you've said numerous times that they had to have 150.
Yeah, they
That was
told us.
their
Yeah, they
number.
told us.
That
They
was
said,
their number.
150, and we're not
My
taking.
question was, the day you walked it, in your mind, did it seem like it may be worth more than 150?
Maybe a little more, but not like a ton.
Should you have told your client, like, hey, I got to be honest, I walked this thing the other day and it's gorgeous, and
I did do
I might
that.
be able to get you a little bit more.
No, I didn't think that. I still don't believe that. In fact, I think that from there it was going south. This was the peak moment right here. Once that acreage discrepancy came in, okay, once that starts getting handled, in other words, someone comes up and starts surveying the property and the acreage does come up short, I think that was a risk to my clients, and I was concerned about that. I was concerned that the deal would go below 150 because of the acreage discrepancy that just came up. So even though the farm was beautiful, and I thought, wow, it's a really beautiful farm, maybe if it didn't have the problems that it had, maybe, but you're always dealing with maybes with a landlocked property, especially that far landlocked. So it's hard to gauge.
Well, the only
It's
thing
just
that-
a feeling, it's all, gut
Yeah.
feeling.
Oh, it's a feeling. And why I have a hard time swallowing that is, with all the discrepancies, the value in your mind went up 5,000.
And it went up 5,000, but I already told you that one of the reasons why I did that is because, number one, I thought I'm a creative marketer and I'm a creative guy that can find a way to get, some revenue streams out of there that a timber buyer alone maybe not be able to do. And so I felt like with my creative skill set that I could make the numbers work, provided I could solve the problems, and I haven't solved the problems. So, I mean, I'll be honest with you, maybe I gave too much. In fact, some of the neighbors are telling me that. I've had neighbors call me and say, would you come look at my land? It fronts on a road.
Yeah. I'm not naive. I mean, I'm sure there was a commission on there.
There was a commission.
So you're net way below 150.
I'm sorry?
You're probably net way below 150.
Well, I'm net below 150, that's
Right.
true.
So.
But I earned the commission, sir. I mean, that's
I'm not saying
income.
you didn't earn the commission. I'm
So,
just
I mean,
saying
that's
that
not a
the
discount
net
on the
amount.
price. I earned the commission as a licensee.
Okay, I'm good.
Commissioner Torbett.
I have a couple questions. So my first question is, did you advise your seller that they could counter with just the asking price without the payment for half the survey?
Yes, that was certainly an option. And that's why I was actually encouraging them to do that. I told them, I patted the paper and I said, I can get them to take that 2,000. I think I can get them to take that 2,000 back because I knew they loved the farm.
And they just
And then I
chose to
said, and
reject it.
then I said, but we will have to disclose the acreage thing. And they just decided they didn't want to do that. They were probably more leaning more towards the timber buyer simply because his offer was for 150 and he was willing to spend the money on the survey himself. And that would have resolved that problem for them at no cost. So those two, when you have those two offers there, like I say, I think maybe you guys would probably like to see, maybe we just counter them both back. But the timber buyer's already gotten a counter offer for 150. I was encouraging him to just reconsider his counter and take that.
Well, the timber guy is not here today, and I'm not really concerned about his offer.
Okay.
So in the offer that we have, it says, by request for seller to pay up to $2,000 maximum for half of the survey costs. The buyer would perform the survey after closing. So I don't see anything in this contract that shows a concern for how many acres were there. So you keep saying that you're concerned that it was going to go south. They've mentioned nothing in this contract.
No, because they don't know yet.
But we have a contract to go on here.
You
and we
do.
have buyers who don't seem to care.
Well, we
how
don't
many
know
acres.
that.
You don't know that because you did not counter.
I'm not the person that makes that decision, ma'am. I tried to encourage them. I said, listen, I can get them to take this 2,000 back, and all we have to do is disclose the acreage, and we can counter this back. I told them that
Why did you say we have to disclose the acreage?
because it's a material. What do you call it? It's material information. It's a real discrepancy. It's from the tax assessor's office. It's a 25%, almost 25% difference. 60 versus 75.
69 versus 75.
60 versus 75. I had it surveyed and it came out 69, but the tax map at the time, I think I emailed
So here's
it.
my other question about that. This says up to $2,000.
Mm-hmm.
So I don't know how much the survey was going to cost. The survey could have cost less than that. It could have cost $500.
Mm-hmm. But
just feel like
it sounded to me like they wanted. Sorry.
Let's please allow the
If
question to be
you
asked.
are representing the best interests of your client, which is the seller,
Yes.
and you have buyers who seem to really love the property.
Yes, but
And you don't give them an opportunity to counter offer, you don't know what they would have paid. Did they give you any indication of how high they were willing to go, the Mosses? Did they
No.
say, like, this is our ceiling?
their offer is what they said they was willing to do. And it's not my decision to counter that. I can't sign a counter offer. I can encourage it. I can give advice on how to do it. And I did that, but I can't sign the counter offer myself.
So
I can't
we
make
have-
my sellers do it.
We have only your word that you encourage them to counter. But we have documents showing that you made an offer in the process of that, which
Yes.
probably preempted them countering, because then they had a better offer. So,
But my offer was genuine. I put up earnest money and I closed. How could I
do you
not?
feel like that the Moss's offer was not genuine?
It was genuine, but my offer was also genuine, and it was superior. And it wasn't superior because I was trying to take advantage or steal the farm from the Mosses. I was actually willing to give that. Was I supposed to withhold that? Was I supposed to withhold my offer?
I have no more questions.
Okay, I want to go away from the transaction itself and how you interacted with Ms. Bragg. At some point, she did ask for verification from you that the offer had been presented. And that was in an email chain that was given to us, and there was no reply from you that was submitted. So I wanted to see if you did reply to her and
Well,
to
I-
give her dates and times as to when
I
the offer was
thought-
submitted.
I thought that giving them a signed response was proof that the sellers had seen their offer.
Okay,
What-
so that, and that's the,
what-
no,
what-
excuse
oh,
me, excuse me.
Yes, sir.
And that's the rejection of their offer that was dated on the 23rd.
Yes.
Okay. So that was, and if I could pull that up. So the way that's probably deliberative, so I'll go with that. Okay. When you were presenting these offers, I just want to understand the sequence. So the Timberman offer, that offer was the first offer you presented to them.
Mm-hmm. He was the
Okay.
first one.
First
yeah,
one.
yeah.
His came in on the 17th, the first initial offer, and then the counters followed after that about a week later.
Well, over that course of
Over the course of those
a
days.
few days, yes.
Okay, and then the Mosses came in after that.
Now, the Mosses came in about the same time his counter was coming back.
Okay, but it was presented to them after the Timberman.
At the same time, but yes, after. But simultaneously, but in the same sitting at the kitchen table.
So you're sitting at the kitchen table with the sellers, your clients,
Mm-hmm.
and in your folder or in your folio or somewhere within reach is your offer.
Mm-hmm.
Okay, so they say no to the Timberman, they say no to the Mosses, and then you reach into your briefcase and take out your offer.
And in the briefcase, it was sitting just like this.
But the point is that
Yes.
that's the moment you presented their offer, your offer to them.
Well, my offer was the third one drafted. So,
And the third one submitted after you show them the Timberman's counter that had come in
Mm-hmm.
and the Moss's initial offer.
yes.
Okay, so their initial offer was at 150, pending the survey, like Ms. Torbett asked you about. Mr. Moss testified that he didn't care about the survey. He sat over there and he said he didn't care about the acreage. He just
that
wanted
wasn't in his
a
offer.
survey.
But that's not what his offer said.
Well, I understand what his offer said.
That is what his offer.
His offer, I understand what his offer said. I understand what his offer said, but what he said on direct examination
not
was
understanding?
that he and his wife did not care about the acreage on the property. So your guess,
He didn't tell me that.
I understand.
Okay.
I understand.
Let's allow the chair to finish his question.
Well, and this is kind of the rub, sir.
Yes, ma'am. Yes, sir.
The Mosses never got an opportunity to counter because they didn't know that they didn't know that your buyer was considering multiple offers. You didn't disclose it to them that there were multiple offers on the total. We didn't.
Let's allow the chair to
Yes, sir.
finish asking the question.
You didn't disclose that there were multiple. We don't have documentation that there were multiple officers were disclosed, and it just seems. Anyway, that concludes my questioning. Do commissioners have any other follow-up questions that they want to ask at this time? Commissioner Torbett.
I'm gonna go back to the contract and what it says. And is it your belief that this contract was contingent upon a survey?
No, but it's my belief that that offer is not 150,000 clean.
But you keep saying
Could
that you
you-
were worried that the survey would tank the offer.
No, that's not what I said. I said that this new data of acreage discrepancy could lead to us finding out that there's a lot less acres there, and that's going to affect the value negatively.
But you have an offer in hand that
Yes.
makes no stipulation to that, and they want a survey after closing.
It's not my offer. I mean, it's not my decision to make, but I understand what you're saying.
Well, it also depends on how this might have been presented to your seller. Because the way that you're portraying it to us is that the survey was going to make a big difference. And this contract says that the survey would be performed after closing. So they just wanted some help covering the cost of the survey. And it also seems as if that wasn't a sticking point. So
Yes, ma'am, but they were
I
lacking
guess
information.
My question is, why do you keep presenting this as if that survey was going to cause a problem for this contract?
I didn't, that's not the point that I'm trying to make. The point that I'm trying to make is that a new piece of data has come up just that day of an acreage discrepancy that I have not yet disclosed to the Mosses. The Mosses think they looked at 75 acres. I don't have any idea what their thoughts are about it, what they care about surveys or how much acreage is. I don't know. We didn't talk about that. We talked about them looking at 75 acres, and that's what they believed they looked at.
So what is this new piece of data?
So the new piece of data was coming in from the timber buyer who said, and you can see it in the text messages there, he said that'd be a good price if it was 75 acres. He said, but I don't think it's there.
So you consider a text from the timberman
No,
a new piece of data?
I went home that afternoon and got on the Tennessee Assessment website and used the measurement tool that they have and verified it for myself and took that addendum to the sellers to show them that evening. Because the sellers also believe that they have 75 acres.
Mr. Bagley?
And you didn't do that before you listed the property?
I didn't have time to do that right away. Listen, we build work files as we can. I pulled the tax card, I pulled the deed, all those, pertinent information. I didn't bother to verify the acreage, sir.
I have another question off Jeff's thing. It was just that you had some, as early as March 22nd at 2 p.m., the Elisa Braga had sent you a message about they were sending you an offer over and that kind of thing, right? So did you ever mention to her, like, hey, heads up, they're out of town, grandkids, doctor's appointment, going to be a little bit, but there are multiple offers on the table? Did you ever tell the other agent? Would you want that courtesy if you were in her shoes?
I don't know that I would. I know this, that, sometimes agents ask that question, but I don't know that we're, duty-bound to disclose it. I just don't, but I did, however, tell the Mosses that there were multiple parties interested. If you think I should have told, how would that change anything? He was asked, I think, by one of the commissioners, that if you had known there were other offers, would you have changed your offer? And he said no. So I don't know that these disclosures were. I don't know if they make people move the needle very much. It may cause some urgency, but I guess you don't know if you don't do it, right?
I don't know if they move the needle either, but I do know we wouldn't be sitting here wondering.
Maybe
because you gave them the opportunity.
Well, I wasn't trying to keep them from having an opportunity. I took their offer and presented it as best I could. I was disappointed when I saw it.
So I guess I'll follow up a question. So at some point I've heard some statements about the the 70 acres, 75 acres versus some number in the 60s for acreage. At some point, did you determine what the acreage of the lot is?
After I entered into the contract with him, I had it surveyed before closing.
Okay, so you had no knowledge? of
I
the
had no
exact
knowledge myself. No, I took the risk.
Okay, thank you. Commissioners have any other questions for Mr. Nutt? Hearing none, Judge, Commissioner Gwen, go ahead.
I didn't see anything in the contract about commission. You had a separate commission agreement
I
with
do.
the sellers?
Yes.
What was the rate?
10%.
Okay. When the deed was recorded, how did you arrive at the 162.5?
I knew you. You're good. You catch stuff. All right, I like you. The contract price was $155.
Right.
I had $2,500 in lending costs. I had $2,500 in survey costs, and I had $2,500 in legal expenses to start the lawsuit for the easements. So my total basis was $162.5, and that's what I applied to and paid transfer tax on.
So the sellers paid the commission. They paid a gross, you paid them a gross number, and then they paid you 10%.
That's my commission.
Right, okay.
And that's what we charge for tough tracks like that. We've always been able to get that.
All right, thanks.
Any other questions for Mr. Nutt? Judge, I was going to ask, would it be appropriate for commissioners to ask questions of the state if we have them?
I will allow an opportunity to engage with both the state and Mr. Nutt again after closing arguments.
Thank you, sir. With that, I think this part of questioning is concluded. Your Honor.
Excellent. Thank you. Thank you, Chair. Mr. Nutt, any additional rebuttal testimony that you would like to give?
No, I don't have any rebuttal I mean, I've already told you guys the truth, the best I can and tried to answer your questions. I receive your constructive criticism.
All right. Thank you, Mr. Nutt. Ms. Cooper, any witnesses you'd like to call?
No, sir.
All right. Then we will move to closing arguments. At this time, I am going to, since it is 2:20 and I've got to charge the board, and then we've got to deliberate, and then we've got to come up with an order. We will do closing arguments, but I'm going to put those arguments on a leash. The leash is going to be 7.5 minutes apiece, after which the board may ask questions of you for anything they would like further clarification about. Ms. Cooper, you have the ultimate burden in this case, so you will go second. And Mr. Nutt, you may present your closing argument now. And once you start, I'll start the clock.
I'm just going to go back to this. I'm not a dishonest broker. I'm not a swindler. I'm an honest broker. I was honest with the sellers. I was honest with the Mosses. I was honest with the timber buyer. Did I, could I have made some strategy advice to the sellers differently? Possibly. But I don't think it would have been lawful or right for me to withhold my offer if it was sincere. I think that would have definitely been wrong. Whether or not I should have, let Ms. Braga know about it, I guess that's up for debate. I'm not sure that the law requires us to do that. It might be a good courtesy. But there wasn't any evil intent on my part. There may be some frustration on my part because I have been working hard on the farm, and I have been telling everybody the same thing. Nobody to date had been willing to pay the sellers what they wanted. And now, somehow, today, it looks like people are trying to convince me that if I had given the Mosses a second chance, they would have, maybe paid $155. I don't know that for sure. We won't ever know that, but I don't know that it's my fault. I suppose you could try to blame me for it if you want, but like I already told you how I presented that offer, and it wasn't in an adverse way. Like I say, I skipped right over the 24-hour thing. And I patted my hand. I couldn't not read the $2,000 discount they were asking for, but I patted my hand over it to try to simmer Miss Tyson down, and get her to, you know, be willing to entertain it, but she wasn't. And and I just don't see how I could not present my offer. I was willing to do it, but that doesn't mean that I wanted it beforehand. Let me put it to you this way. If I wanted it beforehand, why would I even take the appointment? Why would I bother? Why wouldn't I just say to Miss Braga, well, Miss Braga, I'm sorry you can't show the property today. You let me know when you can, and I'll give you showing instructions. And then rush over to the sellers and get an offer in before she could show it. But I didn't do that. I went out and met the fella. I spent 3.5, 4 hours with him because I wasn't interested in the farm until after that evening, after I saw the offers weren't good. I just knew it was sold. I said, man, I just know this, and the Mosses are going to come in. I thought, Stacy, that the Mosses were going to come in with 150. I thought they loved the farm that much. And he said himself, I asked him, was this your idea or is this Miss Braga's idea? And he says it was his idea to put that $2,000 in there. And I'm telling you the truth. I looked him right in the eye and I said, the sellers have rejected every offer where somebody asked him for something in return. I looked him straight in the eye right before he left. I told him that. And so when he brought that in, I was like, oh my word, you know. And I didn't know did he just not understand me or did he go back and get different advice from Miss Braga? Looked like from my questions, Miss Braga was the one on the 24-hour thing and he was the one on the $2,000 thing. But you would have to admit that you couldn't present that offer to your sellers as a full price offer. And you can try to encourage them to counter offer if you want. But it was a difficult situation. I guess it would have been better if I didn't have any personal interest. I guess, I shouldn't have personal interest, but I did have personal interest, and the law says I can't hold it to myself. I have to tell it right now. So that's what I did, and it was a sincere offer. It wasn't meant to, just blow everybody else out. It was meant to be respectful to the sellers and send the message that I put their interest ahead of my own. Because I think more than likely they would have taken 150 from me without any contingencies. Listen, I'm an honest broker. I wouldn't be here. If I was dishonest, I'd just write a check, send in a consent order, and go back to work. I've made some mistakes, and you guys have given me some good criticism. It's really good criticism on that 322. You got me there, but it was pre-typed, and you do see my handwritten 323 on the acknowledgement. That's when the offer was signed. It was on 323 when you see the acknowledgement there, handwritten. Listen, I'm just going to ask you guys for grace and forgiveness. I've heard some tough things today, and I'm expecting some bad news. But I'm going to ask you to please be gracious to me because I've never been in any kind of trouble before, and I don't really handle these situations very often in my little bitty market. So, but if you guys have some advice on how to handle it better next time, and I've heard some of that, but I don't know that any of it would have worked out with my sellers because the sellers do have a vote in it. So I'm an honest person. I certainly haven't tried to mislead any of you either. And everything you've asked me, I've tried to answer honestly as I can. And I just pray for a little grace and mercy, if you would, please.
Commissioners, any other follow-up questions for Mr. Nutt? Hearing none, Your Honor.
All right, Ms. Cooper, your closing argument now.
Members of the commission, I thank you for your attention here today. Thank you, Chairman Diaz. All of you, I thank you for your attention here today. This is an important matter, and it speaks right to the integrity and the purpose of the commission, is to uphold and enforce the integrity of all licensees. But in particular, it should be concerning that we have a principal broker here today that has argued to you that honesty and good faith to all parties should be a moving goalpost depending on their own personal interest in the property. I don't think that's how you all want to proceed here. And when I say here, I mean enforcement going forward. Allegation number one was that he didn't respond. He's admitted that he didn't respond repeatedly. So the heart of the issue here is whether or not Mr. Nutt treated Mr. and Mrs. Moss fairly, decently, and with honesty and good faith. Mr. Nutt would have you believe that Mr. Moss was confused when he testified about whether or not there were other outstanding offers. He was not confused, I would submit to you. He said no. There were no other outstanding offers that day. I think it's pretty clear from the documentation you have in front of you, the timeline of events, what happened here, and that the actions of Mr. Nutt do deserve some sanctioning. And so I would ask you to do so. Thank you.
Thank you, Ms. Cooper. Mr. Chair, does the board have any questions for Ms. Cooper?
Commissioners, any questions for the state? Hearing none, back to you, Your Honor.
All right. Mr. Chair, does the board need any break before I charge?
Commissioners? I think we're satisfied to proceed, Your Honor.
All right, excellent. Thank you for that reminder. If it's 50-50, the matter's in equipoise, and the department would not have met its burden. Preponderance of the evidence is not the same as clear and convincing evidence or even beyond a reasonable doubt used in criminal proceedings. It just means the greater weight of the evidence, or that there is sufficient proven information that causes you to believe that the state's allegations are more likely true than not. You must limit your inquiry into violations of rules and statutes to those that were specifically alleged in the state's notice of charges, and you must base your determination solely on the evidence presented to you during this hearing. This is a de novo hearing, so the events and facts that were brought to your attention at earlier commission meetings, unless they were repeated again today, you cannot consider what has happened before, only what has happened at this hearing today. You must not infer from any of my rulings or instructions that I hold any view or opinion for or against any party. None of my remarks have been intended to indicate an opinion as to the facts or what your ultimate decision should be. If in these instructions I repeat myself or give the same direction multiple times, it's for clarity, not special emphasis. You're not to single out any certain sentence, individual point, or instruction and ignore the others, but instead to take all of my instructions together as one with equal importance. The order in which I give these instructions does not mean anything. It does not signify their relative importance. The evidence consists of the testimony given by the witnesses in this hearing and the exhibits introduced into evidence, which you may review during your deliberations. Statements and arguments by the party, so opening statements, closing arguments, and documents that are in the technical record, such as the notice of charges, and if there are proposed findings of facts and conclusions of law, which we'll get to later, all of those are not evidence. The evidence before you are these 14 exhibits and the testimony that you have received today. You can certainly use and talk about the opening statements and closing arguments and anything that you would like to in the notice of charges to assist you in making your findings of fact, but you do have to have things independently proved by the evidence in this proceeding. Any objection that I've made and asked you to disregard a statement, it was excluded because it was not legally admissible, and anything that I have excluded from evidence, you must assume has no value to you in reaching your decision. You must make your findings of fact based solely on the evidence presented to you at this hearing. There are two kinds of evidence, direct and circumstantial. Direct evidence is direct proof of a fact, such as testimony of a witness about what the witness personally observed. Circumstantial evidence is indirect evidence that gives you clues about what happened. Circumstantial evidence is proof of a fact or a group of facts that cause you to conclude that another fact exists. It is for you to decide whether a fact has been proved by circumstantial evidence. You can weigh them. You can weigh direct evidence and circumstantial evidence the same. You can pick one to give more credit to or not. But if you base your decision upon circumstantial evidence, you must be convinced that the conclusion you reach is more probable than any other explanation. If you need some examples of direct versus circumstantial evidence, I will be happy to provide them upon request. You are the sole and exclusive judges of the credibility or believability of the witnesses who have testified in this case. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. If you need some examples, there are no fixed set of rules to use when assessing credibility, but I can give you examples of considerations that you might want to ask yourself if you need that. Just let me know. The law does presume that all witnesses who are sworn the oath will testify to the truth. If there is conflict in the testimony between witnesses or between witnesses and documentary evidence, it is the responsibility of the board to reconcile those conflicts if possible, or to determine which one is more credible and should be given the most weight. I will note that just because I have admitted evidence in this case, the law does not require you to accept as true all of the evidence I've admitted, even though it's legally competent. You have to make your own evaluation of the testimony of the witnesses and the documentary evidence and determine the degree of weight that you choose to give that testimony. I will note that for each of the charges, you must determine whether the alleged violation has been proved by preponderance of the evidence, and then you have to specify in the findings of fact portion of your order the specific underlying facts that support your decision. In making your determinations, it may be necessary for you to interpret your statutes and your rules. When the language of the statute or rule is plain, then you must follow the plain language of that statute or rule. However, if the language is ambiguous, you may give your interpretation so as to explain the conclusion you reach as to the violation charged. If in your deliberations you find that one of your statutes or rules is ambiguous and you are uncertain as to how to interpret it, please let me know and I will give you a more detailed charge on statutory construction, and I'm happy to do so. You are not required to set aside your common knowledge or expertise in the field of real estate. You may, and in fact should, weigh the evidence in light of your training and your own observations and experience. The state bears the burden of proof. Mr. Nutt does not have the burden of proving that he is innocent of the charges. In terms of your final orders, the Administrative Procedures Act requires orders to contain 4 sections: findings of fact, conclusions of law, a decision regarding what disciplinary action shall be taken, if any, and the policy reasons for your decision and determination. In your findings of fact, you must make your own evaluation of the testimony given by each of the witnesses and any documentary evidence admitted. You must then decide how much weight to give that testimony or evidence, and then you weigh that evidence in light of your own training and expertise, and then you find those facts. Once you've made your findings of fact, you must decide whether or not respondent's activity constitutes a violation of the rules or statutes as alleged in the notice of charges, and if so, you must state those determinations in your conclusions of law section. You must include sufficient analysis of the evidence to clearly demonstrate how the facts of this case support your conclusions. Your conclusions of law should make appropriate specific references to your findings of fact to articulate linkages and connections between the 2 sections of your final order. If you ultimately decide there's been a violation of state statute or rule as charged in the notice of charges, then you must decide what disciplinary action is appropriate in accordance with your legal authority in considering the particular circumstances of this case. You may consider any evidence that the parties have introduced on the issue of appropriate disciplinary action, including whether the conduct allegedly was or is of a continuing nature or a one-time offense. You can also consider what you've done in previous similar cases. You are not required under the law to have absolute consistency in the disciplinary action you take. However, this does not mean that you can be arbitrary and capricious in dealing out disciplinary actions. Disciplinary actions must be based on fairness and reason. Finally, policy reason must accompany your determination, and that states why the decision you render here is appropriate. It's your statement explaining why the disciplinary action you choose, if any, is correct, given the wide range of cases you hear and the various disciplinary options you have, and it tells the public and the reviewing courts why, even though each case is different, why, if you choose to make a disciplinary action in this case, why what you've done here is proper. The gravity of the violation, the harm to others, the respondent's attitude towards the action can be included in your policy statement. You can be anything that you want as to why the disciplinary action you've chosen, if any, is correct. I'll remind you, your deliberations must be audible in public before all parties. If you need assistance with the law or structure of the order, I will be available to assist you upon request. I don't like to put myself in the middle of deliberations unless I'm asked, but I'm happy to do so. It's inappropriate for the parties, their counsel, the witnesses, or any of your staff to participate in your deliberations. Any action that you take must pass by a majority vote of the panel. However, as you've noted earlier, Mr. Chair, if there is a tie, the action will fail. If there's a motion and it's a tie, it fails. If you have any questions about the facts presented, you may, by a majority vote, reopen the proof and hear further testimony from witnesses and/or argument from counsel. And at this time, does either party have any proposed findings of fact or conclusions of law to submit?
I do, yes, sir.
All right. If you could please publish those to Mr. Nutt, myself, and the board. I will note, board members, you are not bound by the party's proposed findings and conclusions. They are only submitted as a guideline as to what counsel thinks the proof has been shown. It is up to you to determine what has actually been proven in this matter. So basically, that proposed findings of fact is not gospel. It is designed to be an aid and to help and to assist you with the process. But everything that you find needs to be independently proven by the evidence here, because that does not bind you in any way as to the ultimate result in this hearing or any individual portion of your order. Unless there's anything from the parties that I need to address or questions from the board concerning my charge, I will now turn the hearing over to our chair to preside over deliberations, after which you will make findings of fact, reach conclusions of law, including a decision regarding whether any disciplinary action shall be taken, and if so, determine what disciplinary action shall be taken and give your policy reason for your decision. All yours.
Thank you, Your Honor. I just would like to update for the record that with the departure of Commissioner Ferris, we are now a 7-member body, so a majority vote will be 4 votes versus 3 votes, either for or against. And I will also note for the record that of the 7, 5 are practitioners and 2 are members of the public that do not hold a license. So that is the composition of the commission today. I think, I'm sorry, Your Honor, just say again, do we go immediately into addressing the deliberations on the charges?
Would you like to have a recess before you go into deliberations?
I don't need one.
We're
ready to go, sir.
You are welcome to jump right into deliberations.
Very good. All right. I will ask the commissioners, let's go ahead and deal with charge 1 of failure to respond within 10 days. It's my sense that Mr. Nutt has conceded that point to the commission and on the record, so I would think no further deliberations is necessary on our part or any further questions. So I think we can go ahead and begin deliberations then on the providing services to all parties with honesty and good faith according to Tennessee Code 6213-403, paragraph 4. Commissioners have any statements or anything they would like to say concerning that charge? Commissioner Smith.
Let me think just a second,
Okay, you want me to come back to you?
please.
Commissioner Moffett, do you have any comments or thoughts you would like to say in terms of dealing honestly and in good faith? Mr. Moffett, do you have anything you want to say? Do you have anything you want to say? Commissioner Gwynn? Your impression, sir.
Well, I mean, this is probably not handled properly, but the question, I mean, for a number of reasons. But the question is, does the evidence show that he acted in bad faith? Has the state proven the case? And I'm, troubled a little bit by what was happening between Mr. Nutt and the sellers. So we don't really know, other than what he's testified as, what was actually said between the two parties. Obviously, they drove the transaction to a degree, but we don't really know what sidebar comments were being made between the two of them in a very tight window of time, which, the 22nd, the 23rd, all this was happening, with three parties and the sellers, so actually four parties, and an agent for the Mosses that didn't show up. Okay, that's not a good thing in my view. So, I mean, I'm kind of wrestling with all those different things. I mean, I don't know how to ferret through all that. So I'm interested in everybody else's opinion as well.
For Commissioner Smith.
And I agree with you, Commissioner Gwynn. I think my concern is presenting the other two offers at the same time you're presenting, the respondent is presenting their personal offer. Timing feels a little awkward to me. And I understand, I'm rambling a little bit, so bear with me. I understand the respondent trying to get the seller's a closure. I get that. I'm not sure that it was handled in the most professional way. I would like to have seen the Mosses receive a counteroffer or highest and best offer. This is hindsight. But that's why we're here, because something happened that caused some discord. So as a practitioner for over 30 years and a practitioner for over 45 years, sometimes we don't make good, thorough decisions. So my hesitation here is I don't feel good about your offer being presented with the other two at the same time without giving the sellers the opportunity to ask for highest and best, and they may have gotten more than 155. We don't know the answer to that. So I'm just giving you my thoughts out loud.
Thank you. Commissioner Tucker, any thoughts?
I guess my thoughts are Mr. Nutt knew that the seller would take 150, but the offer was written for 155, which is more attractive than the other two offers, and he had knowledge of that. So I just think it was very unprofessional.
Commissioner Bagley, any thoughts?
Well, I agree. I mean, it just doesn't pass the smell test, but I don't think, I don't know that I agree with Steve also. I'm not sure that they've proved at 51%. that he did it and that we have proof that he was trying to be unethical, like I said, to me, it doesn't pass a smell test because there's too many things, it's, you talk about the survey just muddying the waters, but then the next statement, you said you were just so hopeful the Mosses were gonna bring in that 150 offer. So if they would have brought it, would you still muddy the waters?
No one gets to participate in a deliberation,
Yeah.
except for the board, and that includes
Yeah.
me, so I'll be quiet.
Okay, so, that stuff's just in there. Like I said, we'll see how this goes, but I think you're a smart guy, and I think you knew kind of what was going on.
Commissioner Torbett, any thoughts?
Just kind of echoing what's been said before, I don't feel like the seller was given the best opportunity to get the most money for their property. I don't feel like the potential buyer was given the best opportunity to purchase a property that they really liked. I think there's a lot that's been said that's kind of confused all of that, but when we go to the documents that we have contracts with missing times on them. We have contracts with dates that may or may not be accurate on them. We have the potential buyer's testimony that he was not informed that there were outstanding offers. I feel like there is enough evidence to show that we're not trying to prove something's ethical here. We're trying to prove that somebody used honesty and good faith. And when the end result is the agent bought the property and got what he at the time thought was probably a pretty good deal on the property after he saw it and loved it, made an offer the same day, I'm just not sure how that shows honesty and good faith. And we have another statute that, is not even on the table here about disclosing and things like that. So we're not even proving that. We're not even trying to prove whether or not he was supposed to disclose this, because that is 62-13-4037A, I think. That's not even on the table here. So we're talking about honesty and good faith. And as a public member, I want to know that my agent is going to fully disclose all of those things and not look at it as an opportunity to have inside knowledge on what the best offer is and immediately make a higher offer. It just, I don't like it. I mean, I don't know how else to say that, but I do feel like that I think we have enough evidence here with just documents that aren't done right. That's it.
Any other comments from the commissioners that they want to say on the record?
Well, I agree with everything it said. My brain was somewhere else when you answered the question.
Thank you, Commissioner Moffett. Commissioner Gwynn, something else?
I think one other comment, this may be just general, but I would have, my antenna would have gone up if I'd been showing a property and the agent who I'm supposedly going to split a commission with didn't even show up. And the fact that it was 3 hours away, I'm sorry. She should have made accommodations for that. And then not to be involved deeply in conversation about the contract. Again, maybe there's a failure on that agent's part. That's the way I would look at it. I'm sorry it happened to Mr. Moss, but it ended up being that there were 3 offers going at the same time, and that's when you really need an agent on your side and not be left. I mean, I'm not saying she left him totally out there, but by not even looking at the property, for one thing, is difficult. So.
I mean, I would say that if there was no disclosure of a multiple offer situation to her, Ms. Braga, then she's unaware that she's in a multiple offer situation and wasn't given the benefit of advising her clients accordingly.
But, you can sit there and say that, but maybe you should assume that there's it's not a bad practice to say, there may be somebody else out here that I don't know about.
Right.
So
I
we
mean,
gotta
maybe an
react
inquiry,
accordingly.
to
Yes.
Mr. Nutt to say, are we
Yes.
in a multiple offer situation?
Yes.
But her actions aren't at question today.
Right, I get that. I'm just making a comment. And the other thing is that if you look at the offers that were received, the Mosses was the only one with a split commission. The timber guy was out there with no broker, and obviously Mr. Nutt was out there with no broker, so.
Okay. Any other comments, statements regarding that second charge on honesty and good faith? Now, there's allegations about a rule as well that the state provides for us, violating one of our rules or a number of our rules. And I think they're all fairly related. If you would take a moment, Commissioners, to kind of look at them. And I'm looking at the notice of hearings and charges.
That's a good question. I'll be looking that up.
Commissioner Torba, go ahead, please.
So how do we define timely?
I think that's a very good question. My practice has been, over the course of transactions, that as soon as my client signs the document and I am able to provide a copy to my counterpart on the other side, I communicate it by email, and then follow up with a phone call and make sure he received it, or that my counterpart has received it, or in some way verify that they do have the offer in hand. Commissioners that practice, do you want to comment about your practice?
My practice is immediate. My practice is if I have an offer to submit to my, to my seller or a counteroffer to my buyer, I'm going to be emailing, I'm going to be calling that agent, I'm going to be calling that client or customer, and I'm going to be a little aggressive. It's not uncommon in my practice to put a 24-hour response for a couple of reasons. Is I want the seller to know that I'm sincere. I've got the money, I can write you a check, let's move on. So I guess I'm a little more aggressive in some ways, but my response is if I have one of those documents in hand, I want the other party to know immediately, even if it's 9 o'clock at night, 10 o'clock at night.
They said that was going to be my next question. Like, is it restricted to like typical business hours, or is it, you're shooting it off when you think they're
When I get an email.
watching their evening programs or whatever?
Excuse me for over-talking you. When I get a response, then I want a response immediately.
Now, I've had an occasion where I look at maybe an expiration date of an offer, and I look at it and I know, all right, I'm not going to be able to get a response within that time. I think there is an opportunity to amend an expiration of an offer if we think that's a circumstance we might run into.
And I think that's my point. If I know that my person that's going to answer can't answer in that time frame, then I'm going to let the other party know, hey, I can't get you an answer this quick. They're out of town. They're with children. They're with doctors, whatever it is. Will your client allow us to extend this another 24 hours? I think it's important, and this is a lesson we all learn, is keep the lines of communication open. When we don't communicate with one another, we end up with issues.
Is that helpful?
Yeah, it's helpful. It concerns me that it looks like the Moss's agent was having to continually ask for a response or confirmation that the offer was delivered. So, yeah.
Commissioner Bagley, how long has it been since you've done a real estate transaction, a residential real estate transaction for somebody else?
Not too long.
Not too long? Okay, I thought you had moved away from that part of the business, but,
I've moved away some, but I mean, I'm still pretty involved.
so what's been your practice in the
On
handling of the
timely?
paperwork on timeliness?
Well, my practice is if I have other deals going and it's going to look bad, I'm going to communicate. I just try to keep, if I want the reputation of I'm honest and I'm all this stuff, then I'm going to try to get that communication better than usual. And if there's stuff happening, then I'm watching that timeline a lot more. If there's no other offers and the client's like, well, I'm out of town, or, you know, then I just communicate that, not such a rush. But if there's other things happening, stuff's coming in and multiple offers, of course, we use a multiple offer form if we have multiple offers. And then, so, I mean, timely's as quick as you can get to it. I think timely is as fast as you can get to the client in a reasonable manner during business hours, if they want that, or maybe a little later.
So let me ask you this, when you're representing a seller and those offers are coming in, do you ever kind of, on a single email to all of your potential buyers, say, okay, hold on, we got a lot of paperwork coming across. Let me get things organized on my end. Let's make sure our offer expiration dates are lined up right so we can get you responses in a timely manner. Have you ever like kind of coached it or managed it like that?
I usually just talk to the seller and ask if I can just tell everybody it's multiple offers and when do they want to cut it off? So
Okay.
if there's multiple offers, then I respond back to everybody. I don't know
Okay.
if it's individually or blanket, but hey, we have multiple offers. Seller's giving you till 5 o'clock Friday.
All right, so for you, that expiration date's highest and best expiration time is set by the seller in your mind? And
Yes.
that information is communicated as quickly as
Yeah.
possible?
And sometimes, you know, the sellers knows from showing time that they've got 2 more showings tomorrow and it's only been on the market an hour and they don't want to, so they'll push it, like today, they might push it till Saturday or Sunday. And you might lose some buyers. They might get upset, but the thing is, I guess timely is with is tech as we are now, I can communicate instantly with my buyers and sellers unless it's a late hour or early morning. And that's something like, hey, I got it. I'll be calling you in the morning, you know, something. Everybody knows pretty quick what's going on.
Commissioner Tucker, any specific experience you want to talk about?
Just pretty much what Joan and this guy have said. So, you know, immediate, there's a time and a date on there for a reason. So everybody needs to make every effort whatsoever to communicate and make sure that is answered and negotiated within that date and time, so.
Commissioner Torbett?
I just would, I would have less questions and concerns about this had the Moss's offer either been allowed to expire or been countered or been rejected before Mr. Nutt presented his offer. And I think that's where I'm having the hardest time with honesty and good faith, because I feel like it prevented what could have been a better transaction. And we would have no way of knowing that now because it didn't happen. And I don't understand the urgency of why he wanted to present his offer before his seller had a chance to respond to the other offer. It just seems like very hasty, and it doesn't pass the smell test.
All right, does anybody want to offer any other comments? Commissioner Moffett?
Yeah, I agree with Stacy. But the one thing that really gets me is why no communications to the Mosses at all to tell them anything that was going on. You know, that's just crazy.
Well, that communication should have come from his agent, but it appears from our documentation that the communication wasn't going to his agent so he
Right.
could get a response.
Yeah. I mean, communication is a secret to any real estate game.
I use Transaction Desk, I'm sorry.
Go ahead, Commissioner Smith, go ahead.
I use Transaction Desk, Authentisign, I use those. I think it's important to always pull that little thing down there that says date and time and be sure it's date and time stamped, and then we wouldn't be looking at some of these so closely. You know, I could sign something today and date it a week ago. I don't know. You don't know when I signed it. So that bothers me a little bit. That we, as principal brokers managing an office, don't have a date and time written in or stamped in somewhere so that when you come to one of these situations, you don't have anything to back you up.
We'll also know that there's deference usually in these documents given to handwritten notations. Like when you're writing out the price and you say, rather than the numbers, and you write in $150,000, that if you write $180,000, the people are going to recognize the $180,000, not going to, not the 150. So that's why, so the Mr. Nutt's point about him acknowledging receipt of his own offer on the 23rd is well taken, but the typed dates up above just muddied the whole thing up, and it might, in my mind, I just think it's part of the reason why he's here today.
And
Go ahead, Commissioner Bagley.
sorry. And in where we have these three things happening in 24 hours, some times would have been really nice. We don't have a single time stamp. Nobody put a time on. I didn't see a time on any document.
The stuff we have for the logger guy, the dates are kind of all crazy on that, at least what I have. So he made an offer on March 17th, and then I couldn't find where the counter was, and then his response to the counter was on the 21st.
Let's look at it and see if we can.
Because was that,
13.
it's 11. Yeah. So this is dated the 17th, counter offer 1.
Is the 17th, but again, no dates by the signatures, but
No, and is there an offer before the counter offer?
it's this one right here. No, that's Mr. No, okay. What's the
This
offer
one.
say?
Well, his original offer was,
I couldn't find it.
his original offer was, and its date and time, on the 17th at 6:35.
Okay.
But I don't have a date on the counter. Excuse me, yes, on the counter. So then, on the first counter, I have it, counter offer number 1, but no date and time anywhere. And then on number 2, the purchaser has signed it on March the 21st, and it's March the 23rd when they rejected it.
And that's the Timberman's
Yeah.
That is
Stolfus.
Stoltz, okay.
Does that iron it out for you better, or?
I mean, not really.
Okay.
Not really.
But that's,
It's
I mean,
it's
that's,
just a lot that's up in the air because we don't have
yeah,
documentation.
okay.
But I also think if you're a buyer and you've been looking for property and you find property that you love and you're getting into a negotiation, so you know they won't accept anything below full price, so you offer full price with a, hey, could you help me on the survey after closing. It's not contingent on the closing. Who knows how far they would have escalated if it's their dream property?
Yeah.
I mean, they could have gone up. You have no idea how much they would have been willing to go up because it's hard to find the property that you love. So I feel like it's just not honesty and good faith to give them an opportunity to bring a better offer to the, like, there was no negotiation at all. And it sounds like it's because he didn't like the fact that they asked for a little bit of money towards the survey.
I would say to that, I have a buyer that an investment, he's an investor, so he buys a number of properties. And he has told me that I can tell folks when I make an initial offer that he is inviting negotiation. Like, he wants them to counter because he wants the negotiation. He likes the back and forth of it, which I think is crazy, but that's what he wants me to do. That's what I do. So, but I always think, I mean, like many of us as practitioners, we always expect a negotiation. We always expect a counter. We always love when the purchase order is over and they're like, yes, you're like, because we always expect the back and forth, and keeping those counter offers and the competing offers in their lanes and in line is always a difficult aspect of it. But we try to do.
I know it wasn't at the outset that the Mosses knew this, but if you look at it, you're saying they kind of walked into a deal where they're competing with the selling agent. I mean, it turned out that way. And so if I'm walking into a deal, I'm trying to buy land, and I know that the agent that's selling it, that's getting a 10% commission, is also going to bid on the property, he's a 10% head start on where I am or where I'm willing to go. That's not a good situation. I mean, I know it wasn't at the beginning, but it turned out that way.
Right. And, and we know circumstances change over the course of a deal. I mean, your confirmation of agency, that's why those documents exist.
Right.
You could always make a new one. If your agency status changes, in fact, you're required to make a new one if your agency status changes. And, if all of a sudden you are interested in a property and you want to buy it, there's a personal interest disclosure. There's also just, sending an email or some other way to memorialize it where they can say, I'm interested in buying this property now, and I'm in the mix. And maybe a different choice. Maybe you don't represent the seller anymore. Maybe you hand that off to somebody else. So it's just a number of different things that could have been done. And a lot of it is probably Mr. Nutt's been doing this for 32 years, so he's kind of, for lack of a better term, just accustomed to doing business a certain way, and maybe the novelty of this deal and the way it was playing out was just something that he didn't account for in his process and over the course of the transaction. So it's making mistakes, they can still be honest mistakes, and I don't think his concern about having an unblemished record is something that we give a lot of weight to. I wouldn't give a lot of weight to, but other commissioners might disagree. Any other? I said may disagree. Other? I don't give a lot of weight to the desire of an unblemished record. I think people make mistakes, and sometimes those mistakes, whether you meant to do it or not, they have consequences attached to them, and you don't get to shirk them because you say I'm sorry and it was an honest mistake. That's just me, but I know I don't get a lot of sympathy when I make a mistake. So, well, with most folks, my wife is a saint. Commissioners, we're starting to repeat ourselves a little bit, so I was just wondering, do commissioners have anything new to say or restate or anything like that? Commissioner Moffett, go ahead.
Well, the thing is, it all happened within one day. Just really drives me crazy. That means it doesn't meet the smell test. It just doesn't. If he'd have bought the property a month later or 2 months later, that's one thing. But he bought the property. All this stuff is the same day. Weird.
All right, any other need for deliberation? Any other comments? Okay. Your Honor, do we have to, when we go through the findings of fact and law, do we have to start with bullet one and work our way through the whole thing, or do we have to?
You can do it however you would like to. However, the usual practice is, I will have a problem with it if you were to do if you were to adopt, for
Okay.
example, an entire proposed order at once. I'd tell you to slow it down.
Okay,
You can go paragraph by paragraph if you'd like. You can go section by section if you would like. I will note, since you did call me in, that there are parts of the order that give alternatives and probably should not be adopted together if that's how ultimately you decide in this case.
okay. So just for example, if, Your Honor, if we wanted to do, say, parts 1 and 2 that discuss the authority of the commission, if we wanted to adopt those en bloc without any further debate, we could do that?
By vote, you could, yes.
By vote, we could do that? And then we could also read into the record certain findings of fact, and then deliberate and vote on
Yeah,
a chunk of them at a time if we wanted
yes,
to?
typically what happens in these, or these I think is most efficient, is if you think that the proposed findings of fact are close enough to a final form, then you go through and you talk about edits, and then you make edits, and then you vote on them as one big proposed findings of fact, say paragraphs 5 through 15 as amended.
Okay.
And that way you're not.
As amended,
That way
I
you're
see.
not voting on every single individual amendment.
So,
because that
so
would
no
take a while.
votes on commas versus periods?
If you want to amend it, if you want to amend it, it's fine. If someone doesn't like Oxford commas, I'll be happy to tell you that you're wrong. Of course, y'all are the ultimate fact finders, so
Right.
I carry no weight in that, despite knowing that I'm right. But it's a lot easier if you make all the edits, including the Scrivener's typographical type of thing, and then just vote en banc, but you can't go more than a section at a time.
I
And
see.
realistically, if you were to ask me, I would say pump the brakes and do each proposed findings of fact in each lowercase bolded section separately.
I see, okay.
So can we approve the authority and parties all in one together?
Yes,
Yes.
we can do that.
Yeah,
So.
yeah, 1 through 4 you could do in
So-
a singular vote.
So Commissioners, I will bring that to our attention now. If you could look over paragraphs 1 through 4 and see if you disagree with any statements in there or would like to make any amendments. And if there are none, or,
So do we make a motion to approve this?
go ahead, Commissioner Bagley with a question.
So in number 4, it says that you are presently a real estate licensee and a principal broker of Nut Realty. Earlier, it seemed like that had gone away and you were just this A-plus or A-plus Enterprises. Are you doing both still?
So you can't ask him that question. You would have to move to reopen the proof to ask that question. We're in deliberations now, so he can't answer you. But by majority vote, you can reopen the proof to ask that one question, and I can put you back in deliberations.
Do you want to know
Does
that?
anybody else remember something
Well,
about that?
I remember the mentioning of the 2 brokerages, yes. And I thought his license was issued under A-plus Enterprises, and that Nut Realty, that license expired.
That's what I thought.
Right.
So
So,
could we just change that, or do we have to ask?
well, we can amend number 4 to say that he is presently a real estate licensee and principal broker just for A-plus Enterprises, and delete the notation of Nut Realty Company, since that firm's license is expired.
I mean, I'd like to verify that somehow, but that's what I remember.
Well, the record shows that his license is issued to A-plus Realty.
Yeah, so we'll amend number 4 under authority. That he is the principal broker of A-plus Enterprises, and that the license of Nut Realty Company has expired.
So just mark out and the principal broker of Net Realty Company and the location and just get rid of that? Or do we need to say it's?
So the amendment, let me just restate the amendment. We're going to strike the portion that says that Mr. Nutt is principal broker of Nutt Realty and the location of the address given as 375 Main Street, Middleton, Tennessee, period. We're going to strike that sentence and then just continue on where it states respondent and the balance of the paragraph. Does that sound right, Joe?
Yes.
Is there any objection to that amendment? Very good. So I will entertain a motion to adopt paragraphs 1 through 4 as amended.
I make a motion to adopt paragraphs 1 through 4 as amended.
Second.
I have a motion by Commissioner Torbett to accept paragraphs 1 through 4 as amended, seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion, I'm sorry, do we need to do a roll call vote, Your Honor?
You do not.
Very good. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Okay, moving on to proposed finding of facts in relation to the failing to file with the commission an answer within 10 days. This is the point that Mr. Nutt has conceded to during the course of testimony and evidence today. If you would read paragraphs 5 through 15 and see if there's any that we want to pull out, amend, or otherwise dispense with.
I make a motion to approve.
A second.
5 through 15.
Yes.
So we have a motion that's been made by Commissioner Smith to adopt paragraphs 5 through 15 on the proposed finding of fact for failure to file with the commission an answer within 10 days, was seconded by Commissioner Tucker. Does any commissioner wish to make an amendment to any? Very well. All those in favor, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. If you take a moment to read paragraphs 16 through 28 that compose the proposed finding of facts for honesty and good faith under 6213-4034. And then the chair will entertain a motion.
I make a motion to accept 16 through 20.
Very good. I have a motion by Commissioner Gwynn to accept paragraphs 16 through 20, seconded by Commissioner Torbett. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. As remaining is paragraph 21 through 28. Does any commissioner wish to make a motion in regards to those paragraphs?
I'd like to amend 21.
What is your amendment, sir?
After viewing the subject property with the respondent, complainant submitted an offer in the amount of $150,000 with a $2,000 survey, up to $2,000 survey expense to be paid for by the purchaser.
And in this context, the complainant would be the Mosses?
Correct.
Okay. So Commissioner Gwynn makes the motion that paragraph 21 be amended to say, after viewing the subject property with respondent, complainant submitted a full price offer of
No full price, the number.
Complainant submitted an offer of $150,000 with a $2,000 contingency for, up to $2,000 contingency for a survey.
Correct. I would say in the amount of $150,000.
In the amount of $150,000. Was there a second? Second by Commissioner Bagley. Any discussion on that amendment? Hearing none, let's vote. All those in favor of the motion for paragraph 21 as amended, all those in favor, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Does any commissioner want to make an amendment regarding 22 through 28?
Before we move on, if I may ask for a clarification.
Certainly, you can ask me, and I can address them.
Yes, sir. I just want to be clear, is the rest of that sentence going to be deleted?
I don't think that was part of Commissioner Gwyn's amendment, but Commissioner Gwyn, what do you think?
Yes, delete.
Don't leave in and waited to receive a response.
So, as amended, well, I mean, this is a record of hearing, so we want it to say what it says. We want it to be complete. We don't want to assume things.
I left it on my section.
Yeah, and you didn't, in your initial motion, you didn't.
That's fine, leave it in.
So the rest of the sentence remains?
Yeah.
Thank you. Is that good, Ms. Cooper? Okay. Does any commissioner want to address paragraphs 22 to 28?
Make a motion. To accept 22 as is.
Okay, I have a motion to accept paragraph 22 as it is. Is there a second? Seconded by Commissioner Smith. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. 23 to 28, picking them off one by one. Here we go. I think 23 is fine.
I have a question about 24.
Let's talk
Okay.
about 23 first.
Okay. Respondent failed to timely respond to the agent. Commissioner Gwynn, what do you got?
We talked about that. There was a response. The question is, was it timely? And I guess we can debate it or not.
Well, we gave our impressions of what timeliness is. I think the general consensus was immediate. And then if there's any delay in being able to respond immediately, there's a communication saying, I'll get back to you in the morning, or things like that, so that everybody understands what the exact timing is going
Well,
to be going forward.
Do we know when the response was?
Well, we only have what the record shows and the email, which seems to be on or about the time between the 22nd and into the 23rd, but we don't have precise times of day, except when it comes to the email responses, because those are time-stamped. That tells us that those responses were in the evening of the 23rd and several hours after the Moss's offer was set to expire at 2 p.m. earlier that day.
So we don't know when the response happened, but
We
we're
don't- we don't
saying
know the
it wasn't
precise-
timely.
We don't know the precise time that the offer was presented and rejected. We have dates, but we don't have the time of day.
I would rather it say when the response happened. Respondent responded blank, whenever it was.
Well, we can't.
I mean, how else can we make a determination if it was timely if we don't know when the response was? Or do we?
I think it was after
Where is it?
I think it was, according to those emails, they were late in the evening, like between the girl, Miss Braga, and it was after I mean, I'm just going on recollection, but I think that they had asked for a response by like 2 p.m. or something like that, and there was no communication on that day, like before 2. if that means timely. I don't know.
Offer terminates at 2, and it was rejected 2 on the 23rd, and it was rejected on the 23rd, but we don't know the time.
We can maybe piece it together, Steve. If you look at number 8, the back of number 8, the first real email that says, "The Tysons appreciate the offer from the Moss family. However, they accepted a higher than asking price cash offer from another buyer. Thank you so much to your clients." And that was at 9:37 PM on the 23rd. So there's nothing that shows there was any kind of communication before that about the offer.
Okay. So, we know that the response was after the expiration of the offer. Is that correct?
Yes.
All right. So why don't we state that in here?
We can. You want to amend the language?
Do you feel like that's timely?
Well, I mean,
Timely is
Well,
subjective, that's why I asked.
I
but-
know it.
well, I think,
It's
I mean,
not,
stating, I'm sorry, I interrupt, but stating the fact that it happened at a certain time doesn't answer the question about timeliness. So I think we have to make some kind of finding as to whether we view the interchange of updates between the agents to be in a manner that we would consider timely based on our own experience. So I don't think not commenting about timeliness is really.
so then the timeliness, is that going to be a factor in determining honesty and good faith? One of the factors,
I think timely would fall under good faith,
timely?
possibly.
Okay, so then that's a key thing then to
Yeah.
determine the timeliness of it.
Yeah, I mean, I think this whole case is here because the question of timeliness is unknown. I think that's why we're here. Because again, I mean, you got the dates. I mean, the typed date was 3/22, but the written date was 3/23, and it's just.
But okay, so I have a contract that expires at 2 o'clock on the 23rd. If I don't hear anything back, okay, I'm not saying you have to respond before that. All I'm saying is the offer is open to that time on that day. So therefore, if I don't have a response by then it's over, correct? So.
Typically the offer would go
All right,
away.
so if you don't get a response by the time you've asked for it, how can you say that's not timely? It's not the answer you want, but if you should have written the contract differently. I mean.
Yeah, fair point.
Right? So they responded, they rejected it after the date. It was already expired anyway because they didn't hear back by the 2 o'clock. Correct?
Right.
I mean, you
So-
couldn't go and take that contract and say, oh, I'm holding you to that if you don't respond by that time.
Right. Well,
you'd
I mean,
lose every.
without a fully executed contract, it's not a contract.
Correct.
Yeah.
You didn't meet the terms, so it's over. So.
Okay, so the more important question then is rather than the expiration date of the offer is more or less the timing between the expiration of the offer and when Mr. Nutt showed up with his offer. And according to that, the dates that we have, there's 2 dates in the signature block area. There's the dates 3/22 that's signed by the sellers,
Correct.
And then there's the acknowledgement of receipt that's handwritten, that's signed by Mr. Nutt for 323. So that's, but the vision that I'm painting in my mind and based on the testimony that's been given is that there's counteroffers that have been considered. Those are rejected on 323, both
Right.
the timber guys and the Mosses. And then his offer is that was,
The timber guys are irrelevant
well, they are.
to a degree.
To a degree, yeah. The fate of their deal is
Yes.
not the point. The point is Mr. Nutt's actions at the kitchen table with his clients and presenting these offers, and his offer coming in, kind of like the superhero, the hero offer coming in and say, I'm going to give you $5K above and clean and solve your problems for you. Not like these two other offers where they came in 150 with stipulations.
Well, a response not being timely, I don't know what we're talking about.
Well, and here's the thing. I mean, I guess we don't have to adopt that paragraph at all if we don't want to. We
All right.
can, we can just skip it and see if the state still has enough to meet their burden.
Fair enough.
Okay,
So I'll make a motion.
so I mean, we don't need a motion not to adopt. We need motions to adopt. So if you don't want to adopt 23, we could just quit talking about it.
All right.
Good? Thank you.
Would it be clearer if we strike it?
Your Honor, the paragraphs that are not adopted, they don't make it into the record of findings of fact, correct? If we don't adopt a finding of fact, it doesn't go into the final record?
That's correct. If you decide, given that you're going paragraph by paragraph here, you probably, I would probably counsel in favor of going ahead and having a vote on it.
Okay.
If you want to elide it from from what you're
Okay.
working with
So,
currently.
a motion to strike paragraph 23 would be in order?
If that is what you would like to vote on, then
Okay.
that is probably a better way than just ignoring it, moving on, than, having to do a very complicated motion about renumbering paragraphs, although we're gonna have to do that in a second anyway, when we hit paragraph
Okay.
31.
So the floor is open for a motion then.
I make a motion to strike 23.
Commissioner Gwynn makes a motion to strike paragraph 23. Is there a second? Last chance. Anybody? Hearing none, that motion fails for failure to earn a second. Any other motions?
I make a motion to accept paragraph 23
Motion to accept 23 as written?
as written.
Commissioner Torpet makes a motion to accept paragraph 23 as written, seconded by Commissioner Tucker. Any further discussion? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed?
No.
Opinion of the chair, the ayes have it on a 6 aye, 1 no vote. That motion carries. Floor is open for motions on paragraph 24 through 28.
'24, I have a little bit of an issue with the wording because we can't determine why he did this. This says because respondent decided to personally purchase the property, which we all know that he did, but I don't know that that's why he didn't respond. Does that make sense? So respondent confirmed that respondent presented both complainant's offer to seller as well as a second offer. I don't think that he said in these emails that we have that it was his offer.
Okay. So do you think there's an amendment or a word change that can cure that, or do you want to strike 24 altogether?
I think I want to strike that altogether or possibly rephrase it.
Oh, yeah. Well, pick one.
Respondent confirmed, respondent presented complainant's offer to seller. Strike out both. Strike out as well, leave as well as a second offer. And then strike out personally submitted by respondent. Because correct me if I'm wrong, but in the email correspondence that we have, I don't see where he says he made the offer. He says, and this also concerns me a little bit, and I don't know if it's something we can talk about or not, Judge, you can tell me, but he says in this original email, they accepted a higher than asking price cash offer from another buyer. He doesn't say he was the buyer, and I feel like he's also told us he's paying interest on this property. So the cash offer gives me a little bit of a concern, but I guess that's neither here nor there.
I was going to ask, is there, into the remaining statement of 24, is there
That's
any?
what I'm looking at. Complainant alleges respondent did not timely convey offer to seller in violation of Tennessee Rules and Regs 12600208. And then I would strike because respondent decided to personally purchase the subject property.
So if
Because
I
he
may.
may not have responded regardless of if he purchased it.
So if I can, I'm going to read paragraph 24 as amended. It says, you want to amend it to say, or your motion is to amend paragraph 24 to say, respondent confirmed, respondent presented complainant's offer to seller, as well as a second offer, period. I'm thinking.
Yep.
Complainant alleges respondent did not timely convey offer to seller in violation of Tennessee Regs 1260-02-.08, period.
Yes.
So do all commissioners understand? Is there a second?
That's my motion.
We've already got the timely in 23. What are we adding to it? If we take out the phrase because of respondent decided to personally purchase the subject property, then all you're left with is did not timely convey.
Excuse me, everyone. We're going to take a recess for deliberations for a quick restroom break.
Okay.
So deliberations are paused. We're going to take a 5-minute recess, meet back up at 3:47.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor. Before we recessed, Commissioner Gwynn was talking about the composition of paragraph 24 and the finding of fact. Go ahead, Commissioner Gwynn, resume your point.
After the semicolon, it says complainant alleges respondent did not timely convey offer to seller.
So would
Offer to seller.
removing timely remedy
Well-
that for you?
Can I say something real quick?
Go ahead, Commissioner Bagley.
So this says that he did not timely make the offer to the seller. The first 23 says he did not timely respond to the agent. So they're
right.
two different sentences.
So I don't know what that's talking about then. Complainant alleges respondent did not timely convey his offer?
Right, complainant being the Mosses. Alleging that respondent, Mr. Nutt, did not timely convey their offer to the seller.
The only one he made.
The only one he had an opportunity to make.
Right.
Is what.
My question on it is, are we just verifying that he alleges that? Because before it's saying that, you know, you're saying that he failed to timely respond to the agent, but this is just an alleged thing. So should we even be?
Well, I think that's what we're deciding. Did the state meet its burden to prove that he did not timely convey it to the seller?
But this one just says that's what the complainant alleges, and I think that is true. That is a fact. The complainant alleges that the respondent did not timely convey the offer to the seller. You know what? I'm going to change my amendment.
Okay,
Can I make a,
so you withdraw your First Amendment?
I withdraw my first amendment.
Okay, so now their floor is clear for a second, for an
So
additional
my-
amendment?
My amendment is to leave that last part in because respondent decided to personally purchase the subject property. So it would state, respondent confirmed, respondent presented complainant's offer to seller as well as a second offer. The complainant alleges, and the complainant did allege this, so I don't have a problem with it, that the respondent did not timely convey offer to seller in violation of 1260-0208 because respondent decided to personally purchase the subject property. That is what Mr. Moss alleged.
Do we want it? Do you want to remove the word alleges? So we get some more of a statement of fact rather than a question?
No, because I think that's the fact. That's what we've got before us here, is that's what he alleged.
Okay. So there is a motion now. If I will reread paragraph 24. Ms. Torben makes the motion for paragraph 24 to be amended to read as follows. Respondent confirmed, respondent presented complainant's offer to the seller, as well as a second offer, period. Complainant alleges respondent did not timely convey offer to seller in violation of Tennessee Code Rules and Regs 1260-02-.08 because respondent decided to personally purchase the subject property.
Yes.
Is there a second? That motion has been seconded by Commissioner Moffett. Any further discussion on the amended? Commissioner Gwynn?
Yes, can we discuss it? So I think it should be clarified that essentially the complainant is saying that he submitted an offer in writing, which we have a copy of, right? This right here, which was rejected after the date, after the time that elapsed in the contract. So what he's saying is that the respondent held this contract until after he could get another, he, meaning the seller, could get another offer from the respondent, after which he rejected this offer. Is that what we're saying? Because I missed that. Huh? I know it. I mean, but that, is that what he is saying? Because
He's saying that Mr. Nutt did not timely convey the offer to the seller because Mr. Nutt decided to personally purchase the subject property. That's what Mr. Moss is saying, which is why Mr. Moss is here with us today. I think alleges is different than stating he impacted this. So Mr. Moss alleges it.
Okay. Any other discussion about the amended paragraph 24? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Anything on paragraphs 25 through 28? Commissioners?
I make a motion to accept 25 through 28 as written.
Commissioner Torben makes the motion to accept paragraphs 25 through 28 as written, seconded by Commissioner Tucker. Any discussion on those paragraphs? Hearing none, let's vote. All those in favor of the motion, please say aye.
Aye.
Any opposed? Hearing none, that motion carries unanimously. Your Honor, do we need to do the applicable law?
Yes, you do.
Okay, very good. We will proceed through that. Okay, paragraphs 29 and 30.
I will note for the board chair that it may be helpful for the applicable law section to vote on them at once, since they are all just restatements of rules and regulations with an amendment for paragraph numbering.
Okay. So the chair will entertain a motion to accept the section on applicable law as written with an amendment to be done by the court reporter, I'm guessing, or to amend the record, or by the state?
Ms. Cooper, if I could prevail upon you to go ahead and make these changes and submit at the conclusion of this hearing to the chair for signature.
I'm doing that as we go along. Yes, sir.
Excellent, thank you.
And I apologize for the typos.
So the motion is to accept the applicable law section with an amendment for council to amend paragraph numbers and to make other technical corrections as needed. Is there a motion? I have a motion by Commissioner Smith, seconded by Commissioner Torbett. Any discussion on this motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. All opposed? Hearing none, that motion carries unanimously. Paragraph 26 is proposed conclusions of law. I don't see any reason to make amendments to that. Is there a motion to accept as written?
So moved.
A motion by Commissioner Smith to accept the proposed conclusions of law as written, seconded by Commissioner Moffett. Any discussion on paragraph 26? Hearing none, let's vote. All those in favor, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Proposed judgment. Let's take a little bit of time with this one. Paragraphs 27 through 31. All right, so 27 through 30 seem to be an offer of a range of sanctions.
Do we need to separate the offenses?
Well, I mean, I think the two allegations in the pleadings are for failure to respond and failure to exercise, to deal honestly and in good faith. So I think
So-
we would need to vote on both of those separately.
Okay, that was what I was asking. So respondent be assessed a civil penalty in an amount not to exceed $1,000 per violation. Do we need to phrase that as
I think
$1,000 for failure to respond?
we can amend paragraph 27 to say $1,000 for one violation and $1,000 for another violation, or some other dollar
Okay.
amount, however, at our discretion. I don't have any appetite for paragraphs 28, 29, or 30. That seems heavy-handed to me, but commissioners may disagree.
So we also have 31 that's
Right, right.
going to be some money.
That'll be some money. But let's focus on 27 for a minute. Is there a motion? Anybody?
I'll make a motion.
Commissioner Gwynn.
Respondent should be assessed a civil penalty of $1,000 for each violation.
Okay, so Commissioner Gwynn makes the motion to assess a civil penalty of $1,000 per violation, violation being 6213, which is the obligation to respond to the commission within 10 days, and 6213-403-1 or 4? 4034 is honesty and good faith.
Correct.
For a total of a $2,000 civil penalty.
Correct.
Is there a second? Did I hear a second?
Second.
Seconded by Commissioner Moffett. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Chair will entertain a motion to reject paragraphs 28 through 30.
Did you make that motion, Jeff, or do you want me to
No,
make it?
I would like you to make it.
I'll make a motion to reject paragraphs 28, 29, and 30 under proposed judgment.
Commissioner Bagley makes a motion to reject paragraphs 28, 29, and 30 under proposed judgment. Commissioner Gwynn seconded that motion. Is there any discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Paragraph 31 is assessed all costs associated with bringing this action. Just pay, I guess it's just court fees and such. Is there a motion?
So moved.
I'm going to assume Commissioner Smith is making a motion to accept paragraph 31 as written.
That is correct.
And Commissioner Moffett has seconded that motion. Is there any further discussion on paragraph 31?
Yeah, does anybody have any idea what that looks like, that number?
I do not. Your Honor?
You would have to reopen proof to find out.
Commissioner Bagley, do you want to reopen proof to find out?
And I
Doesn't
wi-
sound like it.
And I will note that the number would also not be certain because that will also depend on how much time is billed in this case today and how much has been billed by the Administrative Procedures Division as well. So there may be an estimate that can be given or a range, but in terms of anything exact,
Yeah.
I doubt it.
And I was not looking for exact. I was just.
Do you need to know that badly, Commissioner Bagley?
Do you want to put a ceiling on it? Would that make you feel better?
I don't think we can do that. I think their preference would be for us to not do that.
That is a question that I cannot answer. It is more complicated than you would think.
Okay.
Should we put a cap on it?
No,
That's what I just said. He said that.
this is not a real estate deal.
Can we add anything?
So that's going to involve interplay between the rules and regulations as well as the uniform rules of administrative procedure for hearing contested cases as well as the Statute Administrative Procedures Act. And I'd be happy to allow the parties to present argument on that, but you would have to do some fairly specific things that I could not do for you and that you would have to figure out how to do yourselves.
That's all I needed to know about that. Never mind.
No, do we want to see here for another day?
No.
Okay.
No.
Okay. So the motion,
Have a second.
it did have a second. It had so the motion stands on paragraph 31. Everybody ready to vote? Let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Commissioner Torbett. We sure can.
Yes, I got
I
his
would like-
letters.
I would, well, Commissioner Smith, what did you have in mind?
Lots.
I was going to propose a contracts class.
Well, I mean, yesterday we did adopt a new
Yes.
new
yes,
packet of CAS trace
Trace,
coursework. We could do that. That covers
yeah,
Does that cover everything?
a lot,
yes.
including contracts.
So my
Okay.
motion would be that the respondent, and that course is available now, correct? No. When will it be available? Trace.
May I answer?
Yes, you may. It doesn't have any bearing on the allegations or charges, so yes.
It clarifies for me a timeline.
The answer was yes. She
Okay.
may answer.
Oh, here.
Thank you. Trace will be in our system on July 1. That's the soonest it can be offered.
Okay.
We are giving a webinar to providers in reference to this new course at the end of July. So
And it's a how many hour?
it's 35
30-hour course, okay. Thank you. So,
Right now, it's not being provided by any provider.
so my question is, if my motion says for the respondent to take and pass the TRACE course by the end of this year with no additional credit, would I be safe in that timeline? Can she answer that, Judge?
Sure.
Yes, ma'am, I would think so. I think we'll have several providers offering the course sometime this summer, and hopefully you can take it by the end of this year.
Okay, then that's my motion.
So, if I may
Go ahead.
state the motion. Commissioner Smith makes the motion that the respondent be required to take the TRACE course, which is 30 hours of education covering a broad number of subjects, and to have until the end of the calendar year 2025 to complete that course, and for that course not to count towards his continuing education.
Second.
I'd like to make an amendment.
Commissioner Bagley.
I'd like.
Hold
for-
on, Commissioner Torbett seconds. Commissioner Bagley.
I would like for him to get credit for the course.
Commissioner Smith, do you accept the amendment?
Do we need a second for the amendment?
You might, we'll see if she accepts it. And then,
Do we vote on it before I accept it?
no, you can decide if you want to accept it or not. Then we'll vote, and then people
Okay.
can vote the way they want to.
I don't want to accept that amendment.
Okay? So the motion proceeds as it was submitted with no credit towards continuing education. Any further discussion on the motion? Hearing none, let's vote. All those in favor of the motion, please say aye. Aye. Any opposed? Opinion of chair. Opinion of chair, the ayes have it on a 6 aye, 1 no vote. Commissioner Bagley voting no. Any further judgments or civil penalties that we would like to include? Hearing none, I'm going to close the proposed judgments then, and we will proceed to the policy statement, and I will just read that into the record. The mission of the Tennessee Real Estate Commission is to protect the public through establishment and administration of minimum requirements for candidates and licensees, effective professional education of licensees, and enforcement of professional conduct. The actions taken by the Commission today were to protect the public, but also to protect the integrity of the licenses held by close to 50,000 other practitioners in the state of Tennessee. Do any commissioners wish to make amendments to that statement? Is there a motion to accept?
Motion to accept as written.
I have a motion to accept the policy statement as written by Commissioner Torbett, seconded by Commissioner Smith. All those in favor of the motion, please say aye. Aye. Any opposed? Hearing none, that motion carries unanimously. Your Honor, unless there's any other business for us, I will turn the hearing back to you, sir.
All right, thank you, Mr. Chair and commission members. I will ask Ms. Cooper to provide the chair with a copy of the order that reflects all of the commission's changes for the chair's signature. Thank you, commission members, for your time and your thoughtful deliberation and questioning in this matter. I thank you to the parties for your time and your participation in this case, as well as to the witnesses. With that, unless there's anything further, excuse me, unless there's anything further, this matter is adjourned. Thank you all.